Eviction is that.
Please give.
Tomorrow, there is a
Actually,
trying to cut and remove the trees tomorrow.
Which matter?
Yes.
Huh?
Tomorrow.
Aye.
Has been filed not to cut and remove the trees.
Your Lordship, I'm mentioning your
Yes.
Lordship. Fresh matter, I've already moved a memo, your Lordship. And tentative date was given for yesterday.
Please give it,
Has
please
been
give it.
listed. The urgency is that
Tomorrow is the last day, sir. Give it. It will come.
Please.
Give it.
Supposed to be listed today by.
Put it. Please give.
only thing is that there is some urgency. If it's possible to at all take it up at 2:32.
Put it. Please give.
Tomorrow. Tomorrow.
Yes.
Move two memos not got listed. That's what.
Yes.
To appear for the petitioner. My lord, the land, my lord, is 7 acres, my lord, in Sadhali village.
Hmm.
Sadhali village originally a Jodi village. My lord, that is acquired by the government, my lord, by a notification under the Mysore Personal and Miscellaneous Inam Abolition Act. My lord, I am the, my lord, grantee of the land. Till 2002, my name is in the RTC. Thereafter, my lord, by way of an order of which I am not even given notice of, my name is removed and the respondent 6 name is added. The AC, my lord, considers that there are enough records to show that the grant is in my favor, including, my lord, the grant order, my application, my lord, registers, my lord, statutory registers. The DC, my lord, relies upon an order of a report of the Tehsildar and says there are no records whatsoever. That is contrary, my lord, to an endorsement given by the Tehsildar himself. Kindly see the endorsement of the Tehsildar.
Your name was continued till 2019.
2002.
Ah.
From 2002, when the records were digitized, my name is removed surreptitiously. Thereafter, in 2019, when I realized that my name is not there, I moved the AC. AC, my lord, records a finding that there are records in my name.
You have done nothing on the land.
Nobody.
Till 1962.
Vacant. Today also vacant, my lord. From 1962 to
Then
2000.
for what purpose did you get it granted?
My lord, as my lord, yes.
For what purpose did you get it granted?
Well, there was other
For
than
not doing agriculture?
agriculture was doing.
Then you are not paying taxes
Not
every year.
paying. Kindly see the
How could you pay it after 2002 when your name is not removed?
I continue to pay because the register under the act.
How will they accept it if your name is not there?
Kindly see the register under the act. The register under the act, my lord.
Means you are not aware. Though it was removed in the year 2002.
Please.
You are not aware of the removal of your name.
Please.
From the RTC.
Please.
Which means you have not gone to the Tahsildar's office. You have not paid the taxes.
I have paid, please see 64, the register continues to be in my name regarding crops and
How can it
boundaries.
continue, sir?
Regarding crops and boundaries continues to be in my name, but AC, my lord, records a categorical finding that records exist from 1962 that my name is there and therefore, my lord, restores my name in the revenue records. Kindly see the AC's order for a minute. I will only trouble your lordships. Kindly see 97.
What happened in 2020? Tahsildar confirmed that no land has been granted in favor of Sri Appajaya.
Appa Jaya was the original Jodidar.
Huh?
Original Jodidar of the village.
Ah,
Avuru, he lost all rights. Respondent 5 and 6 claim their rights from Appajappa. I am a section 9 grantee. I am not even claiming my rights and from Appajappa. Appajappa and the respondent 5 and 6 have purchased the property
purchased from him.
from him. That is what the AC says. There was no right with Appajappa. How could respondent 5 and 6 purchase from
How
Appajappa?
can the revenue authority decide all this?
Not only regarding my entry, because my lord, entry,
Entry has taken place
Please.
consequent to a registered document.
please.
Then what to do?
My lord, registered, there could not have been any
The
registered.
revenue authorities cannot go into all these
My
questions.
lord, because 2002
They have to
tanka.
go before the civil court.
My lord, only because 2002
You are
tanka.
saying that there is a registered document.
No, registered document, my lord, I am not aware of. Till 2002, my name is there.
You can't go on selling that I'm not aware of, I'm not aware of. Now you have come to know that there is a registered document.
But from Appajappa, who's not even,
Therefore, can the revenue authority decide that one?
well, kindly see what the AC says, that there is no.
Can the revenue authorities decide? Have you seen the judgment in Jayama's case?
Please, my lord,
What does it say?
my lord, I'm aware that my lord can't decide rights, my lord.
Cannot, decide.
My lord, but my lord, AC, my lord, what the DC does, my lord.
Cannot do it, sir.
My lord, kindly see what the DC does.
Yes.
My lord, DC, my lord, says that there are no records in my favor at all. The Tehsildar has given endorsement.
That is the other matter.
Please,
The matter is that they have acquired title under a registered document
please,
of which year?
of 2002, my lord.
Then, from then on, their name is there.
Please,
Then,
my lord, without giving me notice,
therefore,
without giving me notice,
now that you are aware
Yes.
that their name has been entered consequent to a registered document,
please.
what you should do?
My lord, I therefore, my lord, please also see respondent, my lord, 6 files a suit
Or-
against me. Well, kindly see the suit order, kindly see the suit order. They file an injunction suit against me.
Ah,
They, my lord, section order 39 rule 1 and 2 application is dismissed. Kindly see that order.
what is this? That is not enough, sir. Now you have to get a declaration in your favor. Otherwise, it is not possible. The revenue authorities cannot go into all these questions.
My lord, regarding, my lord, the
In terms of section 128,
please.
if a registered document is there, it is presented before the Tahsildar, he is bound to enter the name. There cannot be anything else. Learned AGA,
Well, kindly-
HCGP, takes notice for response number 1 to 4. Issue notice to response number 5 and 6. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Let them come.
My lord, let status quo be ordered, my lord. Only, my lord, property, my lord, construction is going on
The
the property.
mutation entry that was made in the year 2002
Please.
cannot be set aside in the year 2020-21. Not possible, sir.
My lord,
Yes.
we'll maintain status quo, my lord. Let there be no construction.
We are only concerned with the revenue entry.
Please.
We are not saying anything regarding the possession. It is up to you. Yes.
Lordships may kindly say the status quo be maintained, my lord. That is my only humble.
No,
request.
no, which means it should be in your name.
My lord, the name is already, my lord, mutated after the DC's order in the name of,
Deputy Commissioner has set it aside.
has set it aside.
Rightly
My lord,
said.
no construction
No,
be
not
carried
at
out, my lord.
this- not at
Nature of
this
the
stage.
property will change.
Not at this stage, yes.
My lord, third party rights may be created. Lordships may only say status quo then, my
It's
lord.
all the more reason that you immediately file a suit for declaration.
My lord, status quo.
Get an order, not to alienate. Yes,
Status quo may be ordered, my lord, only require, otherwise third party rights if they create, my lord,
No,
be
no.
difficult, my lord.
yes, next matter, please.
Number 2, D. Ramesh.
For the petition. That's order passed by the Assistant Commissioner and Deputy Commissioner is in question here, madam. Whereas the petitioner is the absolute father and the petitioner are the absolute owners of survey number 15. Bar 1, my lord, measuring to an extent of 39 guntas, my lord. My lord, this property was subject matter of the tribunal proceedings, my lord. My lords, this property was granted in favor of Muniappa. And some portion was allotted granted in favor of Tippana. Lord, this order of grant passed by the land tribunal was questioned before this honorable court as per annexure B, page 55. Lord, this honorable court has set aside the order passed granting occupancy rights in 55. Yes, my lords. Annexure B, my lords. My lords, grant made in favor of Tippana and Vaidik Muniappa was questioned before this honorable court by Muniappa, who is also a rival claimant. Because this honorable court had remanded the matter, said the order passed by the tribunal, Mallards on 17/1/2005, and remanded the matter back to the tribunal. During pendency of these proceedings, Mallards, till today, Mallards land tribunal has not taken up the application. It is pending consideration. Mallards, that order remains as it is. Now, Mallards, the rival claimants makes an application challenging the revenue entries mutated in the name of Muniappa, Mallards. That is the petitioner who has approached this honorable court challenging the regrant order made in favor, the occupancy granted in favor of Tippanamal.
Muniappa is the,
He is a rival claimant, Mallards. I am the
rival claimant.
Yes, Mallards, I am the owner of this property.
Who is the other person who is claiming?
Mallards, Timmarayappa and Vaidik Muniappa, Mallards. Mallards, it can be, we can see, it can be seen at Annex D, page 64, Mallards.
Also 6A.
Yes,
6A.
Yes, Mallards.
Vaidika Muniappa is no more.
Yes, Mallards.
Timmarayappa, Muniappa, Muniraja.
Munraju.
Ah,
Mallards, now the Muniappa, son of Munimallappa, Mallards, is the person who has challenged the occupancy rights granted in favor of these two persons.
yes.
Mallards, these two persons, son Muniappa was not at all in possession. Mallards, this revenue entries was questioned before the Assistant Commissioner, Mallards, in the earlier round of litigation. As per Annex D, Mallards, the order, the mutation, the entries made in the name of Muniappa Munimallappa was set aside, Mallards, on 22/12/2003. Mallards, even after the order passed by the Assistant Commissioner, the name of Muniappa alias Munimallappa continued, Mallards. Mallards, hence I filed an appeal, being a landowner, before the Assistant Commissioner, Mallards, page 71, Annex E. Mallards, I am the owner of this property. Mallards, these are the.
You are a rival claimant.
Mallards, those are rival claimants.
Rival claimants ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
Mallards, they are claiming occupancy rights inter se. In Mallards, I am the owner of this property. Under me, Mallards, Form 7 has been filed.
Who are the Muniappa and
Vaidik Muniappa
and Timmarayappa?
Timmarayappa, all are three claimants.
They are rival claimants.
Yes, Mallards. Mallards, now that order passed in the Mallards granting.
Timmarayappa filed an appeal before the Assistant Commissioner.
Yes, Mallards, that has been set aside. The revenue entries were set aside, Mallards. Mallards, even then, Mallards, the revenue authorities had not removed the name of Muniappa Munimallappa. Mallards, hence I filed my.
You are not a party to the proceeding.
Mallards, I am not a party to the proceedings. But however, I am in possession of this property. I am the owner of this
What
property.
is the order passed by the Assistant Commissioner?
Mallards, they dismisses my appeal on the ground that.
Not your appeal, sir.
Mallards, the.
Appeal filed by Timmarayappa.
Yes, Mallards, impugned observation is page 69. That is Annex D, page 69, paragraph 8, Mallards. ಒಂದನೇ ಪ್ರತಿವಾದಿಯು ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿರುವ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ವಿವಾದಿತ ಜಮೀನು ಭೂ ಕಂದಾಲಯಗಳಲ್ಲಿ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಇರುವ ಕಾರಣ ಭೂ ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ವಿವಾದಿತ ಜಮೀನುಗಳಲ್ಲೂ ಇವರ ಹೆಸರಿಗೆ ದಾಖಲೆ ಮಾಡಲು ಯಾವ ಆದೇಶವೂ ಹೊರಡಿಸಿರುವುದಿಲ್ಲ. ಕಾರಣ ಯಾವ ಆಧಾರದ ಮೇಲೆ ವಿವಾದಿತ ಜಮೀನು RTC ಯಲ್ಲಿ ಸೋನ್ಸೋ
ಡಿಸ್ಪ್ಯೂಟ್ ಇಂಟರ್ ಸೆ ಕ್ಲೈಮೆಂಟ್ಸ್.
Yes, Mallards.
ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ.
Yes, Mallards, there is an order to remove the.
ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮುನಿಯಪ್ಪ ಬಿನ್ ಲೇಟ್ ಮುನಿಮಲ್ಲಪ್ಪ ಅವರ ಹೆಸರು ದಾಖಲಿಸುವುದು ವಜಾ
ಮಾಡಲಾಗಿದೆ. ಈ ಜಮೀನಿನ ಪಾಣಿಗಳಲ್ಲಿ ಮೇಲ್ಮನಿದಾರ ತಂದೆಯ ಹೆಸರು ವೈದಿಕ್ ಮುನಿಯಪ್ಪ ಮತ್ತು ಮೂರನೇ ಮೇಲ್ಮನಿದಾರ ಹೆಸರನ್ನು ದಾಖಲೆ ಆದೇಶಿಸಿದೆ. Mallards, now their claim.
What is page number 71?
Mallards, 71 is. Mallards, is the order passed by the Assistant Commissioner in the appeal filed by me. In the appeal filed by me, Mallards, I challenge the order. Mallards, seeking for restoring my name in the revenue records, Mallards.
You have filed one more appeal.
Yes, Mallards. To set aside, Mallards, that appeal is dismissed on the ground that the matter is pending before the tribunal.
Yes.
Mallards, still today that the tribunal, even after lapse of Mallards 12 years, has not taken it. However, Mallards, I continued in possession.
Yes.
Even these two persons are not in possession of this property.
Then you went before the
Deputy Commissioner. Mallards, Deputy Commissioner also dismisses my appeal, Mallards. Mallards, he doesn't consider all these, the documents which are being produced by me and dismiss my appeal, my lords.
Muniappa.
Okay.
You have filed a appeal only against Muniappa.
Yes, my lords, Muniappa, Munimallappa.
But the order passed by the assistant commissioner earlier is in favor of Timrayappa.
Timrayappa.
His name has been entered.
Yes, my lords,
Then-
his name is not also entered, my lords, kindly refer to annexure, page 52 annexure A19, my lords, RTC of the year 2015, 14-15.
ಅವ್ರನ್ನ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ವಲ್ಲ
ಅಲ್ಲ, ನಾನು ಮಾಡಿದ್ದೀನಿ ಇದರಲ್ಲಿ.
ಎಲ್ಲಿ?
Before assistant commissioner.
annexure E ಅಲ್ಲಿ.
Yes, my lord. ಅಲ್ಲ, ಇದೆ, respondent number 3, my lords, he is
ಯಾರು?
Muniappa, Muimallappa.
ಮುನಿಯಪ್ಪ.
ಅಲ್ಲ,
Where is
Muimallappa.
Timrayappa? In whose favor the order is passed by the assistant commissioner.
My lords, he is not in possession of that property. My lords, his name is also not entered in the revenue records.
But you are aware that such an order has been passed by the assistant commissioner.
Yes, my lords, I have
Then-
not challenged that order, my
What
lords.
are you challenging before the assistant commissioner?
My lords, revenue records, my lords, in standing in the name of Lakshman and
Lakshman.
Muniappa. My
That has been set aside already.
lords, it continues, my lords. It continues in their name. My lords, kindly refer to page annexure, A21, page 54.
Learned HCDP takes notice for response number 1 to 4. Issue notice to response number 5 and 6. Learned counsel for petitioner is directed to serve a copy of the petition along with annexure from the learned page.
My lords, at least, my lords, the status quo may be maintained, my lords, regarding possession.
Ella you conceal relevant material, go file a case against some person who against whom order is already passed by the assistant commissioner.
My lords, his name.
Direction is issued to enter the name of some other person.
My
You
lords,
are not challenging that one.
my
What
lords,
is this you are doing? Yes.
much on.
This matter had appearing for the petitioner, and petitioners are challenging the OD and Durustu conducted by the ADLR before the DDLR, and DDLR was dismissed. Against that order, Milord filed appeal before the JDLR. JDLR also dismissed the appeal. But agreed by the order, we are before the court. Milord, my claim, petitioner's claim, Milord, is that based on the register sale deed 1964. Milord, annexure page 51 may kindly look at, Milord. Page 51, a typed copy of the sale deed dated 10/6/1964, Milord. Milord, I may be permitted to read only 2 points, Milord, because I purchased under this sale deed my father Venkatappa. ತನ್ನ 1964ನೇ ಇಸ್ವಿ ಏಪ್ರಿಲ್ ತಾರೀಕು 10ರಲ್ಲಿ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ವಿಜಯಪುರದ ಹೋಬಳಿ ಧರ್ಮಪುರ ಗ್ರಾಮದಲ್ಲಿ ಹಾಲು ಮೊತ್ತದ ಮುನಿರಾಮಯ್ಯನ ಮಗ ವೆಂಕಟಪ್ಪನಿಗೆ, ವೆಂಕಟಪ್ಪ ಇಸ್ ಮೈ ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಸ್ ಫಾದರ್, ಗ್ರಾಮದಲ್ಲಿ ಇರುವ ಗುಡ್ಡಪ್ಪನ ಮಗ ಹನುಮಂತಪ್ಪ ಆದ ನಾನು ಬರೆಸಿಕೊಟ್ಟ ಶುದ್ಧ ಕ್ರಯಪತ್ರದ ಕ್ರಮವೇನೆಂದರೆ ತಾರೀಕು 6/6/2062ರಲ್ಲಿ ಸೋನ್ಸೋ ನಂಬರ್ ನನ್ನ ಸ್ವಾಧೀನ ಅನ್ನುವುದಿಲ್ಲ ದೇವನ
What can you do, sir?
My revenue
After
entry is,
more than 60 years.
my sale deed is 2 acre 20 guntas. Their sale deed also I have produced before the court.
Correct, sir.
Respondent
What
sale
were
deed.
you doing for 60 years?
My father was a
Not find out lesser extent in your possession?
possession is still we are in 2 acre 30. Even now
Why did
conducted
you
we are in
adopt?
possession. Even today conducted Podi Milad. We are in a spot inspection conducted. We are in 2 acre 20. They are in 2 acre 20.
Let us see, let us. see.
Only revenue records transferred 2 acre 33
Let,
guntas reduced my
HCIP
extent.
Takes notice for response number 1
1
to
to
3.
3.
To notice to response number 4 to
4 to
13.
My interim
Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned.
further proceedings, my lord, this order was implemented, my lord,
ಮುಂಚೆಯಿಂದನೂ ಇದೆ ರೀ.
is this why I am not,
Your instance, some changes is thought to be done.
no,
Not
my lord, not
published.
in my instance. This is my registered sale deed, my lord.
Yes.
I am seeking only for stay of the impugned order, my lord.
No.
Otherwise, they will
ಹಂಗಾದ್ರೆ
further.
it will come to you.
No, my lord, nothing, my lord. Parties to maintain status quo with regard to possession, my lord, at least.
We are not concerned with possession.
ಅಲ್ಲ ಸರ್ವೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ again.
You went.
I am not went. They filed application, my lord, now. Again by
You
virtue of,
started it all after 60 years.
my lord, my sale deed is 2 acre 20, rightly, my lord.
Yes, yes.
Before, petition. The case of the petitioner is for regulation of unauthorized cultivation. Lord, this court, at page 24, a writ petition was filed, but this honorable court disposed of with a direction to consider the application on merits and dispose of in accordance with the laws made Annexure C, operative portion. But they have not considered at all. Thereafterwards, but the next document is
One more petition.
one more writ petition. There they have given a direction, my lord, to consider, and my lord, the respondent should not dispossess the petitioner. This is the order. Now, my lord, a petition was filed, LGC next annexure E, my lord, before the, my lord, land grabbing court. My lord, that is page 33. Your lordship, please come to, my lord, the last page of the order, where it says, my lord, page 53. And they have dropped the proceedings, my lord, contents of report read that the scheduled land comprises
Against whom?
against petitioner and others also. My name is, your lordship will find, my lord, in the
Ravi.
Ravi.
Been late, Muni Venkatappa.
Munaktappal Magas.
Ah.
Nandu, there are 6, my lord, the respondents.
Yes.
Sixth respondent is the Ravi. The issue was, my lord, reached finality, is controlled, dropped. Now, my lord, all of a sudden, again, my lord, they proceeded annexure F by issuing, my lord, a complaint by the Tahsildar to take initiate action under, my lord, section 192A of the act.
Where is the final order?
My lord, annexure F, my lord, page 54. Final order of the,
Order illa, that is an internal.
final order is 53, my lord, page 53.
53.
53.
Ah.
And may I read your lordship, my lord.
Hmm.
The third para, contents of report read, the scheduled land comprises of Devanhalli Taluk, Vijayapura, Gollalli village. Sir, he is at the distance of 27 kilometers from BPM, 10 kilometers from Devanhalli, town municipal limit 7 kilometers from Vijayapura town, sir. The distance mentioned in the report is more than notified jurisdiction of the court. In view of the distance report, case is dropped. Disposed of as,
only on technical grounds.
please, my lord.
That
Now,
it
my lord,
will not come within the jurisdiction.
we will not come within.
There is
the-
no decision.
My lord, they have initiated action against me. That has been dropped. My lord, your lordship connection, annexure F. My lord, the Tahsildar lodged a complaint with the police under section 192A. On the last para, my lord, of the complaint. ಆದ್ದರಿಂದ ಸರ್ಕಾರಿ ಜಮೀನಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಚಟುವಟಿಕೆಗಳು ಮಾಡದಂತೆ ಸದರಿ ಅವರು ಸೂಚಿಸಲು ಹಾಗೂ ತಾವು ಸೂಚಿಸಿದ ನಂತರವೂ ಯಾವುದೇ ಚಟುವಟಿಕೆಗಳು ನಡೆಸದಿದ್ದ ಅದರಲ್ಲಿ ಸದರಿ ಒತ್ತುವರಿ ಮಾಡಿದ್ದು ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಸೋನ್ಸೋ 192 ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. For all, my lord, 2 writ petitions have been filed, and the, my lord, action was initiated under, my lord, Land Grabbing Act. That is also, my lord, dropped. Now this notice has issued now.
Learned HCDP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCDP. Full stop. Next para. Learned counsel for the petitioner submits that on 2 occasions, the petitioner's father was before this court in
What?
WP number
8479. Annexure C.
the petitioner's father and the petitioner were before this court in WP number 8479 of 2012 and WP number 2381 of 2017, seeking directions to the respondents, more particularly the Tahsildar, Devanalli Taluk, and the Committee for Regularization of Unauthorized Occupation to consider the application given by the petitioner's father in form number 53, seeking regularization of unauthorized occupation of
The lands, my lord,
4 acres and 20 guntas of land
in survey number
in survey
60
number 60 of Gollahalli village, Vijaypura Hubli, Devanalli Taluk. Full stop. This court by order dated 19th of April 2017 in WP number 2381 of 2017 directed
page 26, my lord.
that till the application filed by the petitioner's father is considered and disposed of, the petitioner cannot be dispossessed either by the state or the revenue authorities. Full stop. Further, action was initiated at the hands of the Tahsildar before the special court for
Land grab.
land grabbing in LGC bracket P number 2076 of 2017 against the petitioner and 5 other persons. Full stop. However, by order dated 1/9/2023, the special court disposed of the complaint, stating that it has no jurisdiction to entertain the complaint. Full stop. Thereafter, the Tahsildar has written to the police inspector of Vijaypura police station seeking protection and to ensure that the petitioner does not carry on any activity on the land in question. Full stop. Learned Counsel submits that despite orders being passed by this court on 19th of April 2017, the Tahsildar is precipitating the matter even after having the knowledge that the application filed by the petitioner's father has not been disposed of. Full stop. Next para. Consequently, the respondent Tahsildar is directed not to precipitate the matter any further. Full stop. The Tahsildar is also directed to make a statement before this court as to whether the application filed by the petitioner's father has been considered and disposed of. Full stop. List this matter after summer vacation.
Number 5, Punit C.
For petitioner, that petitioner filed a form number 50
in 1991, please, my lord. The same has not been considered till today, please, my lord. That's why petitioner seeking writ of
Form
command,
number 50
please, my lord.
for
as per
regularization.
Regularization of
57
unauthorized
ಎರಡು ಮಾಡಿದೆ.
modification.
Huh?
57 ಹಾಕಿದ್ದಾರೆ.
Yes,
29461 of 22.
yes, disposed of.
Serial number 6, Pankaja BC.
Appearing for the petitioner in this matter, my lords. My lords, petitioner has made an application and form number 57 for regularization of unauthorized occupation of the land in survey number 57, my lords. Till now, my lords, the Tahsildar of the Chitradurga has
Yeah.
not considered. It is the covered by judgment, my lords, the land bearing survey number 47, my lords.
Huh?
My lords, petitioner has made an application before in the form number 57, my lords.
57.
Yes, my lords.
Same thing.
Same, my lords, is a covered by judgment, my lords.
Yes.
It may be disposed in the similar manner.
29461.
My lords, serial number 10 also, my lords, pertaining to this same matter.
Then also disposed of.
10 of same.
Number 7, Mahesh Arupi.
Your lordship, kindly let me pass over this election portal.
Pass over.
Serial number 8, Mahesh BJ.
My lord, annexure E. Page 23, my lord, is an order passed by the Tahsildar under section 104. But it says that there existed a road as per the records, which is sought to be cleared. Lord, may I take your lordship to before that? Page, Lord, 15 may kindly be.
It said annexure A.
Annexure E, my lord.
Annexure A, you want?
Annexure A and E, both are the order. Now, annexure A, page 15 may kindly be seen. That shows the factual aspect.
Hmm.
Lord, the road which goes straight, my lord, that is the road which is being used now. That is also in petitioner's land. The road which, my lord, which runs from southern side to the, towards the west, my lord, that is the road found in the Nakashi, which goes, my lord, in the middle of an agricultural land. But anyhow, my lord, the petitioner himself has left a road, which is also being used by all the villagers. Tahsildar has passed an order under section 104 for eviction. But even the villagers also, my lord, they have made a requisition that the existing road itself is convenient for the passage, because the other road, which is in the middle of the road, middle of the agricultural land, which is not feasible for the traveling of, more particularly the vehicles. But despite that, my lord, in fact, my lord, if your lordship could look into the report of the revenue inspector, my lord, annexure D, page 21. He also says that, my lord, in the middle, my lord, ಸರ್ವೆ ನಂಬರ್ 37 ಜಮೀನಿನಲ್ಲಿರುವ ನಕಾಶೆ ಕಂಡ ದಾರಿಯನ್ನು ತೆರವುಗೊಳಿಸಲು JCB ಯಂತ್ರದೊಂದಿಗೆ ಹೋದಾಗ ಗ್ರಾಮಸ್ಥರು ಕರ್ತವ್ಯಕ್ಕೆ ಅಡ್ಡಿಪಡಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನಿನ ಪಕ್ಕದಲ್ಲಿಯೇ ಒಂದು ರೂಢಿಗತ ರಸ್ತೆ ಇದ್ದು ಆ ರಸ್ತೆ ಇರುವುದು ನಮಗೆ ಸೂಕ್ತವಾಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 37ರಲ್ಲಿ ಹಾದು ಹೋಗುವ ರಸ್ತೆ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ ಎಂದು ಗ್ರಾಮಸ್ಥರು ಮಹಾಜರಿನಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. This is the factual aspect. The other legal aspect is that, my lord, even your lordship, few days back, Lord, has passed an interim order. The 104, my lord, to pass such orders in so far as roads, streets, the drains, etc. It is the domain of the deputy commissioner under section 67 subclause 2. But considering, my lord, the decision of a coordinate bench, my lord, annexure K, your lordship has recently, my lord, in an identical matter.
You are admitting that there are two roads now.
Yes, one road, it was
One road as per
voluntarily left
the-
by me.
As per the village map.
As per the village map, there is only one road.
As per the village map, there is one road.
One road.
You are saying you have found a alternative
But
road.
in the.
Both are there.
Yes, my lord, both of them.
What do you want now?
Now that the road, my lord, which is shown in the Nakashi,
Ah,
my lord, that cannot be put to use because it goes, my lord, in the middle of the agricultural land.
Ah.
It will not cause inconvenience to anybody else.
what is the
Let-
legal position?
Pardon, my lord.
What is the legal position?
My lord, that is the reason.
Unless you file an application seeking diversion of the road,
That application is filed, my lord, that is filed.
what do you want now?
Now, my lord, let this order be stayed, my lord, till my.
Order.
Now the Tahsildar has passed an order under section 104
Ah.
saying that you form the road. He says that he has
There
directed.
is no question of forming the road. The road is already in existence. You are wanting it to be stopped only to use the other road, alternative road.
The
That
existing,
is not permissible unless an order is passed by the competent authority. Till an order is passed by the competent authority, both the roads will be used.
no, the road, my lord, which is found on the sketch, my lord, it is never put to use. The Tahsildar, the question is, my lord, the Tahsildar under section 104.
File an application, get an order at the hands of the competent authority, then let him say, okay, this road is diverted to this, because it does not show how this road is going to connect to the other roads.
No, if your lordship. could
Nothing
look-
is found on record.
No, that is there, my lord. In the sketch, the sketch is prepared by the office of the Tahsildar itself.
ಎಲ್ಲೋ ಹೋಗಿ ನಿಂತ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ, ಮುಂದೆ ಎಲ್ಲೋ ಹೋಗುತ್ತೆ
ಇಲ್ಲ,
ಏನೋ
ಅದು ಹಂಗೆ
ಗೊತ್ತಿಲ್ಲ.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Both the roads.
Your
Otherwise,
application has to be considered by the competent authority and an order has to be passed for diverting the land,
That's
a
true, my
road.
lord.
Till then, you can't stop them, public from using it.
No, I'm not, no, my lord, this
Learned,
order.
HCGP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Full stop. Next para. The petitioner appears to be aggrieved of the,
Annexure E, my lord.
what is annexure A?
Annexure A and D are the, my lord, annexure A is the initial order. Again, he passed annexure E. My lord, both for the eviction of this,
ನೀವು ಅಡ್ಡಿ ಮಾಡೋದನ್ನ ಖುಲ್ಲಾಪಡಿಸಿ ಅಂತ ಹೇಳಿದ್ರು.
But in the 104 ಅಲ್ಲಿ, if your honor could look into, the lordship could look into annexure A, ಆದೇಶ ಸಾಗರ ತಾಲೂಕು ಆನಂದಪುರ ಹೋಬಳಿ ಆತವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 37 ನಕೇಶ್
Annexure A and annexure E, which are two orders passed by the Tahsildar, Sagara Taluk. Full stop. On hearing the learned counsel for petitioner, it is clear that in terms of the village map, there is a road passing through the land bearing survey number 37 of Atawadi village belonging to the petitioner. Full stop. However, it is sought to be contended by the petitioner that an alternative road to the edge of the property has been formed by the petitioner himself and is being used by the villagers from a long time. Full stop. It is the intention of the petitioner not to permit the usage of the road in which is found, which is in terms of the village map. Full stop. Next para. Learned HCGP submits that unless an application is filed by the petitioner before the competent authority seeking diversion of the road, the petitioner cannot prevent the villagers from using the road in terms of the village map. Full stop. Next para. Have you filed an application?
No, the application is filed. Annexure H may kindly be seen. The village panchayat has recommended to the, my lord, the Tahsildar.
Where is your application, sir?
Application, my lord, is not, application is
ಮತ್ತೆ?
not, application is submitted to the
It
village
is for
panchayat.
you to file an application.
No, application is submitted to the village panchayat, which has, my lord, forwarded to the
Panchayat
Tahsildar.
powers ಇಲ್ಲ.
No, it is forwarded to the
ಹಾಗೆ
Tahsildar.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. It is for you to file an application.
The annexure H may kindly be seen for a moment.
ನಾನು ಏನು ಹೇಳಕ್ಕ. It is up to you. There is substance in the submission of the learned HCGP. So, if the petitioner intends to divert the road, then he will have to make appropriate application to the competent authority. And till then, he cannot prevent the villagers from using the road in terms of the village map.
But if such application is, my lord, filed, my lord, let the, because, my lord, even village, the villagers also, my lord,
Already application file ಮಾಡಿ, you come and make a submission, we will direct.
Serial
Yes.
number 9, Anand KV.
Petitioner for the government matter. No, so the challenge is to an interim order passed by the deputy commissioner in the revision petition with annexure yes, my lord. Page number 195. My lord, in the lordship got it 195.
Where is the order of the assistant commissioner?
Assistant Commissioner is at page number,
Who approves the assistant commissioner?
I am the,
You approve.
I
the
approach the Assistant Commissioner.
In
Assistant-
the year 2001, 2002,
Yes, my lord, the order,
calling in question, MR number 1 of 1983-84.
yes, my lord.
Yes,
My lord, because the long round of litigation was remanded from the KAT, and then ultimately in the year 2021, the Assistant Commissioner has passed an order in my favor.
Hmm.
And your lordship can refer to the respondents in the, before the Assistant Commissioner.
yes.
Two private respondent, Venkateshaya and Raja. They are the persons who objected with respect to my ownership and possession over the property.
Huh?
Before the Assistant Commissioner, only two private respondents, Venkateshaya and Raja.
They are the appellants.
Sorry, my lord.
They are the appellants before the assistant commissioner.
Yes, howದು.
Yes, my lord, before the Assistant Commissioner, which was,
Then you were the respondent. is
I
it?
was the respondent.
Respondent.
Later, my lord, that
They filed an appeal.
They
they filed an appeal.
ಕೇಳಿದಕ್ಕೆ ಹೌದು, I filed an
Sorry,
appeal.
my lord, it was under, I was under the impression that Assistant Commissioner, I am the revision petition before the Assistant.
Nidikkamma,
Yes, my
you
lord.
are the respondent.
Before
they-
that Assistant Commissioner's order,
Yes.
I challenged before the Deputy Commissioner.
ಏನಾಯ್ತು? What is it? What of the contention?
My lords, where my lords, my ownership has been declared as that I am the owner. And the kata was, which was ordered in their name was ordered to be cancelled and ordered to be mutated in my name. My lords, the operative portion of the order is at page number 194.
Suits have been filed.
Lord, suits have been filed. I
Case
have,
number 432 of 1996.
I have filed the suit
Ah.
and there's a decree in my favor.
Suit for?
Suit for injunction against the Gainidar squad sought that they have filed an application for regularization and their application was dismissed. And I am confirmed as an owner because I have purchased it from the year 1981. I am in the possession.
Hmm.
My lords, without bringing all this into the notice, some of the other respondents, my lords, who are not at all party before the Deputy Commissioner, had filed a revision petition again at annexure, yes, my lords, who are not at all the parties. All the while, they are not at all the parties before any of the proceedings. At annexure, yes, my lords,
The
Some-
suit was between you and Venkateshaya and Raja.
Raja,
Huh?
Venkateshaya and two others, my lords, which,
What
my
was
lords,
their contention?
their contention is that, my lord, they are having the right, Gaini rights over the very same property. They have filed an application.
Order
Correct.
was passed by the land tribunal
Land tribunal was, it
in
was
their
passed
favor?
in, no, my lord, there was no order in their favor.
Ah.
It was rejected
Ah.
and it was subsequently confirmed in my name, my lord.
Then how could they claim that they have acquired rights by virtue of orders passed by the land tribunal?
They never, that, my lord, they're all
the
fighting the.
Order of the AC is not challenged by the
By the petitioner?
appellant, my lord. By the no, it was in the favor of petitioner, the appeal was
ಹೌದು. Venkateshaya and Raja did not challenge it.
challenged. ಇವ್ರು ಇಟ್ಲೆ
That
ಅಂಬಿಕಮ್ಮ
appeal was dismissed, is it?
appeal, ಹೌದು, appeal ಅಲ್ಲಿ if my lordship sees the order 194, my lord, the last 3 lines ಅಲ್ಲಿ
ಹಾ.
ಜಮೀನ್ದಾರ ಕ್ರಯದಾರರಾದ CS ಅಂಬಿಕಮ್ಮ, that is the petition ಪುಟ್ಟರಂಗಯ್ಯ ಅವರ ಹೆಸರಿಗೆ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ OS ನಂಬರ್ ಅಂತೆ ಹಾಗೂ ಹಿಂದೆ ಇದೇ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಖಾತೆ ಪಾಣಿ ಮಾಡಲಾಗಿರುವ MR ನಂಬರ್ ನಮೂದಿಸಲು ತಹಸೀಲ್ದಾರ್ ತುಮಕೂರು ಅವರಿಗೆ ಆದೇಶಿಸಿದೆ. That is, the order was in their favor.
Ah.
And my lord, now the review petition has been filed before the Deputy Commissioner under 136(3)
Ah.
by the parties who are not parties before the Assistant Commissioner.
Ah. But
And
what is their claim?
Their claim is, my lords, they claim that they are the sons of my vendor who had sold me in their 1981. And their contention is that, my lords, since they are also the legal heirs,
Hmm.
now that vendor is no more, my lord.
Hmm.
My lord, since they have right over the property and without their right being hesitated, their father had sold it, hence they are also having equal rights over the same.
So that is pending before the Deputy Commissioner, my lord.
Matter is pending before the deputy.
ಅದಾದ್ಮೇಲೆ ಡಿಕ್ಲರೇಷನ್ ಸುಟ್ಟು ನಾನು ಹಾಕೊಂಡು ಅವ್ರ ಮೇಲೆ ವೆಂಡರ್ಸ್ ಓವರ್ ದಿ ವೆಂಡರ್ಸ್ ಸತ್ತೋದ್ಮೇಲೆ ಅವ್ರ ಮಕ್ಳ ಮೇಲೆ ಐ ಆಮ್ ಲಿಟಿಗೇಟಿಂಗ್ ವಿತ್ ದೆಮ್
In the civil code.
ಇನ್ ದಿ ಸಿವಿಲ್ ಕೋರ್ಟ್.
This order before the DC, my lord,
Ah.
what has happened is they have challenged the order of the AC before the Deputy Commissioner under 136(3)
Yes.
by the parties who are not parties before the Assistant Commissioner.
ಆಯ್ತು.
The deputy commissioner has given a stay without any reason. That is what their contention is.
My lords,
It is still pending.
Third stayed as a AC order dated 18/4/2022 till next date. Now we have also approached the very same authority. Now objection akidi 1 year they are not taking up the matter. They are sitting on the matter. My lords, may I request your lordship, let there be a direction from this court. Let the deputy commissioner hear our objection and pass necessary orders. Let this matter a time bound manner disposal model, then will agitate our rights, my lord. Because unless there's a final order, I do agree that, my lord, this court cannot.
Berkeley. Learned AGA takes notice for response number 1 to 4, 1 to 5.
Will file memo for dispensation for other.
The other respondents is not necessary for
Not
the
necessary.
following reason. Next paragraph. Learned counsel for the petitioner submits that even the private respondents herein who have filed the revision petition in RP 19/2023 before the deputy commissioner, Tumpur, have not denied the fact that under a registered sale deed dated
21/12/1981.
the revision petitioner's father, Sri
Well, no, I am the purchaser.
Vendor Elri
Narsimaya. Narsimaya, my lord.
Narsimaya sold esto jaga
Lords, 2 items. Server number 101. Just take that.
sold 4 acres and 6 guntas in survey number 101
And 2
and
acres.
2 acres and 11 guntas in survey number 104 of Satyamangala village, Kasba Hoadli, Tumkur Taluk, in favor of the petitioners,
Petitioner, only petitioner. So,
petitioner. Full stop. There was a counter claim by one Sri Venkateshaya and Raja before the assistant commissioner in RRT bracket
90s.
bracket T close 195 of 2001-2002 stating that they had acquired rights by virtue of an order of regrant passed in their favor. Full stop. However, the assistant commissioner dismissed the appeal by order dated 8/4/2022, directing the Tahsildar to continue the name of the petitioner in terms of MR number 1 of 1983-84. Full stop. The appellants before the assistant commissioner, namely Sri Venkateshaya and Raja, did not file any revision petition before the deputy commissioner. Full stop. However, the legal heirs of late Sri Narsimayana,
Narsimha Shastri and Rama Shastri.
Narsimha Shastri and Rama Shastri, who had sold the property in favor of the petitioner, filed the revision petition before the deputy commissioner, calling in question the orders passed by the assistant commissioner.
Sorry, I interrupt, my lord. The revision petition which has been filed is not by the legal heirs of those persons. They are the private, they are claiming that they have purchased some of the properties. They are not the legal heirs of,
They had independently purchased. the
independently
property.
purchased the property.
Last sentence, Vodama. However, some other persons claiming to have purchased the property from Sri Narsimha Shastri and
Rama Shastri.
Rama Shastri have filed the revision petition challenging the orders passed by the assistant commissioner in RRT so and so 195 of 2001-2002, which is not maintainable. Full stop. Next para, nevertheless, the learned counsel for the petitioner submits that having regard to the nature of the dispute, that was commenced much prior to 1996 and a litigation before the civil court has proceeded in OS number 432 of 1996, which ended in the favor of the petitioner.
Correct.
Appropriate directions may be issued to the deputy commissioner to conclude the proceedings in a time-bound manner. Full stop. Next para. Placing the submission of the learned counsel for petitioner on record, the writ petition stands disposed of, directing the deputy commissioner, Tumkur district, to conclude the proceedings in RP number 19 of 2023 as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of this order.
Yes. Status
According.
so far as the entries in there, because all the entries are standing in my name. Because
Without hearing them, it's not possible. Yes.
All contentions.
Yeah, Nanen I have not said anything.
Obliged.
Then order pass number 11. Avinash Gowda, GS.
Got the order passed by the AS. Assistant Commissioner Malord is at page, annexure C, Malord, page 30. Lord, your lordship may kindly see, Malord, the order was passed on 5/1/2024. Annexure C, Malord, page 30, Malord. The order was passed on 5/1/24. Annexure D, Malord, the petitioners therein one Sakama had expired, Malord, on 9/12/21 itself. Next, Malord, annexure D, page 37. Order is passed against the dead person. Malord, page 37, date of death, Malord, 9/12/2021. Sakama, Malord, has expired on 9/12/21. Against this, Malord, we filed an appeal before the DC, annexure A. Malord, though a contention is raised that, Malord, the order was passed against a dead person. Now, your lord. Malord, just Malord reproduces the appeal memo from page 22 on.
Order was passed, initiated on 2018 itself.
18 itself.
On the proceedings, the
Learned
order
ADA takes notice for all the respondents. Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that although it was brought to the notice of the deputy commissioner that order was passed by the assistant commissioner invoking rule 108K of the Karnataka Land Revenue Rules, 1966, cancelling the grant. But the respondent, Srimati Sakama, against whom the order is passed, had died in the year 2021.
Yes, Malord, 9/12/2020.
Had died on 9/12/2021 in terms of the death certificate produced at annexure D, the deputy commissioner has not adverted to such contention and has simply and has mechanically pass the impugned order dismissing the appeal filed by the petitioners, who are the legal heirs of Srimati Sakam. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures A and C till the next date of hearing.
Number 12, Nataraj BS.
The petitioner has challenged the annexure D and E. That is, E is the endorsement issued by the Tahsildar to refuse to enter my name in the revenue record. And D is that sought for relief of mandamus in respect of annexure D. Background of the case is that, Your Honor, the property in question was granted in favor of Tippaya. I request this Honorable Court to turn to in page number 9, that RTC.
Please come to the synopsis. You have to give all the information in the synopsis. Yes.
My Lordship, in this matter, the property in question was allotted to one.
Petitioner participated in a public auction.
Yes, my Lordship.
Ah.
Background of the case is that property in survey number
And he
297
got registered a sale certificate
from the court,
on 21/6/2005.
2005.
Ah,
That has been registered in sub-register.
ah,
Upon that sale deed, I given a representation from the year 2011 approaching the Tahsildar to
Hmm.
effect the kata by deleting the name of that person who has party in that execution proceedings.
it has not been considered.
Not been
Your
considered,
name has not been entered.
not been affected. And they're saying that, my Lordship, I require to produce
And
the
what is
Lebanese
the
sketch.
endorsement issued now?
Issued stating that I require to produce the Lebanese sketch and also produce the sketch of that property. When the property was auctioned in the court itself, there is a sub-survey number was given to that property. Again, they merged the entire extent of the property in by
Yeah,
showing my
My lord, the endorsement that has been given, my lord, is covered by a judgment of my lordship, my lord. They are asking for Lebanese sketch only to identify the property, my lord. My lord, my lordship has held Lebanese sketch badu license surveyor sketch aru kodlebeku only for the purpose of identifying the.
If the entire extent has been purchased, there is no question or requirement of Lebanese sketch.
If my lordship sees the
ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು a part of it is sold.
endorsement ನೋಡಿದ್ರೆ annexure E ಅಲ್ಲಿ.
Ah,
If my lordship sees the last paragraph of the endorsement, my lord, page 19 annexure E, my lord.
where is the decree?
decrease the producer not annexure
Sale
16.
certificate.
Sale certificate is annexure
Scheduled property.
C in page number 16, my
The
lord.
extent 4 acres.
4 acres, my lordship.
It is a entire extent.
That is the what survey number 297/2. What was the total extent was 4 acres only.
4 acres.
That was a
Complete has
purchase.
been. ಮತ್ತೆ ಇಲ್ರಿ 11 sketch ಏನಕ್ಕೆ ಇರಬೇಕು?
ಅಲ್ಲ ಒಂದು.
ಬರ್ಕೊಳ್ಳಿ.
If my lordship sees ಅಲ್ಲಿ ಇದು ಇವ್ರದಿದೆ RTC ಲಿ the extent is shown is little bit more, my lord. RTC which they have produced.
Oh, 33 acres, 10 ಗುಂಟೆ.
There. But prior to this was merged, my lord.
ಅಲ್ಲ, ಒಂದ್
Subsequently,
ನಿಮಿಷ, ಒಂದ್ ನಿಮಿಷ.
Page
ಅಲ್ಲ, ಅದೇ ಕಾಲಮ್ ನಂಬರ್ 9 ಅಲ್ಲಿ
ಹೌದು ಹೌದು.
various names are there.
There ಇದೆ.
Who is this person against whom the order was passed?
Tippಣ್ಣ son of Mariappa.
ತಿಪ್ಪಣ್ಣ.
Yes, my lord.
ಅವ್ರದ್ದು 4 acres separate ಆಗಿ ಇದೆಯಲ್ರಿ?
Iದೇ subsurvey number was allotted long back itself. When
11
was
is
the auction was conducted.
279/2 ಅಂತಾನೆ ಇರೋದು RTC ಅಲ್ಲಿ ಎಲ್ಲಾರ್ಗು ಸೇರಿ.
ಹೌದು.
297
separate ಆಗಿಲ್ಲ.
279 ಅಷ್ಟೇ ಈಗ merge ಮಾಡಿದ್ದಾರೆ. At the time of the auction, subsurvey number was allotted.
Then where is the separate RTC?
Separate artist not, this is merged ಒಟ್ಟುಗೂಡಿಸಿದೆ ಅಂತ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಒಟ್ಟುಗೂಡಿಸಿದೆ ಅಂತ ಮಾಡ್ತಾರೆ. This is after I purchased the property in the public auction, this land has been totally clubbed together.
ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, my lord.
ಒಂದ್ ನಿಮಿಷ. I will direct them to produce the
Lebanese sketch, my lord. There is a
no,
judgment.
not Lebanese sketch.
Sketch prepared by the license.
The previous documents
My lord.
found in the office of the Tahsildar as well as the ADLR.
Yes, my lord.
If there is any information that this property belonging to Sri Tippanna was separately identified and coded and new number was issued, there is no need for issuance of Lebanese sketch.
License surveyor.
If that is not there, then we will direct.
Yes.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. The grievance of the petitioner is that although he purchased 4 acres of land in survey number 279/2 of Changavara village, Gaudagere Hobli, Sira Taluk, in a public auction conducted by the Civil Judge Junior Division, Sira,
In execution number 160.
in
of 96.
execution case number
160 of 96.
160 of 1996, and got a sale certificate registered in the office of the sub-registrar, Sira Taluk, nevertheless, the respondent Tahsildar has issued the impugned endorsement declining to register the name of the petitioner in the RTC as against Sri Tippanna, who was the earlier Khatedar, only on the ground that the petitioner is required to furnish a 11E sketch. Full stop. Learned Counsel submits that a perusal of the RTC for the year 2023-24 at Annexure A clearly shows that 4 acres of land were separately registered in the name of Sri Tippanna, son of Mariappa, whose property was purchased by the petitioner. Full stop. In that view of the matter, Learned Counsel submits that there is no need for
11 is.
the petitioner to procure a 11E sketch. Full stop. Next para. Learned AGA is directed to secure instructions from the Tahsildar and the concerned Assistant Director of Land Records as to whether the revenue records and survey settlement records disclose the identification of 4 acres of land in favor of Sri Tippanna, son of Mariappa. Full stop. Release this matter on 30th of May 2024.
Number 13, G.R. Lakshmipati Reddy.
Yes, Mr. Lakshmipati Reddy. Matter is called out. There is no representation for the petitioner. List this matter after summer vacation.
Number 14, Vishwanatha Shetty V.
I beg to appear for the petitioner. That the petitioner has challenged Annexure K order passed by the Deputy Commissioner. But the facts of the case, my lords, please.
This is under section 49.
My lords.
Which is the previous order?
My lord, the previous order is passed by the Tahsildar at Annexure E, my lords.
Annexure E.
Annexure E, page 47.
There is an order passed by the Assistant Commissioner.
My lords, that Annexure E order, some correction is made by Assistant Commissioner. For that, directly the respondent number 5 approached the Deputy Commissioner.
Yes.
My lord, the facts of the case, my lord. The properties consisting in 3 villages of Dodde Yajjaji, Chikkabelwangla and Sonnenalli villages, which are around 39 acres, which were 30 acres, were belong to Kane Mata, my lord. One Sri Sadakshari Swamigalu was Matadipati, my lord. He acquired all these properties in his name out of his own efforts under the different registered servants. My lord, during his lifetime, my lords, since this Sadakshari Swamigalu is hails from Siddhaganga Mata concerned, my lord, he has established a education trust under the name and style of Sri Siddhalingeshwara Education Society, my lords, please. And he was running a school, free school, to an extent of 400 children, my lords, please. Free school and including hostel provided in survey number 48 of Sonnenalli village and surrounding one day 3 villages. These 3 villages sketch out. He acquired all these properties as single plot. My lords, please, during his lifetime, the secretary of the this education society, now who represented the society, was looking after the affairs. and Swamiji was looking after entire administration and all. Swamiji intention was to see that whatever the proceeds of this acre land acquired by him for the purpose of developmental and also to help the general public. During the lifetime of Swamiji, my lords, please. Swamiji has executed a will, my lords, please. I produced at page number 30, my lords, please. May kindly peruse at page number 30. A typed copy put this. Certified copy, handwritten. My lord, in para 3, my lord, ಮಠದ ಆಸ್ತಿಗಳನ್ನು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿಕೊಂಡು ಹೋಗಬೇಕೇ ವಿನಃ ಯಾವ ಕಾರಣದಿಂದಲೂ ಪರಭಾರೆ ಮಾಡಕೂಡದು. My lord, in this regard, in respect of this will, my lord, subsequently a small dispute was also raised between this secretary and some of the villagers and also Swamigalu. In this regard, my lord, P&SC 4 of 2007, Annexure B, my lords, was filed by Swamiji. That is respond number 5, my lords. Annexure B, page 32, my lords. In this also, my lord, finally the matter came to be settled. My lord, in page number 34, last paragraph in the Suru. My lord, before the Honorable Court, an order is passed. The name of Kanya Mata is to be entered in the column number 10 of the RTC extract. And Swamigalu, Basaraj Swamigalu name can be referred as President or Matadipati and refer Madian. Then, in column number 12 concerned, my lords, please, 12 class 2, these lands were leased during the lifetime of Swamiji in favor of this trust. Name of trust is to be mentioned in the revenue records. Then subsequently, my lords, please, the things were going on. My lord, this respond number 5 has started to act indetrimental to the interest of the will. In fact, my lord, 400 students who were studying there, and he has given a letter, we are unable to run the institution. That letter was given to Education Department. His school closed Madspittu Swami. That is a different aspect, my lord. Subsequently, what he did, my lords, please, kindly peruse RTC extract page 43, my lord, Annexure C5, my lord.
Please
Page
read the
43, my lord.
the last portion where you said these were the orders passed by the
Honorable
district court.
May kindly peruse, my lord. May kindly peruse at page number 34, last paragraph. May I read, my lord?
Yes.
It is further ordered and decreed that the registered will, it is specifically stated that the lands bearing survey numbers alla barutte Swami. Numbers, I am no dispute with regard. Next page bandaga Swami. Hejjaji village and the lands bearing survey number so and so. Anteli Swami. 5ನೇ line alli
Are the exclusive properties of
exclusive properties of Kane Matta. In this, my lord, in this view of the matter, in the records of rights pertaining to these lands, in column number 9, the name of Khanemat represented by its Matadipati, Sri Basavaraja Swamigalu, should be shown. And the name of the Siddhalingeshwara Vidya Samaste by its secretary should be shown in column number 12, as the said properties are leased by late Shadakshri Swamigalu in favor of Siddhalingeshwara Vidya Samaste under agreement dated 22/7/1976 and 6/6/1984, and that the said lease agreement should be referred to in column number 11 pertaining to other rights. However, the plaintiff shall not, my lord, plaintiff is respond number 5 Swamigalu, shall not be entitled to alienate the said properties except on cultivation with the defendant. My lords, please. Now, my lord, as per this exhibit RTC C5, my lord, Annexure C5, page number 43 may kindly be there. My lord, intellectually, my lord, he moved before the revenue authority. He got his name, Khanematanu pakkadalli bitru, avaru swanta hesaru bariskonಡ್ರು Swami. School ಹೆಸರನ್ನು ಕೂಡ ಇಲ್ದಂಗೆ ಮಾಡ್ಬಿಟ್ರು ಈ ಟ್ರಸ್ಟ್ ಹೆಸರನ್ನ. Then my kindly peruse at this stage, my lord, kindly turn to Annexure L, my lord, page number 58, my lord. Annexure L, page number 58. My lord, 5 acres of land belong to the Matt, my lord. He has sold by appointing one developer as his GPA holder for 2 crores, my lord, in page number 88, sale deed commences, my lord. First he says Basavaraja Swamigale, represented by one Mrs. Paulwit developers, sold in favor of Pranav Reality, my lord. Then my lord, next page ಅಲ್ಲಿ ಅವರೇ ಮಾಲೀಕರು ಅಂತ ತೋರಿಸ್ಕೊಂಡು ಬಂದ್ರು ಸ್ವಾಮಿ, ಕಾನೆಮಠ ಹೆಸರೇ ಹೇಳಿಲ್ಲ. Then sale deed amount, may kindly peruse at page 92, my lord. In page 92 para 5 ಅಂತಿದೆ ಸ್ವಾಮಿ. 2,28,00,000 ಮಾರ್ಕೊಟ್ರು, ಸ್ವಂತಕ್ಕೆ ಉಪಯೋಗಿಸ್ಕೊಂಡು. No account of, at least ಮಠದ ಹೆಸರಲ್ಲಿ ಅಕೌಂಟ್ ಇದ್ರು, I can understand, my lord. Then my lord, ಸ್ಕೂಲ್ ನಾವು ನಡೆಸ್ತಾ ಇರ್ತಕ್ಕಂಥ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮಠದ್ದು ಬಿಟ್ಬಿಟ್ಟು, may kindly peruse the next annexarium at page number 101, my lords, please. He leased for 25,000 to some third party, my lord, instead of running for public purpose as per the Swamiji's intention to give public. So this land, remaining lands, my lord, he has ಬರ್ಸ್ಕೊಂಡಿದ್ದಕ್ಕೆ the secretary has approached the Tahsildar to enter the name of this trust also in column number 12 class 2 and all. My lords, please. Yes, sir.
I have to go to the civil court only.
My lord, that no, I'm not in this aspect, my lords, please. No, now the order is.
Nothing can be done by the revenue authorities. You will have to go before the civil.
No, I'm not on the point of his sale and all, and revenue authority has to pass any order. I'm not on that, my lord. Now my humble submission is that the name of Basavaraja Swamigalu mentioning in column number 10.
ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
Swami?
After the sale deed.
No, I asked the No. Just to show my lords his conduct in misusing ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಹೇಳಿದೆ. ಅವ್ರ ಹೆಸರನ್ನ ಕಾಲಮ್ ನಂಬರ್ 10 ನಲ್ಲಿ ಕಾನೆಮಠ ಮತ್ತು ಬಸವರಾಜ ಸ್ವಾಮಿಗಳು ಮೀಠಾಧಿಪತಿ ಅಂತ ಬರೆಯೋದಕ್ಕೆ ನಂದು ತಕರಾರಿಲ್ಲ. ಸ್ಕೂಲು ಹೆಸರೆಲ್ಲ ಇತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ರಿಮೂವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. As per the directions which was continued in the
sale deed.
I asked the ಬೇಡ ನಾನು. I asked the ಬಗ್ಗೆ ಕೇಳಿ.
ಇನ್ಯಾವುದು? What it means?
The other properties, man.
Which are the other properties?
Other properties are consisting around another 25 acres of survey numbers. I refer to in pair of 4, man. In the repetition pair of 4, 5, 6. All lands ಮಾಡ್ಲಿ ಸ್ವಾಮಿ. ಕೊಂಡುಕೊಂಡಿರೋದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ತೀನಿ.
Before in the impugned orders.
Impugned order is only pertains to.
Is there any information showing that which are the lands that are sold and which is the property?
It is there.
You are asking for the
in annexure K and annexure Ch.
In the impugned orders.
It is there.
From in the impugned orders, please point out.
Please. No, that impugned order referring to Tahsildar order, my lord, may kindly peruse. Survey numbers are there in this. Tahsildar order annexure E.
Please come to the order of the deputy commissioner.
The order of
the deputy commissioner.
Order of the deputy commissioner is referred to survey numbers in pair of.
Adralli, please show the survey numbers that have been sold. And survey numbers for which you are asking for.
150 bar P32 is sold, my lord.
Ellide?
My lord, in fourth line, my lord. ಹುಲಿಕುಂಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 150 P32 sold property. That ಬಿಡಿ ಸ್ವಾಮಿ, ಅದ್ರ ಬಗ್ಗೆ ನಾನು
respect of which you are asking for the revenue entry.
That is, my lord, kindly peruse survey number 4th line, my lord. From 4th line, 1 minute. 4th line. ದೊಡ್ಡ ಬೆಳವಂಗಲ ಚಿಕ್ಕ ಬೆಳವಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 53/4A2 ಸೊನ್ನೆನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ.
Have you said these are not properties that have been disposed of?
Not yet disposed. Only one property. This 150 bar P32. 32 alla.
One property has been sold.
That only sold. Other properties are not sold.
Let us see the sale deed.
My lord, sale deed may kindly be perused at page number 88, my lord. My lord, in 88, my lord, schedule I like to take, my lord's kindly.
Survey number 150 bar P32.
ಹೌದು ಸರ್. 32 A ಅದು ಇಲ್ಲಿ ಅದನ್ನ P it's 3 ಅಂತ 2 ಅಂತ ತೋರಿಸ್ಕೊಂಡೆ ಸರ್. ಬರೀ 32 ಅಂತಾನೆ.
150 bar P32.
This 5 acres of land is sold out. I do not want to seek any order in respect of that property.
ಅದನ್ನು ಸೇರಿಸಿದಿರಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಅರ್ಜಿ ಕೊಡುವಾಗ ಸೇರಿಸಿದ್ದಾರೆ, ಆಮೇಲೆ ಮಾರಿರೋದು ಗೊತ್ತಾಗಿಲ್ಲ. ಆ ಸೇಲ್ ಡೀಡ್ಸ್ ಆಮೇಲೆ ಕೊಟ್ಟು ಅಲ್ಲಿ ಸಪ್ಲೈ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಅದು ಬೇಡ ಸ್ವಾಮಿ, ಅದು ಬೇಡ. 18 ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದು ಸ್ವಾಮಿ. ಇದನ್ನ ಈ ಅರ್ಜಿ ಏನು ಟು ಇನ್ಕ್ಲೂಡ್ ದಿ ನೇಮ್ ಆಫ್ ಟ್ರಸ್ಟ್ 18 ಇಂದ ಪೆಂಡಿಂಗ್ ಇತ್ತು, ಇವರು 21 ನಲ್ಲಿ ಸೇಲ್ ಮಾಡಿದ್ರು. ಸೊ ದಟ್ ನಂಬರ್ ವಿಚ್ ವಾಸ್ ರೆಫರ್ ಟು ಇನ್ 18 continued in the order of Tahsildar and DC, my lord. Except that sold portion, my lord, for other properties, my lord, it may be stayed. If it is his name is shown, he will sell all other properties also, my lord.
If my lordship says page 76 ಅಲ್ಲಿ RTC produce ಮಾಡಿದ್ದಾರೆ of all latest of 23-24.
ನಮ್ಮ ಹೆಸರು in presence of the Tahsildar order, the name of trust is entered there in my lord. The name of trust and Kanemata is also referred, my lord. In presence of the order of the Tahsildar and
ಅದೇ ತರ ಇದೆಯಲ್ರಿ ಆರ್ಡರ್. Please
Swami?
read the impugned order at page number 86.
ಇದೆ ಸ್ವಾಮಿ, ಬಟ್ his name is shown as Kanemata ಅಂತಿದೆಯಲ್ಲ, ಆದ ಕಾರಣ
No,
ಇವು
no.
ಕಾನೆಮಠ
Please
ಸೇರಿಸ್ತಾ
read-
ಇಲ್ಲ.
Please read it. sir.
ಕಾನೆಮಠ ಸೇರಿಸಿಲ್ಲ ಸ್ವಾಮಿ, ಕಾನೆಮಠ ಮಠಾಧಿಪತಿಗಳ ಹೆಸರು ಅಂತ ಸ್ವಾಮಿ. ಕಾನೆಮಠ ಇದನ್ನು
ಓದಿ.
ಪ್ರತಿನಿಧಿಸುವ ಮಠಾಧಿಪತಿ ಬಸವರಾಜ ಸ್ವಾಮಿ ಎಂದು ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ನಮೂದಿಸುವುದು ಅಂತ ಹೇಳಿದೆ.
Huh?
No notice is also given to us. No notice is also given to us.
It is in terms of the decree passed by the.
I understood.
Then what is the problem?
If his name comes there, he will sell away. Already once held it to
No,
support.
that is how the order is passed by the district court.
My lords, please. They
District court ಅಲ್ಲಿ ಯಾವ ತರ ಹೇಳಿದಾರೋ ಅದೇ ತರ ಮಾಡಿ ಅಂತಾನೆ ಮಾಡಿರೋದಿಲ್ಲ.
now my lord, he has violated the orders of
That
the.
is a different question.
Can
sir.
his name be continued? my lord?
You are only requesting
Yes, my lord.
that the
But-
revenue entry should be made in terms of the orders passed by the district court.
that-
That is what the deputy commissioner has ordered now.
But if once his name comes, my lord, already he got his name alone in his name he got, which was set aside by the Tahsildar, which was rectified, is alone, not even Kanemata was referred by him. Tomorrow, my lord, it would leads to, I think, losing of this property belong to Mat
Lordship says in
for his personal use and,
in some of the RTC, only the name
How
of
can he do it, sir?
my lord, it is already,
Now,
sale deed is
the
produced.
orders passed by the deputy, ಆವಾಗ ಅವ್ರ ಹೆಸರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು.
ಹೌದು.
ನೀವ್ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ.
ಅದು ಮಾಡೇ ಆಗಿರೋದು ಈಗ ರೆಸ್ಟೋರ್ ಆಗಿದ್ದು ಎಲ್ಲ ಹೆಸರು ಕಾನೆಮಠ ಅಂತ ತೋರಿಸಿ
ಸರಿ ಮತ್ತೆ ಇನ್ನೇನು then
may kindly peruse on
only one property has been sold.
my lord J40
ಬಗ್ಗೆ you have to take proper steps.
that I'll ಸೇಲ್ ಆಗಿರೋದ್ರ ಬಗ್ಗೆ ತಗೊಂತೀನಿ ಸ್ವಾಮಿ. I can understand, I am not before my lords.
Cannot be agreed by the impugned order.
My lord, once
How are you agreed by the impugned order? It is in your favor only.
it's not in any manner affecting, my lord. If once his name is shown, already a person who indulged in it.
Sir, anyone will understand. Kani Mata ಕೆಳಗಡೆ represented by so and so ಅಂತ ಇರೋದು. It will not become his own property.
Definitely, my lords, please, I agree with my lords, please. When once there is a, because of the reason of this, when once in the
Then you will have
register.
to go back before the district court once again, seek modification of that order.
Violation of the order.
Till that it is not possible.
For violation of the order,
ಬೇರೆ
this
that-
honorable courts,
regarding that sale of 6 acres,
my lord,
you will have to approach the
civil court, my lord,
Ah,
I'll approach.
yes.
I'll approach the civil court, my lord. To that effect, I am not seeking relief. But if once again he is allowed, my lord, he will continue to sell the property, we will have to.
Tell it, sir. Now the deputy commissioner has passed an order which will ensure that the RTCs will be maintained in terms of the directions issued by the district court.
May make a, maybe beyond the scope of some extent. May make a request, my lords, that ye shall not create any encumbrance of the properties, my lord. To save,
ಅದೆಲ್ಲ how can this court pass such an order, sir?
my lord, because it is already there in.
It is already high time.
No, it is already there in the will as well as in the P&S.
ಅಲ್ಲಲ್ಲ,
He has to,
have you taken steps challenging the sale deed?
now I will have to, my lord. I came to know later.
It is high time. You please do it. ಯಾವಾಗ ಆಗಿರೋದು ಅದು?
Some, sale deed
ಯಾವಾಗ ಆಗಿರೋದು?
2021 ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ
During,
you have not filed a suit.
no, I'll have to, during Corona, my lord, in that particular point of time, he did all this.
Learned AGA takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. On perusing the impugned order passed by the deputy commissioner from a Bangalore rural district at annexure K, this court is satisfied that the deputy commissioner has directed the Tahsildar to ensure that the entries in column number 9, 11 and 12 are made in terms of the orders passed by the district and sessions judge in P&SC number
4.
4 of
ಇಲ್ಲ sir, 4 ಬಂದು OS ಆಗಿ convert 2 of 2005, OS 4 of 2007
2 of 2005.
and bracket ಅಲ್ಲಿ OS 4 of 2007. If once dispute arises in respect of P and S, it will be converted into suit, my lord.
Which was converted as OS number
4 of 2007.
4 of
2007.
2007.
As per
Dated
Annexure B.
3rd of July 2010. Full stop. The Tahsildar, respondent Tahsildar is directed to comply with the directions issued by the Deputy Commissioner most expeditiously to ensure that no further transactions or encumbrances are created contrary to the directions issued by the district and the learned district and session judge.
ಅಲ್ಲ ಆಗೋಗಿದೆ ಅದು. ಆಗೋಗಿದೆ.
No further.
ಆಯ್ತು. ಅಲ್ಲ ಯಾಕಂದ್ರೆ 20.
ಯಾಕಂದ್ರೆ that is only 6 acres. ಇನ್ನು ಬೇಕಾದಷ್ಟಿದೆ.
25 ಎಕರೆ ಇದೆ.
Actually ಬೇರೆ ಇದೆಲ್ಲ my lordship they have produced RTC ಅಲ್ಲಿ.
I'll take necessary steps before this.
ಆಯ್ತಲ್ರಿ ಆಗ್ಲೇ 2.5 ವರ್ಷ ಆಯ್ತಲ್ರಿ.
ಇಲ್ಲ ಸರ್, ಅವ್ರ ಗಮನಕ್ಕೆ ಬಂದಿದ್ದೆ ಲೇಟ್ ಆಯ್ತು.
ಅಲ್ಲ ಬೇರೆ RTC ಲೆಲ್ಲ it is only much name has been shown my lord. They have produced 2023, 24 ಅಲ್ಲಿ.
Yes.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಏನಿದೆ ವಾಟ್ ಎವರ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಐ ಪ್ಲೇಸ್.
Yes.
Number 15, Nagaraja RC.
Previous matter, serial number 13. Just delayed 1 second to come. I was at the finish.
ಅವ್ರು ಇವ್ರು ಬಂದಿದ್ರು ಕೇವೇಟರ್ ಹೋಗ್ಬಿಟ್ರಲ್ಲ. ಯಾರು?
Basuling.
Where is he?
Indraju BM.
ಅವ್ರು ಬಂದ್ರೆ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, otherwise I can't take it up. Yes.
Number 15, Nagaraja RC.
This is under section 79 A and B, my lord.
The order of the AC is on 17/7 to 2012 my lord. Sale deed of 26/2/2010, same party. Look.
The lordship has, the Tahsildar has given an endorsement saying
Same
that
order
79 A and B
appear before the Assistant Commissioner on 31st of May 2024.
Preliminary hearing. Serial number 16, BK Chandrasekhar. BK Chandrasekhar.
Not the petitioner is the absolute owner of the land in question, having purchased the same under the registered sale deed, Annexure D. Revenue entries are also entered. Even earlier revenue entries which are standing in the name of our vendor is also produced. Annexure C to E, E2. And revenue entries F and F1. But thereafter, there are certain discrepancies in the measurement for which I approached the revenue authorities. Revenue authorities set right the mistake as per Annexure G.
Who are the private respondents?
Fifth respondent. Fifth respondent claiming to have purchased certain portion of this land has moved the Tahsildar
Purchased
without
from whom?
notice. Yes, he is said to have purchased.
Purchased from whom?
Purchased from somebody. Yeah, ಹೇಳಿದೀನಿ ಪ್ಯಾರಾ 6 kindly be seen. ಹೇಗೆ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತಾನೆ ಹೇಳಿದೀನಿ.
So you filed a suit
ಸೂಟ್ ಇದೆ,
in OS number
ಅವರು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
of 2015.
ಅವ್ರದ್ದು ಸೂಟ್ ಇದೆ ಲಾಸ್ಟ್ ಅನೆಕ್ಷರ್. ಈ 2 ಸೂಟನ್ನು ಅವರು ಇದು ಮಾಡೋದು ನಮ್ಮವ್ರು ಹೇಳಿದ್ರು ಇದಕ್ಕೆ ತಗೊಂಡಿಲ್ಲ, ಗಣನೆಗೆ ತಗೊಂಡಿಲ್ಲ. 2 of 22 ಅವ್ರದ್ದು, ಇನ್ನೊಂದು ನಮ್ದು ಅರ್ಲಿಯರ್. ಅದೇನಾಯ್ತು, ಅರ್ಲಿಯರ್ ದಿ ಸೂಟ್ ವಾಸ್ ಡಿಕ್ರೀಡ್ ಫಸ್ಟ್. Some of the defendants have challenged the same. Then ultimately the appellate court remanded the matter. Now it is pending.
Your suit also is pending now.
My suit is also pending. Their suit is also pending.
Yes.
Without taking note of all these things, now proceeded to order for the entry of name of the fifth respondent after 80 years. ಅದು ಹೇಳ್ತಾರೆ after 80 years ಅಂತ, but the reason ಏನು ಕೊಡಲ್ಲ. But however, ordered to enter the name of the, ಅದನ್ನು ಅಪಿಯರ್ ಆಗ ನಾನು ರಿವಿಷನ್ ಹಾಕಿದೆ ಬಿಫೋರ್ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಎಲ್ಲಾನು ಹೇಳ್ತಾರೆ, ಇದ್ರ ಬಗ್ಗೆ ಏನು ಮಾತಾಡೋದೇ ಇಲ್ಲ. Just he says the order the assistant commissioner is correct. Now their sale deed is also produced. Para 6 may kindly be seen. ಅವ್ರು ತಗೊಂಡಿರೋದು 24/4/1941. 39 ಅದನ್ನು ಹಾಕಿದ್ದೀನಿ. I have produced annexures P series P1 P2. ಈ ಲ್ಯಾಂಡ್ಗೂ ಇವಾಗ ಮಾಡಿರೋ ಲ್ಯಾಂಡ್ಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧವೇ ಇಲ್ಲ ಈ ಸೇಲ್ ಡೀಡ್ಗಳು ನೋಡಿದ್ರೆ. ಅಂಡ್ ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಮ್ದು ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರಿ ಜಮೀನೆ ಮಂಜೂರಾತಿ ಕಾಯ್ದೆ ಉಲ್ಲಂಘನೆ ಇನ್ನಿತರ ಕಾಯ್ದೆಗಳ ಉಲ್ಲಂಘಿಸಿರುವುದನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು
ಅಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ಏನು ಮಾಡಿಲ್ಲ. ಅದು ಅವ್ರ ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿದಾರೆ ವೆಂಡರ್ಗೆ, ನಾಟ್ ದಿಸ್ ಲ್ಯಾಂಡ್. ಇನ್ನು ಈವನ್ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಇಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. Annexure P1 series is the sale deed. P1 P2 P1 P1 P2. 1941 sale deed is the sale deed which is in favor of fifth respondent, which was not brought to the light till 2021.
Which is the mutation entry?
ನಮ್ದು ಅದು ನಾ ಸೆಟ್ರೈಟ್ ಮಾಡಿರೋ ಎಂಟ್ರಿ.
ಯಾವುದು MR ನಂಬರ್ ಏನ್ ನಿಮ್ದು?
ಎಕ್ಸಿಬಿಟ್ Annexure G.
Where is the RTC?
RTC ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. ಫ್ರಮ್ Annexure E to F, F1. ಇದರಲ್ಲಿ ನಮ್ಮ ವೆಂಡರ್ಸ್ಗಾಗಿರೋದು ಹಾಕಿದ್ದೀನಿ, ನಮಗಾಗಿರೋದು ಹಾಕಿದ್ದೀನಿ. T. Srinivas.
Total extent of land is 7 acres 35 guntas.
ಅವ್ರ ಆ ತರ ಇಲ್ಲ. 4 acres and ಆಡು.
RTC. Please
4 acres and ಆಡು.
Please see the RTC, sir.
ಹೌದು, ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಅದು. ಬಟ್ ಅವರು he doesn't say ನಮ್ದೇ ಪರ್ಚೇಸ್ ಮಾಡಿದೀವಿ ಅಂತ.
What you purchased is 3 acres 30 guntas.
3 acres 36 ಗುಂಟ.
And what they have purchased is 3 acres 26 guntas.
ಎರಡು ಮಿಕ್ಸ್ ಇಲ್ಲ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ ರಾಂಗ್ಲಿ. ದೇ ಐಡೆಂಟಿಫೈ. ಎಸ್, your lordship may kindly take the order at Annexure
See, there are total 7 acres 35 guntas in survey number 25.
ಹೌದು.
And both the names are there in respect of 3 acres 30 guntas, 3 acres 26 guntas. What is the difficulty?
ನಮ್ದು ತೆಗೆದು ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಹೆಸರನ್ನ.
ಇಲ್ವಲ್ಲ,
ನಮ್ಮ ಹೆಸರು ತೆಗೆದು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿ ತೆಗೆದಿದ್ದಾರೆ?
ರೆವೆನ್ಯೂ ಎಂಟ್ರೀಸ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿ ತೆಗೆದಿದ್ದಾರೆ?
ಲಾಸ್ಟ್ Annexure may kindly see ರೆವೆನ್ಯೂ ಎಂಟ್ರೀಸ್ ಲಾಸ್ಟ್ Annexure. ಅವ್ರ ಹೆಸರು ಮುತ್ತಯ್ಯ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ. ನಮ್ದು ತೆಗೆದುಬಿಟ್ಟು
ಯಾವುದು
ಲಾಸ್ಟ್ Annexure F1.
ನಿಮ್ಮ ಹೆಸರು ಇದೆಯಲ್ಲ?
ಪದ್ಮ ಇದೆ ಅಲ್ಲಿ.
ಇಲ್ಲ, ನಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಇಲ್ಲಿ.
ವಾಟ್ ಇಸ್ ದಿಸ್ ಸರ್?
ಆಮೇಲೆ ನಮ್ಮ ಹೆಸರು ಇಟ್ಟು ನಾವು ಅರ್ಜಿ ಕೊಟ್ರಿ. ಸಿ ದೇ ಹ್ಯಾವ್ ಎಂಟರ್ಡ್ ದಿ ನೇಮ್ ಆಫ್ ದಿ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ನಾವು ಅರ್ಜಿ ಕೊಟ್ವಿ. ಆಮೇಲೆ ದೆನ್ ದೇರ್ ಆಫ್ಟರ್ ಇಟ್ ವಾಸ್ ಚೇಂಜ್ಡ್. ನಮ್ಮ ಹೆಸರಿಗೆ
ಬಂದಿದೆಯಲ್ಲ,
ಈಗ ನಮ್ಮ ಹೆಸರಿಗೆ ಬಂದಿದೆ.
ಪ್ರಾಬ್ಲಮ್ ಏನು?
ನಾವು ದಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಇಸ್ ದೇರ್.
ವಾಟ್
ಆರ್ಡರ್ ಇಸ್ ದೇರ್. Pursuant to the impugned order, tomorrow the civil court may change their version. ಗೊತ್ತಿಲ್ಲ ಅದೇನ್ ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ಅಂತ. ಅಲ್ಲ, ಇಲ್ಲಿ ಆಲ್ರೆಡಿ Annexure A and B are the orders. Annexure A and B are the orders.
He has said nothing.
ಅಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಬರೀ
Between the two of you. He has only said
Your
please
lordship
find out
may kindly see.
whether it is government land.
3 acres 26 ಗುಂಟಾಸ್ಗೆ ಹಾಕ್ತಾರೆ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರು. ಪೇಜ್ 40 ಆದೇಶ ಪೇಜ್ 39. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಾದಿಯ ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ 25ರಲ್ಲಿ 3 ಎಕರೆ 26 ಗುಂಟೆ ಅಂತಾರೆ ಅವರು. 3 ಎಕರೆ 26 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಎಕರೆ 26 ಗುಂಟೆ ನಮ್ದು. ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ
3 ಎಕರೆ 30 ಗುಂಟೆ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆ.
36 ಗುಂಟೆ
ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆ. ಬಟ್ ಇಲ್ಲಿ ತೆಗೀರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಇದ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಿಸ್ ಅಪೀಲ್ See, this appeal is by
directed in terms of the registered document.
Annexure B ಇದೆಯಲ್ಲ,
you can enter their name. That is not going to disturb your revenue entries. Accordingly, both the names are there.
ಅಲ್ಲ, ನಮಗೆ ನೋಟಿಸೇ ಇಲ್ಲ ಅದು. ಈ 3 acres 26 ಅವ್ರು ಕೊಂಡ್ಕೊಂಡೇ ಇಲ್ಲ. ಅದೇ ಈ ಸೇಲ್ ಡೀಡ್ಸ್ ನೋಡಿದ್ರೆ ಇವಾಗ Annexure P, P1, P2 ಅದ್ರಲ್ಲಿ ಅವ್ರು ಕೊಂಡ್ಕೊಂಡೇ ಇಲ್ಲ. ಅದನ್ನ
only concerned with your lands. Your name is there in the revenue records. It has not been removed. How are you agreed?
3 acres 26 ಗುಂಟೆ ಅವ್ರು ಕೊಂಡ್ಕೊಂಡೇ ಇಲ್ವಲ್ಲ.
ಯಾರು? How are you worried about the other man?
No, fifth respondent.
You should only worry about your revenue entry. It is there.
when
It has
the,
not been
when
removed.
the civil litigations were pending.
There is any
I-
litigation
second,
regarding
1 second.
encroachment
Huh?
at the hands of another person, that has to be decided by the civil court.
That is why now
Is
before the
Nimma
civil
CH-8
court,
prakara, revenue entries are there.
then this order would not have been passed. Annexure A and B would not have been passed.
Sir, it's a direction to the Tahsildar to enter their name in terms of the registered document.
ಅವರು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅವ್ರಿಗೂ ಡೌಟ್
ಆಯ್ತು.
ನಾವು ಸೂಟ್ ಹಾಕಿದೀವಿ Annexure B latest order ಇದು
7 ಎಕರೆ ಚಿಲ್ಲರೆ ಇದೆಯಲ್ಲ.
Annexure B is the
Both
latest
of you
order.
have purchased, both of your names are there in the RTC.
No. 1 second, my lord.
Well,
Annexure B is the latest order after the suit.
AGA,
When the suits are pending, after the suit, this Annexure B is passed.
respondents number 1 to 4, issue notice to respond number 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Having gone through the material available on record, more particularly the RTC at annexure F1 for the year 2023-24, it is clear that the name of the petitioner continues in the RTC in respect of 3 acres 30 guntas in survey number 25 of Bobanahalli village, Kasba Hobli, Chanpatna Taluk. Full stop. The name of the fifth respondent is entered in respect of 3 acres and 26 guntas. Full stop. The total extent of land available in survey number 25 is 7 acres 35 guntas. Full stop.
Including Karab.
Prima facie, comma,
Including Karab. 7 acres,
court
35.
does not see any grievance that can be vented at the hands of the petitioner. Full stop. Yes.
Number 17.
Not-
Regularization.
I have sought for status quo to be maintained in the revenue records, in the revenue records.
ಇದೆ ಸರ್ ಇಬ್ಬರ ಹೆಸರು ಇದೆ.
ಇಲ್ಲ my lord, in the event ಅವ್ರು 3 acre 36 DC ಅವ್ರಿಗೆ ಆದೇಶ ಮಾಡಿ ಇನ್ನ 3 acre 20 ಗುಂಟ ಅದರ್ಸ್ ಇದೆಲ್ಲ ಅದನ್ನ ಸರ್ಕಾರದ ಸೇರುತ್ತೋ ನೋಡಿ ಅಂತ ವೆರಿಫೈ ಮಾಡಿ ಅದು.
But that is not his contention.
ಇಲ್ಲ ಅವ್ರಿಗೆ actually the other person is aggrieved by this order, not the petitioner my lord. ಅವ್ರು 3 acre 36 ಗುಂಟ intact ಇಟ್ಟಿದ್ದಾರೆ.
Yes.
Number 17.
I appear for the petitioner.
79 AB na?
ಹೌದು. Same person,
10%?
same person.
Huh?
3271.
Yes.
Annexure F is the order, impugned order, page 40.
Appear before the assistant commissioner on 31st of May.
But there was an earlier order dropping the proceedings, same in respect of the same transaction, the earlier assistant commissioner at annexure C dropped the proceedings against me under section 70 for violation of section 79A and B. Annexure C, page 33, my lord. ಬಿಡಿ ನಾನು ಗೊತ್ತು. Order is at page 36 and 37, 34 and 35. I have carefully examined the records, considered the contentions put forth on behalf of the respondent. In the first instance, as per RTC, in respect of land in survey number 16 for 2 acre 30 guntas is standing in the name of respondent herein by inheritance as per MR 16 of
That was
4 and 5.
pertaining to survey number 78 part 2.
ಅಲ್ಲಲ್ಲ,
Measuring
to show that I am the ಇದು
37 guntas. Sale deed dated 24/8/2012.
ನಂದು ಇದು ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಈ ಲ್ಯಾಂಡ್ ಸರ್ವೆ ನಂಬರ್ 78/2 measuring 37 guntas in respect of this transaction proceedings took place.
Yes.
And there is holding that I am already an agriculturist having produced land bearing survey number 16/4. The learned assistant commissioner drops the proceeding in April 2014.
Yes.
Now again, without issuing me notice, he initiated proceedings again in the year 2015 and passes an order that there is violation. However, the subsequent order also.
In respect of the same transaction.
Same land, my lord, 78, survey number 78/2 measuring 37 guntas.
7 guntas.
Sale deed is cancelled.
Sale deed dated
Sale deed dated 24/8/2012.
24/8/2012.
Page 42, page,
Yes.
in page 2 of the order, same sale. deed.
They want, the revenue officials want to create disputes.
Yes, he is right. How can there be a second proceeding? Berkeley. Learned AGA takes notice for all the respondents. Next paragraph. Learned counsel for the petitioner submits that earlier the Assistant Commissioner, Bangalore South Subdivision had conducted a proceedings in LRF bracket 83 bracket AS clause 3 of 2013-14 in respect of the sale transaction dated 24/8/2012, whereby the petitioner had purchased 37 guntas of land in survey number 78/2 of
Sakalavara village.
Sakalavara village, Jigini Hobli, Anekal Taluk. Full stop. The Assistant Commissioner was convinced that the petitioner had not violated the provisions contained in section 79A and 80 of the Karnataka Land Reforms Act. Full stop. Accordingly, the proceedings were dropped by the Assistant Commissioner by order dated 28th of April 2014 with a direction to the Special Tahsildar Anekal Taluk to take necessary action to mutate the name of the petitioner herein in the land records in terms of the sale deed dated 24/8/2012. Full stop. Learned counsel submits that when that being the position, the Assistant Commissioner once again initiated a proceedings in LRF 83/AJ clause 10 of 2015-16 in respect of the very same sale transaction, namely 24/8/2012 in respect of 37 guntas of land in survey number 78/2 of Sakalavara village. Full stop. The impugned order has been passed without notice to the petitioner on 7/1/2019. Full stop. Next paragraph. Moreover, it is submitted that consequent to the deletion of the provisions contained in section 79A and B from the statute book in terms of the Karnataka amendment so and so, all proceedings which were concluded prior to the
Initiation.
Amendment Act have been saved. Full stop. Next paragraph. There is sufficient force in the submission of the learned counsel for petitioner. Full stop. The Assistant Commissioner was not made aware of the fact that earlier proceedings were initiated against the petitioner in LRF number so and so 3 of 2013-14, and the same was dropped by order dated 28th of April 2014. Full stop. Therefore, there was no occasion for the Assistant Commissioner to have initiated second proceedings in respect of the same sale transaction. Full stop. Next paragraph. Consequently, the writ petition is allowed. the impugned order at annexure F dated 7/1/2019 in LRF number so and so 10 of 2015-16 is hereby quashed and set aside. Yes.
My lord, there is a entry in RTC in the name of government that may be directed to be reversed in my name.
When was it done?
Annexure E nalli.
Consequent to the impugned.
Yes, not consequent to impugned. order.
The revenue entries shall be reverted in the name of the petitioner consequent to
Annexure.
the earlier orders passed by the Assistant Commissioner.
Still number 18. Srikanth NV.
I appear for the petition, my lord. The petitions, my lord, challenging the order passed by the deputy commissioner, my lord, sir. At annexure A and annexure A2, my lord, sir, passed by the Tahsildar. Revision petition number 157 of 2019, my lord, thereby the revision petition was allowed and the order passed by the second respondent, my lord, the assistant commissioner was set aside. The fact of the
14
case,
of 2010-2011.
yes, my lord. Annexure A1,
MR 14.
Chikkanna bin Dodda Narayanappa.
lord, the facts of the case.
Salayappa bin Dodda Narayanappa. Gentiye.
Gentier, annexure A2, my lord. Lord, the facts of the case is that, my lord, so one Doddana, my lord, is the proposal of the family, my lord. He has having 3 children, my lord. One is, my lord, Doddanarayanappa, Chikkanaranappa, and Chikkanna, my lords. The petitioners herein, my lords, are the sons of, my lord, Doddanarayanappa. My lord, there was
Partitioned in the year 1940.
1940, my lord. Annexure B, my lord, the partition deed effected between the sons of, my lord, the Doddanna. After, my lords, annexure C, the sale deed, which was, my lord, the father of the petitioner herein, has purchased the property, my lord, one T. Ramaya.
Dodda Narayanappa purchased.
Yes, my lord. On
The
31,
above property andre?
my lord, on 31/5/1957, the father of the petitioner, my lord, has purchased the property from one T. Ramaya, my lord, through registered sale deed, my lord. That is produced, my lord, annexure C. Subsequently, my lords, the Doddanarayanappa, my lord, was died in the year 1989, my lord. His wife, my lord, Nagamma, has executed a will in favor of one Chikkanna, my lord. That is the first petitioner hearing. My lord, subsequently, what happened, my lord?
They didn't have children?
He has children. The petitioner are the children of Doddanarayanappa and Nagamma, my lord. My lord, sir, the revenue entries, which was entered in the name of, my lord, sir, the 4th respondent, that is the cousin brother of, my lord, the 3rd son. There are 3 children, my lord. That is Doddanarayanappa, Chikkanna, Chikkannaranappa, and Chikkanna. The Chikkanna is the 3rd son of, my lord, sir, Doddappa.
Sir, why are you talking of the other family members? You are saying he purchased the property.
Yes, my lord. He purchased
Then
the
it
property.
becomes self-acquired property.
Yes, my lord.
Why are you talking about the
What
partition
happened
then?
Subsequently, what happened, my lord? The petitioners here have filed a suit for declaration and
It seems
injunction.
that he has left behind a will.
Yes, my lord.
On the basis of the
On
will,
the basis of the
that
will, my lord.
person has sought for revenue entries.
Yes, my lord.
Yes.
The suit was filed by the, my lord, the petitioners, that is Chikkanna. The suit was partly decreed, my lord. The suit was filed for declaration and injunction. Injunction was granted. My lord, the declaration was declared. Subsequently, RA was filed before the district court, my lord. RA court, my lord, they confirmed the judgment of the OS case, my lord. Subsequently, my lords, on the basis of the will, my lords, which was executed by Nagamma, the 4th respondent, that is the Chikkanna, his name was entered, my lord, in the revenue records.
Yes.
Even though, my lords, the contention of the petition is that the survey number 16/1 was purchased by the father of the petitioner.
That has to be decided by the civil court. Your contentions have been negated.
Yes, my lord.
Then,
my lord, what happened, my
what
lord?
can the revenue authorities do? Revenue
But it
authorities
is
will
the
not be able
absolute,
to
absolute
do
property, my lords, of the Doddanarayanappa, my lord. But without
anything.
issuing
You have
any
supported
notice.
decree.
Yes, my lord. Injunction was granted, my lord, but declaration was negativated. And the district court also, my lord, they confirmed the judgment. Against that order, my lord, the petitioners have preferred RSA, my lord. That has been dismissed for non-prosecution. Now, my lords, without notice, my lord, without hearing. As per annexure A2, my lord, since, my lord, the petitioners are the absolute owners of the property, the
You cannot declare that yourself, sir.
Well, on the basis of annexure C, my lord.
Civil court has declined to give such a declaration.
Yes, my lord. But my lord, on the OS case, my lord, the judgment of the OS, may I read that the relevant paragraph, my lord? Page number 68, my lord, may kindly be see. 68, my lord, in page number 11, the judgment of the civil court. Page number 68, my lords.
Hmm.
67, my lord, issue number 3, my lords.
Hmm.
The defendant has taken up a contention that the suit property was purchased from joint family funds, and therefore Nagamma has no right to execute the will dated 13/7/1990.
Hmm.
Exhibit P1 clearly discloses that there has been a partition between the father of the plaintiff, his brothers, including the defendant. The suit schedule property was purchased in the year 1957, after a lapse of 17 years from the date of partition. Thus, the suit schedule property was not purchased from the joint family funds of the plaintiff grandfather's family. The father of the plaintiff had purchased the suit property. Subsequently, the suit property was included in the property of the father of the plaintiff, and it became the joint family property of the father's family.
Hmm.
In the said partition, in the partition between the plaintiff, his brothers and father, the suit schedule property was given to the share of his father for their maintenance. Subsequently, to the death of the father of the plaintiff, as the father of the plaintiff had not executed any will, Section 8 of the Hindu law applies. As the father of the plaintiff had died intestate, the plaintiff, his brothers, and his mother become the class 1 heirs are equally entitled to the suit schedule property. Thus, his mother Nagamma has no right to execute the will dated 13/7/1990.
Hmm.
Accordingly, this issue is partly negativated.
Hmm.
That the petitioners are claiming this property on the basis of the sale deed at Annexure C, my lord, which was purchased by the father of the petitioner from T. Ramaya, my lord. It is the absolute property of the father of the petitioners. On that basis, my lord, this survey number 16/1 has become the absolute property of the
The
petitioners, my
suit
lord.
is partly decreed.
Partly decreed, my lord.
The defendant is restrained.
Restrained from, my lord's, the relief of declaration that the plaintiff is the absolute owner of the property is dismissed. It is, however, held that the plaintiff along with brothers are the joint owner of the suitable property.
Ah.
The defendant is restrained from interfering with the plaintiff's peaceful possession.
Defendant is this Chikkana.
Yes, my lords. B.N. Chikkanna, my lords.
Ibru Chikkana alri.
My lords, one is, my lords,
Uncle.
B.N. Chikkanna, my lords, is the father of the son of Dodnaranappa. ಇಬ್ರ ಹೆಸರು ಚಿಕ್ಕಣ್ಣ ಅಂತಾನೆ ಇದೆ. Chikkanna is the son of late Doddanna.
Defendant is the person in whose favor will is left behind, is it?
No, my lord. The petitioner. B.N. Chikkanna.
Already idರಲ್ಲಿ ರೀ annexure E ಅಲ್ಲಿ page 58 ಅಲ್ಲಿ.
Yes, my lord.
Who is the plaintiff?
Plaintiff, my lord, is the B.N. Chikkanna.
ಅವ್ರ ಹೆಸರು
ಇಬ್ರು ಚಿಕ್ಕಣ್ಣ ಅಂತ ಗೊತ್ತ್ರಿ ನನ್ಗೆ.
My lord.
Who is the person in whose favor will has been left behind?
My lord, B.N. Chikkanna.
plaintiff.
B.N. Chikkanna.
B.N. Chikkanna is the plaintiff. He is the son of my lord Dodnaranappa. And this Chikkanna is, my lord, is the third son of Doddanna. My lord, Doddanna has 3 sons, my lords.
So it is however held that the plaintiff along with his brothers are joint owners of the
True schedule property. That was confirmed by the Honorable District Court also. And
now you are making submissions in whose favor?
My lord, on behalf of B.N. Chikkanna.
B.N. Chikkanna.
Yes, my lord. He preferred an appeal before the Assistant Commissioner, my lord. Page number 20, my lord, Annexure A1. The order is in favor of the petitioners.
You approach the Assistant Commissioner.
Yes, my lord. Assistant Commissioner favored the order in favor of the petitioner. Subsequently, my lord, the respondents has preferred a revision petition before the Deputy Commissioner. Deputy Commissioner dismissed the revision petition on the ground that, my lord, page number 19, my lord, is the relevant paragraph. Rejected the order of the Assistant Commissioner, my lord.
What is the reasoning?
My lord, page number 18, my lord, is the reasoning.
Yes.
Para number 7, my lords. I read that, my lord.
Yes.
ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ದಿನಾಂಕ 15/9/18 ನೀಡಿದ್ದು, ಅದರ ವಿರುದ್ಧ ಪ್ರಸ್ತುತ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿಯನ್ನು 6/9/2019 ಸಲ್ಲಿಸಲಾಗಿದೆ. ಸದರಿ ಆದೇಶದ ಮಾಹಿತಿಯು ತನಗೆ ಲಭ್ಯವಿರುವುದೆಂದು ಹಾಗೂ ಪ್ರಸ್ತುತ ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮ ಪರವಾಗಿ ಆದೇಶವಾಗಿರುವ ಅಂಶಗಳನ್ನು ಬಹಿರಂಗಗೊಳಿಸಿದ ಬಳಿಯವಷ್ಟೇ ತನಗೆ ಪ್ರಶ್ನಿತ ಆದೇಶದ ಮಾಹಿತಿ ಸಿಕ್ಕಿದ್ದು ಸದರಿ ಆದೇಶವನ್ನು ತಪ್ಪು ಹಾಗೂ ಕಾನೂನುಬಾಹಿರ ಅಂಶಗಳು ಜಾರಿಗೊಳಿಸಿರುವುದರಿಂದ ಅದರ ವಿರುದ್ಧ ತಾನು ಸಲ್ಲಿಸಿರುವ ಪುನರ್ಪರಿಶೀಲನಾ ಅರ್ಜಿಯನ್ನು ವಿಳಂಬವನ್ನು ಮನ್ನಿಸಿ ಪರಿಗಣಿಸಬೇಕೆಂದು ಪುನರ್ಪರಿಶೀಲನಾ ಅರ್ಜಿದಾರರು ಹೇಳಿಕೊಂಡಿರುತ್ತಾರೆ. ಮುಂದಿಟ್ಟಿರುವ ಈ ಕಾರಣಗಳು ನಂಬದೇ ಇರುವ ಸಕಾರಣಗಳಿಲ್ಲ. ಅಲ್ಲದೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ RSA 1772 of 2008 ಇನ್ನೂ ಅಂತಿಮ ತೀರ್ಮಾನಕ್ಕೆ ಬಾಕಿ ಇದೆ ಎಂಬ ಕಾರಣದಿಂದ ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ಜಾರಿಗೊಳಿಸಿರುವಂತಹ ಹಾಗೂ ಪುನರ್ಪರಿಶೀಲನಾ ಅರ್ಜಿದಾರರ ಪ್ರಕಾರ ಸದರಿ RSA ನಂಬರ್ so and so ಅಪೀಲನ್ನು 3/3/2009 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ತಿರಸ್ಕರಿಸುವುದರಿಂದ ವಿಳಂಬವನ್ನು ಮನ್ನಿಸಿ ಪುನರ್ಪರಿಶೀಲನಾ ಅರ್ಜಿಗಳನ್ನು ಗುಣಾವಗುಣಗಳ ಆಧಾರದಲ್ಲಿ ಪರಿಶೀಲನೆಗೆ ಅಂಗೀಕರಿಸುವುದು ಸಮಂಜಸವೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟು ಮೇಲಿನ 1ನೇ ವಿವರಣೆ ಸಕಾರಾತ್ಮಕವಾಗಿ ಉತ್ತರಿಸುತ್ತೇನೆ. ಪ್ರಸ್ತುತ ಪ್ರತಿವಾದಿಗಳ ಪ್ರಕಾರ ಅವರು ದಾಖಲಿಸಿದ OS ನಂಬರ್ 454/93 ದಾವಾದಲ್ಲಿ ವಿವಾದಿತ ಜಮೀನು ಲೇಟ್ ದೊಡ್ಡಣ್ಣನ ಎಲ್ಲಾ 3 ಮಕ್ಕಳ ಜಂಟಿ ಆಸ್ತಿ ಎಂದು ತೀರ್ಮಾನವಾಗಿದ್ದು ಅದನ್ನು RA 61/2006 ಮಾನ್ಯ ಹಿರಿಯ ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯ ಸ್ಥಿರೀಕರಿಸಿದೆ. ಸದರಿ ತೀರ್ಪಿನ ವಿರುದ್ಧ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಸ್ತುತ ಪ್ರತಿವಾದಿಗಳು ಸಲ್ಲಿಸಿದ್ದ RSA 1772 of 2008 ಮೇಲ್ಮನವಿಯನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 3/3/9 ತಿರಸ್ಕರಿಸಿದೆ ಎಂದು ಪುನರ್ಪರಿಶೀಲನಾ ಅರ್ಜಿದಾರರು ತಿಳಿಸಿ ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಪ್ರತಿ ಹಾಗೂ ಅಂತರ್ಜಾಲ ಮಾಹಿತಿ ಪ್ರತಿಯನ್ನು ಹಾಜರಿಸಿದ್ದಾರೆ. ಇವುಗಳನ್ನು
RSA is also disposed of.
It was dismissed for non-prosecution. It was dismissed for non-prosecution.
Ah.
Annexure, my lords. Annexure G, page number 11, my lords. Subsequent ಅಕ್ಷರಣ ಪತ್ರದಲ್ಲಿ ಸದರಿ ಅಪೀಲು ಇನ್ನೂ ತೀರ್ಮಾನಕ್ಕೆ ಬಾಕಿ ಇದೆ ಎಂದು.
Who is that other Chikkana?
Other Chikkana, my lord, is the third son of Doddanna, my lord. My lord, Doddanna has 3 sons, my lord.
Uncle.
One is, my lord, the Dodnaranappa, second son is Chikkanaranappa, and third son is Chikkanna. The petitioners herein are the sons of my lord Dodnaranappa, and Chikkanna is the uncle of the petitioners, my lords.
Where is the genealogical tree? No genealogical tree.
I have not produced one. But relationship is not been disputed, my lords.
So the mistake that he has committed is, he found in page number 19.
Yes, sir.
The last 5 lines. ಹೀಗೆ
OS ನಂಬರ್ 454/93 RA 61/2006 ಮತ್ತು RSA 1772/2008 ತೀರ್ಪುಗಳಂತೆ ವಿವಾದಿತ ಜಮೀನು ಎಲ್ಲಾ 3 ಸಹೋದರರ ಜಂಟಿ ಆಸ್ತಿಯಾಗಿದ್ದು
ಇಲ್ಲಿ ಎಲ್ಲಾ 3 ಸಹೋದರರ ಜಂಟಿ ಆಸ್ತಿಯಾಗಿದ್ದನ್ನ he has misunderstood that the 3 brothers.
Yes, ma'am.
ಅದು ಪಾಣಿಯಲ್ಲಿ ಬಂದಿದೆ ಅವರು.
ಪಾಣಿಯಲ್ಲಿ
93 page 93 ಅಲ್ಲಿ 3 ಜನ ಅಣ್ಣ ತಮ್ಮಂದಿರ ಹೆಸರು ಇದೆ. ಚಿಕ್ಕಣ್ಣ ಬಿನ್ ದೊಡ್ಡನಾರಾಯಣಪ್ಪ.
I have produced the RTC, my lord, sir.
The finding is clearly in favor of Sri Doddanarayanappa. That he had not purchased the property out of the
joint family
funds.
Yes, my lord. It is his separate property.
Wrongly been understood. Learned AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 7. Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that although the initial claim of Sri B.N. Chikkanna, the husband of petitioner number 1 and father of the other petitioners, was that he acquired absolute title in respect of the land in question, that is
Survey number 16/1 measuring 2.03 acres.
land measuring
16/1
land measuring
measuring 2.03 acres, my lords.
in survey number
16/1.
of Byadrahalli village, Kundana Hubli, Devanhalli Taluk, Bangalore rural district was not accepted by the civil court in OS number
454 of 1993. my lord.
Come on, nevertheless. It was clear from the judgment passed by the additional civil judge, bracket junior division, Devanhalli, that Sri B.N. Chikkanna, along with his brothers, are joint owners of the property in question. Full stop. This aspect has been wrongly, this aspect has been misunderstood by the deputy commissioner to say that the defendant, Sri Chikkanna, son of Daddanna, was also entitled for a share in the property. Full stop. Learned Counsel submits that it is Sri B.N. Chikkanna along with his brothers, who are all sons of Sri Doddanarayanappa, who are entitled for the land in question.
Yes.
And not Sri Chikkanna, son of Doddanna, who was the defendant before the trial court in OS number 454 of 1993, who had any share in the land in question. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at Annexure A passed by the Deputy Commissioner in RP number 157 of 2019 till the next date of hearing.
Please.
Number 19, H.V. Praveen Gowda.
And for petitioner in this matter. Challenging the order passed in Annexure A. My lord, your petitioner had acquired the land by virtue of partition deed based on the rectification deed and sought for the Issa Podi. During the course of Issa Podi, she came to the knowledge that there is a shortage of 5 guntas of land. Then she gave a requisition to the respondent number 3 here. He did not take any action against. Then she sought an appeal.
Is a dispute between the family members
Extent.
No, my lord.
regarding extent.
Yes,
Is it a dispute between the family members?
Yes.
yes, ma'am.
Huh?
Yes.
Yes.
Then the petitioner sought for the Podi fixed adverse file before the respondent number 2.
Registered rectified partition deed.
Partition deed.
Huh?
Yes, my lord.
Where is that?
Annexure C.
Page 29.
Partition took place between Kenchegoda,
Giri.
his wife Kempamma, then children Girigowda, Venkatesha, Govindegowda, Onnegowda.
Yes, my lord.
Jayalakshmi, this petitioner.
Jayalakshmi.
Jayalakshmi Obridare, party number 5. She is the petitioner.
She is a petitioner, ma'am.
Where are you in the partition deed? Annexure B is the partition deed.
Yes, ma'am.
Is between
Fifth place. Srimati
ಕೆಂಚೇಗೌಡ, ಕೆಂಪಮ್ಮ, ಗಿರಿಗೌಡ, ವೆಂಕಟೇಶ, ಗೋವಿಂದೇಗೌಡ, and ಹೊನ್ನೇಗೌಡ.
Venkatesha-
She's Venkatesha's wife.
wife Jayalakshmi.
Venkatesh was alive at that time, first partition.
ಆಯ್ತು. Then where is the rectification deed?
ಅದು more than rectification, it says reconsideration.
Huh?
ಮರು ಹೊಂದಾಣಿಕೆ ಅಂತ ಹೇಳ್ತಾರೆ. They, in the petition.
Anyway, it's a registered document.
Yes, yes.
Yes, ma'am.
It's a registered document. Once again, between ಕೆಂಚೇಗೌಡ,
ಗಿರಿಗೌಡ,
ಕೆಂಪಮ್ಮ, ಗಿರಿಗೌಡ, ಗೋವಿಂದೇಗೌಡ, ಹೊನ್ನೇಗೌಡ and
in place Venkatesh.
ಏನಾಗಿದೆ ಇದರಲ್ಲಿ?
ಇದ್ರಲ್ಲಿ 5 ಗುಂಟಾ ಶಾರ್ಟ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಕ್ವಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Which is the property? Property in question?
48/2 survey number.
48/2.
Yes, ma'am.
Page number ಹೇಳಿ.
Page number 44 ನಲ್ಲಿ
44.
ಹೌದು 5 ಶ್ರೀಮತಿ ಜಯಲಕ್ಷ್ಮಮ್ಮ ಕೋಮ್ ಲೇಟ್ ಶ್ರೀ ವೆಂಕಟೇಶ್ ಅವರಿಗೆ ಸೇರುವ ಸ್ವತ್ತಿನ ವಿವರಗಳು. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಹುಳಿ ಭೋಗಾದಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ಸಂಖ್ಯೆ 48/13 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 32 ಗುಂಟೆ ಪೈಕಿ 2 ಎಕರೆ 2.25 ಗುಂಟೆ.
Is this the property?
ಜಮೀನಿಗೆ. Yes, ma'am.
48/13.
8/13.
48/13.
ಇಲ್ಲ 48/9.
48/9. Item number 2. Page number 44.
Yes, ma'am. 7 ಗುಂಟೆ.
Which is the property in dispute? 48/9 or 48/13?
48/9.
48/9. Measuring 7 guntas.
7 ಗುಂಟೆ.
You have got only 7 guntas.
Yes, ma'am.
Yes.
She filed an appeal before the JDLR. The other respondents, respondent 5 to 8, JDLR issue notice to appear before the,
Yes.
issue notice to the respondent number
Yes.
5 to 8 to appear before the court.
Hmm.
The respondent 5 to 8 already JD their land to the one Mr. K. Srinivas.
Yes.
And also given the GPA
Yes.
to him. He appeared with these respondents before the respondent number 2.
Yes.
Here respondent number one K. Srinivas filed an appeal to the appeal in the National Commission, my lord, Delhi. National Commission for Scheduled Case, Delhi.
Bidi, it's of no consequence. Leave that one. It has not,
Stay.
it has no power.
Power ಇಲ್ಲ ಬಟ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಗೆ ಸ್ಟೇ ಮಾಡೋದಕ್ಕೆ.
ಏನ್ ಸ್ಟೇ ಮಾಡೋದಕ್ಕೆ?
My lord,
Has to be decided by the revenue authorities now.
Yes, my lord.
You have gone before the joint director.
Yes, my lord.
What is his opinion?
In page 15.
Yes.
ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಷ್ಟ್ರೀಯ ಪರಿಶಿಷ್ಟ ಜಾತಿಗಳ ಆಯೋಗಕ್ಕೆ ಎದುರುದಾರರ ಪರ.
Where are you reading?
Page 15.
15. What is this?
It's a typed copy, my lord. In page 10.
Annexure D is your petition, appeal. Appeal memo.
Appeal. But in annexure A, it's an order passed by.
Yes.
ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಷ್ಟ್ರೀಯ ಪರಿಶಿಷ್ಟ ಜಾತಿಗಳ ಆಯೋಗಕ್ಕೆ ಎದುರುದಾರರ ಪರ
ಅಲ್ಲ ಬೇಕಿಲ್ಲಮ್ಮ, you leave all that. You come to the relevant facts. Your contention was you got 7 guntas
7 guntas.
in the rectified partition deed.
Yes, ma'am.
What is your contention?
ಇಲ್ಲಿ 5 ಗುಂಟಾಸ್ ಕಡಿಮೆ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಕ್ಕೆ ಅದು ಸ್ಟೇ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್ ಅದು.
There is an interim order of stay. Page 19 is the reasoning that is there.
48/16
ಪಿತ್ರಾಜಿತ್ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ.
29 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ದಾಖಲೆ ಇರುತ್ತದೆ. ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 48/16 ಗಡಿಯೊಳಗಡೆ ವಿಸ್ತೀರ್ಣ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿದಾಗ 24 ಗುಂಟೆ ಮಾತ್ರ ಇರುತ್ತದೆ. So it is in respect of 48/16.
16.
Yes, ma'am.
48/16.
Yes.
Now please come to the rectification deed. (48/16). ಎಲ್ಲಮ್ಮ 48/16 ಅಲ್ಲಿ ಏನು ಇಲ್ವೇ ಇಲ್ಲ ನಿಮ್ಗೆ?
ಇಲ್ಲ. Actually,
nothing has been
48/13
given in 48/16.
48/13 and 7.
48/13 ಅಲ್ಲಿ 2.25 ಗುಂಟೆನೆ ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ 48/16 ಅಲ್ಲಿ ನಿಮ್ಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ 48/9 ಅಲ್ಲೇ ಇರ್ಬೇಕು. ಯಾಕಂದ್ರೆ 48/13 ಅಲ್ಲಿ ಬರೀ 2.25 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದಾರೆ. 5 ಗುಂಟೆ ಶಾರ್ಟ್ ಇದೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. 48/9 ಅಲ್ಲೇ or 48/4 ಅಲ್ಲಿ 20. Actually there is a variation in the first partition and second partition. ಅಲ್ಲಿ ಕೊಟ್ಟರು ವೆಂಕಟೇಶ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟರು ಪ್ರಾಪರ್ಟಿನೇ ಬೇರೆ. ಅಲ್ಲಿ ಫಸ್ಟ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 48/2 ನಲ್ಲಿ ಮಾತ್ರ ಕೊಟ್ಟಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. There would have been a durusti immediately after the first partition. Based on that, they have executed one more rectification.
The proceedings have been stayed now.
Yes, my lord.
In terms of the orders passed by the National Commission.
Yes, my lord.
You are agreed of that one?
Challenging that order.
You want the proceedings to go on?
ಅದು
The
measure ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ
issue
ಸ್ಟಾಪ್
order
ಆಗಿದೆ.
annexure A
Yes, my lord.
passed by the joint director is that the proceedings are now stayed in view of the orders passed by the National Commission.
Yes, my lord.
You are agreed of that order?
No, I'm challenging that order. to
Adhe, you are
continue.
agreed of that order?
Yes, my lord.
You want the proceedings to go on?
Yes, my lord. Yes.
ಇಲ್ಲ caution ಕೇಳಿದ್ದಾರೆ.
ಯಾವ್ದನ್ನ?
The prayer
Stay
Watch the
Annexure
issue
A.
order at annexure A. Adhe, that is nothing but an order of stay ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
And AGA takes notice for response number 1 to 3. issue notice to respondents number 5 to 8. Notice to respond number 4 is not issued for the time being. Full stop. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Who went before the National Commission?
K. Srinivas,
A. Srinivas.
GPA holder of R 5 to 8.
You have not produced a copy of that order?
No, it's not. Produced.
No, my lord.
Burley, let us see.
Number 20, Sridhar Ji.
Petitioner in this case. Lecture R is the impugned order passed by the Tahsildar. This order has been challenged before this honorable court in another writ petition WP 18,975 of 22. This honorable court has granted interim stay of the proceedings. Again, on this order, my lords, this order arises of proceedings under section 142 of the Land Revenue Code. What has happened, my lords, R8, at the instance of R8, survey was initiated by the R3 to 5, my lords. Subsequently, ADLR orders, my lords, that the Hadbast and Hissa Tipni has to be changed because there was no tally of the measurements, which the Tahsildar.
Earlier also you were before this court.
No, my lords, this is the first time.
Pending is.
First time, my lords.
Huh?
Pending. Another writ petition is pending.
Yavudu?
Annexure T is the.
Annexure D.
T, my lords.
Page number?
Page number. 144, my lords.
This has to be tacked on along with that.
Please, my lords.
Huh?
Stay, we have sought for stay and dispensation of sketch.
List this matter along with WP number 18975 of 2022. Comma, immediately after summer vacations.
Not stay.
Other lag is a lagle.
Maybe
An order has been passed in the writ petition already. You are saying it is in respect of the same order.
Same order, my lords. Petitioner is different. That is it.
So what? It is stayed already.
This is tagged along with it.
Yes.
21,
Dispensation.
Devendra N.
Sort.
At Bandmele,
Please.
then we will pass such an order after noticing who is the learned counsel who is appearing there.
Please.
Yes.
21, Devendra N.
Challenging the Assistant Commissioner 79A, Your Honor.
79A.
Order dated 28/8/2018. I am not challenged that
79A.
appeal
79.
for the
Serial number?
21.
20 ಆಯ್ತಾ ಇವಾಗ 79 AP.
ಹೌದು sir.
ಹೌದು.
ಹಾ
ಈಗ ನಾನೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ, ನಾನೇ ಪಾರ್ಟಿ ಇದ್ದೀನಿ.
ಏನಪ್ಪ?
Same party, same.
When is the order passed?
Order is
18,
passed on
28/8/2018.
18. All right.
ಇದರಲ್ಲಿ ಕೈಡ್ಲಿ ಬೆರುವುದು ಅನೆಕ್ಷರ್ ಎ Your Honor. ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟುಗೋಲು ಅಂತ ಹಾಕೊಂಡಿದೆ.
Disposed of, sir. It is allowed. Please go before the Assistant Commissioner on 31st of May.
ಅಲ್ಲ June first week ಅಲ್ಲಿ kind.
Huh?
June first week.
You want it in June first week?
Please
On 4th of June.
publish.
All right.
Number 22, Adi Naranappa.
Petitioner is challenging the dismissal of the appeal filed by the petitioner. The petitioner is the absolute owner of 2 acres of land in survey number 93 by virtue of the family settlement, which is produced at annexure C.
136 proceedings, sir.
3 available order.
136 proceedings, sir.
Yes, sir.
You'll have to go before the Deputy Commissioner.
Deputy Commissioner.
If Assistant Commissioner has passed an order under section 136(2),
Yes, sir.
you will have to go before the Deputy Commissioner under 136(3). Please go before the Deputy Commissioner. Berkeley. Learned AGA takes notice for response number 1 and 2. Notice to the other respondents is not necessary for the following reasons. Next para. A preliminary objection is raised by the learned AGA that the impugned order dated 14/12/2023 has been passed by the Assistant Commissioner, Kolar Subdivision under section 136(2) of the Karnataka Land Revenue Act, 1964. Full stop. A provision for filing a revision petition before the Deputy Commissioner under section 136(3) has been enabled in the statute. Full stop. In that view of the matter, the learned AGA submits that since an alternative efficacious remedy is available for the petitioner, the writ petition should be dismissed. Full stop. Next para. Upholding the submissions of the learned AGA, the writ petition stands dismissed while reserving liberty to the petitioner to approach the Deputy Commissioner, invoking section 136(3) of the Act. Ordered accordingly.
Number 23, Regularization VS.
132 proceedings. See, the order of the revenue inspector has been challenged before the assistant commissioner. Assistant commissioner holds that it is a civil in nature. Already the suit for partition is pending. Therefore, you go before the civil court, against which the 136(3) revision was filed before the DC. DC issues an endorsement as per annexure C, page number 15, without even looking into the papers, without even issuing notice to the other side. Therefore, I am before this honorable court. Endorsement issue ಮಾಡಿ ಅವರು ಇವರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮಾಡಿರೋದು ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು.
The same type of matter you had earlier appeared.
No. That is a different footing. That is there was a civil suit, injunction suit was pending. This is a different matter. In this matter, though the 136(3) application was filed, that has not been considered at all. The simple endorsement was issued. And there
he will do the same thing.
He will write immediately after death of my father, so many other heirs are there. In one heir name, this Pauti Kata was changed. Joint ag barbekagittu. Joint ag madilla. Now he is going to create charges also. And he may even sell also on the basis of this mutation entry in his alone.
Why have you not gone before the civil court?
Civil court, the matter was pending. Partition suit is pending.
You could have filed an application directing him not to alienate the property.
Adu not to alienate allagatte. Idun balaskondu innen martane anta gottilla namage. Because this has to go now. This is an illegal order passed by the revenue inspector. Only in one person's name. On jentiagi anta ellar hesarigu madidre tondre illa heirs ge. Without even issuing notice to the petitioner. No notice was issued. Annexure A is under challenge. And annexure B.
Set it aside, but you'll have to go once again you'll have to go before the deputy commissioner.
Alla, all hodre ee order set aside agi ellar hesarnalli bandre namage ಏನು ತೊಂದರೆ ಇಲ್ಲ till the disposal of this suit.
This court is not going to decide that.
Therefore
he has to decide.
Yes, the DC has to decide it now. DC has to decide it. He has not decided anything. He has issued only an endorsement. He has not even issued notice to the other side.
Annexure F is the appeal memo. Annexure F for the deputy commissioner. ಅದು 50 ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು 133 ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು. That appeal was filed in section 51A.
50
ಹೌದು 50 ಅಲ್ಲಿ 136(3) ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
He issues an endorsement. Even without even looking into the.
He should have said that appeal should have been filed at 136(3) and issued notices. However, the matter can be relegated back and.
No, that is because appeal was filed earlier under section 49.
49. Whatever may be the thing, my lord, this type of endorsement he cannot issue.
Yes. ಅಲ್ಲ ಬಟ್ ಅದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ 136 ಅಂತ ಹೇಳ್ತಾರೆ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ 136 ಅಂತ ಹೇಳ್ತಾರೆ. Even though the appeal is filed.
Maybe a wrong quoting the provision.
Provision wrong quoting ಆಗಿದೆ ಅಷ್ಟೇ. So since the order is under 136, it should have been appealed under 136 subclause 2 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. 3 ಅಲ್ಲಿ appeal ಆಗಬೇಕು.
Where is the order of the Assistant Commissioner?
Page 10.
Assistant
Annexure
page
B.
10.
Annexure B. ಕರ್ನಾಟಕ ಭೂ
Page 10.
ಕಂದಾಯ ಕಾಲಂ 136 ಅಂತ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ.
ಇಲ್ಲಿ ಸಿಂಪಲ್ ಆಗಿ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಡ್ತಾರೆ. Page number 15, annexure C. He cannot do that.
He has to pass a speaking order.
That is wrong. Page number 13, the order of the Assistant Commissioner, para 2 may be kindly seen. ಉಳಿದೆಲ್ಲ ಲೀಗಲ್ ಹೆಸರನ್ನು ಬಿಟ್ಬಿಟ್ಟು ಒಬ್ಬರ ಹೆಸರಿಗೆ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲ, your contention is different. Your contention as per the Assistant Commissioner is not that you are also entitled for a share. You are saying they don't have any rights. They don't have any rights. ಅದೇ ಅಲ್ಲ, ನಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಹೇಳಿದೀವಿ ನಾವು 21 ಜನ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹೇಳ್ತೀವಿ ನಾವು ಒಂದನೇ ಎದುರುದಾರ ಹಾಜರುಪಡಿಸುವ. Let it be considered by the Deputy Commissioner. Deputy Commissioner has to consider it. Learned AGA.
Limitation making.
Huh?
Appeal revision is filed, limitation may be.
Earlier matter. ಅಲ್ಲೇನ್ ಪರವಾಗಿಲ್ಲ ರೀ, ಇವಾಗ ರೀಸೆಂಟ್ ಆಗಿ ಆಗಿರೋ ಆರ್ಡರ್ ಅದು, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. Learned AGA takes notice for response number 1 to 3. Notice to 1 to 3 and 5. Notice to respond number 4 is not necessary for the following reasons. Next para. Learned counsel for the petitioner submits that aggrieved by the order passed by the Assistant Commissioner, Kolar subdivision in RA 140 of 2023, dated 27/2023, the petitioner herein filed a revision petition before the Deputy Commissioner in RP number 85 of 2023, challenging the orders passed by the Assistant Commissioner. Full stop. However, the Deputy Commissioner has issued the impugned endorsement dated 29/8/2023 at annexure C, dismissing the petition without even issuing notice to the respondents and hearing the parties. Full stop. The Deputy Commissioner has opined that since the Assistant Commissioner is of the opinion that the matter is of a civil nature with disputed questions of title, the matter has to be decided by a civil court. Full stop. Learned counsel submits that the Deputy Commissioner could not have disposed of the petition by issuing an endorsement. Full stop. Next para. There is substance in the submission of the learned counsel for the petitioner. Full stop. The Deputy Commissioner is required to have issued notice to the respondents in the revision petition filed by the petitioner. Full stop. After hearing the parties, the Deputy Commissioner is required to pass orders in accordance with law and not by issuing such an endorsement. Full stop. Next para. Consequently, the writ petition is partly allowed. Full stop. The impugned endorsement dated 29/8/2023 issued by the Deputy Commissioner, Kolar District, is hereby quashed and set aside. Full stop. The matter stands remanded back to the Deputy Commissioner to consider the revision petition filed by the petitioner in RP number 85 of 2023, issue notice to the respondents therein, and thereafter consider and dispose of the matter in accordance with law.
In the meanwhile, my lord, the annexure A may be stayed till such time. Annexure A, the change of mutation entry may be stayed, my lord. See, ultimately, all the persons will be benefited. once the- that is-
By this time, you should have gone to the civil court anyway. Yes.
Before Sharath Gowda.
My lord, time may be fixed, my lord, by the deputy commissioner. Otherwise, within 6 months.
ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. See, you should go to the civil court only. Ultimately, it cannot be resolved by the revenue authorities.
For that, the
What is the-
suit for partition is pending.
ಅಲ್ಲಿ
Ultimate ಆಗತ್ತೆ.
you should file an application seeking a direction that he shall not alienate the property during the pendency of the suit. ಮುಗೀತಲ್ಲ ಅಲ್ಲಿಗೆ. ಯಾರ ಹೆಸರಲ್ಲಿ ಇದ್ರೆ ಏನಂತೆ?
The problem is, my lord, he may create charges
ಅದೇ.
and all those things, sir. That is
Because
the reason.
he will do all that, you will have to file necessary application before the civil court.
It is there.
Yes.
Time frame may be, my lord, at least for deputy commissioner to dispose of.
ಇನ್ನು
the matter.
ನೋಟಿಸ್
Otherwise,
ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅವರು.
24 Sharath
ಅವ್ರು
Gowda.
ಮಾಡೋದೇ ಇಲ್ಲ ಅವರು.
ಅದೇ, see, that is why I am saying, you take necessary orders at the hands of the civil court. ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. You are already before the civil court. Ultimately, it has to be decided by.
Mutation entry,
So
illegal
in the interregnum, to protect your interest, you should have filed necessary application and secured directions. That you are not doing.
ಅಲ್ಲ ಅಲ್ಲಿ ಮಾಡುವಂತದ್ದು ಒಂದು ಅವ್ರು
ಇವ್ರು ಮಾಡಕ್
ಕೇಳಿದ್ರೆ ಇಲ್ಲಿ
ಬರೋದಿಲ್ಲ.
ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಕೇಳಿದ್ರೆ ನೀವು ರೆವೆನ್ಯೂ ಮ್ಯಾಟರ್ ಚೇಂಜ್ ಆಫ್ ಎಂಟ್ರೀಸ್ therefore we don't entertain.
ಅದಕ್ಕೆ you are not seeking for any orders at the hands of the civil court regarding the revenue entries. You are only seeking a direction against the party. That you have failed to do. Yes.
Number 24.
Lords, for issuance of Sagwali chit, Lords, similar to yesterday's matter, Lords, the petitioner is owner of 1 acre 20 guntas of land in survey number 488.
CT
ಯಾವ್ದು ನೆನ್ನೆದು repetition?
WP
Lords,
34
ನೆನ್ನೆದ್ರಲ್ಲಿ ಅವರು ಫೀಸ್ ಕಟ್ಟಿರ್ಲಿಲ್ಲ, ಇದರಲ್ಲಿ they have paid, my lords, the amount.
ನಿಮ್ಮದು ಕಟ್ಟಿದ್ದಾರೆ.
WP ಕಟ್ಟಿದ್ದಾರೆ.
ಹಾ?
ಕಟ್ಟಿದ್ದಾರೆ.
ಕಟ್ಟಿದ್ದಾರೆ.
WP
Yes.
number 342 of 23.
Yes, disposed of.
Great.
ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕಿಮ್ಮತ್ ಕಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಕಟ್ಟಿದ್ದಾರೆ.
ಚೆಕ್ ಮಾಡಿ.
Masdor matter.
ಕಟ್ಟಿದ್ದಾರೆ.
Serial number 7, Mahesh Arupin.
Petitioner. Petitioner was the landlord question was a Patel Ungli landlord. It was re-granted in favor of father of first petitioner, the year 71. Thereafter, Lord, one Kadar Sahab Lord was in possession of 2 acres as a tenant Lord. Occupancy rights was granted in the year 81.
In his favor.
In his favor. I have no objection for that. Then, Lord, this third respondent herein, Lord, filed an application seeking occupancy rights under the provisions of the Religious and Charitable Inams Abolition Act, Lord. That is application I have produced, Lord, as per Annexure D. That is after the time limit under the Act, Lord. On this, Lord, inquiry was held, an order was passed granting occupancy rights to a certain extent. That order was Annexure E is the copy of that order. That was challenged before this honorable court, both by the tenant as well as the landlord. The Annexure F and Annexure G are the orders passed, Lord, remanding the matter to the land tribunal. After remand, Lord, a fresh statement was recorded. No documents were marked. Then, Lord, you will ask me kindly turn to page 79. The order sheet of the land tribunal. 28/10/2022, bottom, page 79. Appellant advocate. Then for submission of written arguments, 18/11/22, matter was urgent to 18/11/22. Thereafter, my lord, the sitting was not there, matter was not called at all. Then, my lord, according to our information, my lord, this assistant commissioner who was sitting as a presiding officer, he was transferred to some other place. Before going, my lord, this order is passed. Next page, will ask me kindly, my lord. It seems not as per the order sheet, 10/2/23 matter was called, you are present, which was factually incorrect. Then, my lord, next date ಅಲ್ಲಿ ಇದ್ದಿದ್ದನ್ನ ಹೊಡೆದಾಕಿ ತಿದ್ದಿದ್ದಾರೆ. ಯಾವ ಡೇಟು ಅಂತಿಲ್ಲ. ಇಂಕ್ ಪೇಜ್ 18, my lord.
You are challenging this order at annexure L.
Yes, my lord. This order is passed without hearing us, my lord. ಆ 15th ಅಲ್ಲಿ ತಿದ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ 15th ಮ್ಯಾಟ್ರ್ ಕರೆದಿದ್ದೀವಿ.
ಫಾರ್ಮ್ ನಂಬರ್ 10 ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
10 ಕೊಟ್ಟಾಗೆ ನಮಗೆ ಗೊತ್ತಾಗಿದ್ದು. ಫಾರ್ಮ್ 10 ಅವರು ತಗೊಂಡಿರೋದು 2024 ಫೆಬ್ರವರಿಯಲ್ಲಿ. ಅದನ್ನ ತಗೊಂಡು ಪೊಲೀಸ್ ಹೆಲ್ಪ್ಗೆ ಬಂದ್ರು. ಬರ್ಕೊಳ್ಳಿ.
Learned AGA takes notice for response number 1, 2 and 4. Issue notice to respond number 3. Learned counsel for petitioners is directed to serve a copy of the writ petition along with the annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the earlier order passed by the land tribunal was questioned by the petitioners as well as the third respondent in 2 writ petitions before this court, namely WP number 25100 of 1993 and 40137 of 1993. Full stop. Common orders were passed by this court.
Separate orders were passed. Separate orders was passed. That was a mistake.
The two writ petitions were disposed of by order dated 31/5/1988, setting aside the order of the land tribunal and remanding the matter back to the land tribunal for fresh consideration. Full stop. Learned counsel submits, while taking this court through the order sheet maintained by the land tribunal at annexure K,
Page 79.
that the impugned order has been passed without hearing the parties. Full stop. The petitioner was not even aware of the fact that such an order was passed on 15/3/2023.
Yes.
Full stop. The petitioner came to know of the impugned order only when the third respondent sought to interfere with the possession of the property on the strength of form number 10 at annexure M said to have been issued in his favor consequent to the impugned orders. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at annexure L dated 15/3/2023 till the next date of hearing.
M also, form 10 also has to be.
ಅದು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Orders, serial number 25. Uramo DA.
Finally, a week's time is granted to take fresh steps for service of notice on response number 3 to 6.
Serial number 26. Hanmantappa RV.
10 days time, my lord. You should press notice responding number 5, my lord.
Same order at the request of learned counsel for petitioning.
Serial number 27. Manjunath KV.
My lord, this is that matter wherein
Is this
Dot.
matter of the service of notice on respond number 3?
my lord, this is that matter wherein the dot has been inserted, my lord, in the survey number.
ಹೌದ್ರಿ, ಅವಾಗ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕಲ್ಲ.
Either.
Special AC has come, special.
Last time, Rashid directed to AZ, Assistant Commissioner.
There was a stay that was, we initiated a proceedings before by the Assistant Commissioner, issuing notice to all the parties, my lord. Why this honorable court stayed the proceedings, my lord? On 11/3/2024, my lord, my lordship vacated the stay, directed us to initiate a proceedings, my lord. We have issued the notice, my lord. Meanwhile, my lord, the AC has been appointed as AOR, my lord. My lord, immediately after election, within 6 weeks, we'll complete the proceedings, my lord, within 1 or 2 sittings. Special Tahsildar is present before this honorable court. ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ಅವ್ರಿಗೆ ಅವ್ರಿಗೆ 11/3 ದಿ ಆರ್ಡರ್ ವಾಸ್ ವೆಕೇಟೆಡ್, ಮೈ ಲಾರ್ಡ್. ದೆನ್ ಮಹಮ್ಮದ್ ಹುಸೇನ್ ಸಾಬ್ ಅನ್ನೋರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಮಾಡಿ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಅವ್ರು ಇಲ್ಲ. ಸೊ ಅವ್ರಿಗೆ ಪರ್ಸನಲ್ ಆಗಿ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ಅನ್ ಎಫರ್ಟ್, ಮೈ ಲಾರ್ಡ್. 16/3 ಕೋಡ್ ಆಫ್ ಕಾಂಡಕ್ಟ್ ಬಂತು. ದೆನ್ ಹಿ ವಾಸ್ ಅಪಾಯಿಂಟೆಡ್ ಆಸ್ AOR, ಮೈ ಲಾರ್ಡ್. ಮೈ ಲಾರ್ಡ್, ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ಎಲೆಕ್ಷನ್, ಮೈ ಲಾರ್ಡ್, 26 ಆಗಿದ ತಕ್ಷಣ ವಿತಿನ್ 6 weeks ವಿಲ್ ಟ್ರೈ ಟು ಕನ್ಕ್ಲೂಡ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ಮೈ ಲಾರ್ಡ್. On 11/3/2024, the following order was passed. Extract ಮಾಡ್ಕೊಂಡು fourth. Next para. Hereafter, learned AGA submits that the special Tahsildar is present before this court with instructions from the Assistant Commissioner. It is submitted that notices have been issued by the Assistant Commissioner consequent to the proceedings initiated at the hands of the Special Tahsildar. Yes, sir. Nevertheless, having regard to the Lok Sabha elections 2024 and the Model Code of Conduct, the Assistant Commissioner was not available for the proceedings. Full stop. However, learned AGA submits that immediately after the elections are concluded, the Assistant Commissioner will proceed to hear both the parties and thereafter pass necessary orders in accordance with law. Full stop. Next para. Learned Counsel for the petitioner submits that the petitioner will be satisfied if such action is taken by the Assistant Commissioner. Full stop. Next para. Consequently, the writ petition stands disposed of.
My lord,
Recording the submission of the learned AGA.
my lord, if I may, let the petition be pending, my lord. He has said, ಅಲ್ಲ 6 weeks time ಕೇಳಿದಾರೆ, ಅವ್ರು ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. Kindly, kindly understand.
We will fix a date.
Yes, ma'am.
We will fix a time here.
Yes, ma'am.
Disposed of with a specific direction to the Assistant Commissioner. Yava? Assistant Commissioner, my lord. Bangalore South, my lord.
South, Bangalore South, ma'am.
Bangalore South Subdivision. To hear the parties and thereafter
pass necessary orders as expeditiously as possible and at any rate within a period of 6 weeks from the date of receipt of a copy of this order. Hinಗೇನಾದ್ರು ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ask for extension. Yes.
Much.
28. Vikyat B.
Service for point number 5 and that is. The putting up
This matter of service of notice on respondent.
immediately after vacation. Immediately after vacation.
Allah, it has to be listed after service only. Date and ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. Yes.
Number 29. Yes.
I have served the copy on the other side, your lordship, not the same. And I also informed him no also.
Petition copy ಬಂದಿದ್ಯಾ?
Yes, my lord, I got it.
Learned AGA submits that he has received copy of the petition. Next para, learned counsel Sri H.C. Sivaram submits that he has served copy of area number 2 of 2024.
Yes.
On learned counsel for the petitioner.
Petitioner as well as.
The learned AGA.
Already served. While filing itself, I served him.
Full stop. However, there is no representation for the petitioner.
Yes, sir.
Full stop. List this matter immediately after summer vacation.
Any date may be fixed. Because there are two suits
Not
pending,
date
your lordship.
ಮಾಡಕ್ ಬರಲ್ಲ.
They have obtained an interim order, they are waiting before this court.
ಬರುತ್ತೆ.
Chandrappa V.
Steps.
This is RA.
Lords, I filed an application for vacating the interim order, Lords. Lords, I have sent the copy by, Lords, by mail. Lords, the issue is, my Lords, on the basis that, my Lords, revenue entries, my Lords, were changed now. My Lord, they have come before this honorable court. My Lord, the issue, my Lords, in fact, was settled in 2012 itself. They, by the order of the deputy commissioner. That order is not challenged. My Lords, only they cite, my Lord, the proceedings which was taken in 2019-20. And my Lords have, my Lords, obtained the interim order at the hands of this honorable court. Annexure R2, my Lords, have produced along with the application.
One ನಿಮಿಷ. Yes.
Lord, what happens, my Lords, is by the, my Lords, the revenue entry, my Lord, which has been affected, my Lords.
Yes.
What happened, my Lords, earlier, my Lords, it was affected in their favor, which was challenged, my Lords, the Karnataka Appellate Tribunal, my Lords, remanded the matter.
Who are you?
My Lords, I am R7, my Lords, respondent number 7. I am holding, my Lords, I am also, my Lord, purchaser of the property.
Right.
So, my Lords, property, my Lords, land. In survey number 1, my Lords, that land, my Lords, is to the total extent of 5 acres.
The land was converted, layout is formed.
My Lords, it is, my Lords, I am submitting, my Lords, that is not, my Lords, there is suppression of fact. My Lords, total extent of land is 5 acres, 8 guntas. My Lords, 1 acre, 27 guntas. My Lords, is the land, my Lords, which was the issue. My Lords, we came, my Lords.
That previous order that you're talking of.
My Lords, annexure A2, my Lords, of annexure R2, my Lords, along with the application which I have produced, which is produced by me, my Lords. At page number 20 of the application. R2, my Lords. It was held that, my Lords, only in accordance with, my Lord, the title documents, the entries are to be affected. This is the, and he said, my Lord, DC set aside the earlier order, saying that is in excess of title deeds, the entries are affected in the favor of the petitioner hearing. Or the petitioner's father.
Narayan Swamy is not a party to the proceedings.
Lord's father of Lord's the petitioner.
Yaru?
Narayan, so if your lordships kindly see, my lords,
Narayan Swamy, son of H. Lakshmaya.
H. Lakshmaya, my lords, if your lordships kindly see from,
Respond number 2,
Like
H.
here-
Lakshmaya.
please, my lord, father of the petitioner,
H. Lakshmaya.
please.
Ah,
Lords, he was a party there. His
Hmm.
order was passed setting aside the earlier entries. And it was said, you hold the inspection and in accordance with the title deeds, you effect the entries. My lord, unfortunately, that was done, my lords, after life of so many years. But my lords, 2012 order, where they were parties, my lords, they have, my lords, not, my lord, produced along with the petition, not challenged this order, my lords, at all. And what action was taken in pursuance of that, my lords, is challenged here.
ಹೈಯರ್ ಕಾಪಿ ಸರ್ವ್ ಆಗಿರಲಿಲ್ಲ.
Sent by email, my lords.
ಇವಾಗ ಗೊತ್ತಾಯ್ತು ಸ್ವಾಮಿ.
We tried to call him. Give a copy. Please, my lord.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತೀವಿ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
Learned counsel.
ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಅವರು ಡೆಡ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಅವ್ರ ತಂದೆಯವರು.
For respond number
Lord 7.
7. Satish,
My lords, my colleague's name, my lords, is reflected. Your lords may show my name also.
you have filed Wakala.
I have filed wakalat, my colleague's name is shown, my lords.
Learned counsel for respond number 7 is requested to serve a copy of IA number 1 of 2024.
Please.
On the learned counsel for petitioner. Full stop. Next para office is directed to show the name of learned counsel Shri
MP Shrikant,
MP Shrikant for respond number 7.
please.
Yes.
Lord, there is
This
urgent
matter after summer vacation.
Lords, your lord, some date may fix, my lords, immediately after summer vacation. Or your lordship may say immediately after.
Then ಆದ್ಮೇಲೆ
Immediately. after.
yes, immediately after summer vacation.
Please.
Yes.
31, Karnataka P.
It is served, there was a direction for the government advocate to take the instructions so far as
ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ರು. One restoration of the name of the petitioners as per the order of annexure, my lord, annexure D. The assistant commissioner, after setting aside the sale, my lord, directed to restore the names of the petitioners. Annexure D at page number 2320. Lord, when the petitioners approached based on this order, the
Any instructions?
ಅದೇ my lord, what the annexure G, the special Tahsildar says, my lord, annexure G ಅಲ್ಲಿ there is an appeal that has been preferred, my lord, by one of the family members of the grantee. If my lordship sees annexure G,
Proceedings were initiated under PTC.
Somoto.
ಅಲ್ಲಲ್ಲ ಇದು
Somoto, ಅದು
ಇಲ್ಲಿ-
that was
ಇಲ್ಲಿ
not related
my
to the
lordship,
petition.
what has happened, my lord? PTCL Act ಅಲ್ಲಿ it has proceedings was initiated. Assistant Commissioner said it has to go before the land has to be restored in the name of grantees or the legal heirs. Then my lord, there was
Name
one
of the legal heirs of Muniga was required to be entered in the RTC.
ITC ಮಾಡಿದ್ರು. ಆಮೇಲೆ if my lordship sees the annexure
To remove the name of government from the land records.
annexure G ಅಲ್ಲಿ annexure G, a suo motu proceedings was initiated against one lady by name Chokkama, who is also claimed to be one of the legal heirs of the original grantee.
Alla, it's wrong.
He has issued the endorsement stating that in a proceedings earlier initiated by the special DC by order dated so and so, directed the land in question should be
ಅದೇ ಆರ್ಡರ್ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೆ.
forfeited to the government.
ಅದೇ ಆರ್ಡರ್.
And therefore, the name of government has been entered in the land records. For that reason, the application, the petition has been rejected.
ಅದೇ that is what I am trying to say. Annexure G, if my lordship sees annexure G, page 32, ಆ ರೆಫರೆನ್ಸ್ ಕೊಡೋದು ಅವರು.
Next year G at page number 30. She is not our relative or a family member. We are no way connected with that, my lord, order. Actually, we are not parties to that.
State of Karnataka versus Chokkam.
ಹೌದು. ಯಾರ ಬೇರೆ ಇದ್ರು.
ಇವಾಗ the order that has been passed by the Assistant Commissioner, my lord, on 10/6/2013 Annex D ಅಲ್ಲಿ ಆ proceedings legal case initiate ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ.
What has that order got to do with these people?
ಇವರು, if my lordship sees page annexure page 23, my lord, annexure D.
Annexure D.
D, my lord. ಅವರು, she is also one of the party before the Assistant Commissioner.
Respondent.
Respondent, ಹೌದು.
ಅಂದ್ರೆ purchasers ಕಡೆ.
ಹೌದು. ಹೌದು. So
purchasers ಕಡೆ.
there was already a proceedings that was initiated with which
proceeding ಅವರು purchasers ಅವರು.
ಅದೇ, but this order is a subsequent order that has been passed in 2015. Saying that the land has to be forfeited and the name of the government.
Why?
Because she has no right over the property and suo motu proceedings. It's
So that has got nothing to do with the petitioner.
That is because of this order, my lord, where the order of the deputy.
Which is the impugned order?
Impugned order, your prakara D.
Annexure A.
Annexure A.
Now, as per the order at annexure D, my lord, we approach.
Endorsement is given.
Given. This endorsement was given based on the reference of this order that has been passed by the deputy commissioner, which is subsequent to the order of the Assistant Commissioner DL. ಅದು ಗೋಮಾಳ್ ಲ್ಯಾಂಡ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರ ಚೊಕ್ಕಮ್ಮ ಅವ್ರಿಗೆ ಹೆಸರು ತೆಗಿಬೇಕು. ಸೊ
how is it possible?
ಅವರು
The Assistant Commissioner has passed an order under the provision of the PTCL Act.
Correct, madam.
Restoring the
name of the original legal heirs of original
or the
grantee.
legal heirs.
Correct, madam.
According to that, they are asking for entry of their names in the land records while removing the name of the government.
But subsequent ಇವ್ರು ಏನು
ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. They are not parties to the proceedings.
ಅರೆ ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, because the subsequent order which was passed in the year 2015 by the deputy commissioner.
We will make it clear and we will issue directions. ಬರ್ಕೊಳ್ಳಿ. Yeah, 5/3/2024 ಅಲ್ಲಿ it is the contention of the petitioners ಅಂತಿದೆ. ಪೂರ್ತಿ ಪ್ಯಾರಾಗ್ರಾಫ್. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹಾಕೊಂಡು. Next paragraph. The learned AGA was directed to secure instructions and make submissions. Full stop. Today, the learned AGA submits on instructions that the impugned endorsement dated 1/2/2024 has been issued by the Special Tahsildar, Yelahanka Taluk, based on such an order earlier passed by the Special Deputy Commissioner on 11/8/2015. Full stop. Next para. It is clear from the material available on record and the instructions given to the learned AGA, that the orders passed by the Special Deputy Commissioner at annexure G dated 11th of August 2015 in RRT bar 2 bar NA bar 444 bar 2009-10, wherein the appellant is the state and the respondent is Srimati Chokkamma, wife of late Lotappa, comma, has nothing to do with the petitioners. Full stop. The petitioners are entitled to have their name entered in the land records. Consequent to the orders passed by the Assistant Commissioner in proceedings bearing number.
Annexure D, my lord. Annexure D. Page number 20.
23 K SC/ST 8/2006-2007 dated 10th of June 2013. Full stop. Next para. Consequently, the impugned order at annexure A dated 1/2/2024 issued by the Special Tahsildar, Yelahanka Taluk, Bangalore is hereby quashed and set aside. Full stop. The Tahsildar is directed to take action in accordance with law. That is, in terms of the provisions of the Karnataka SC/ST PTCL Close Act 1978 and the rules. Rules 1979. To restore the lands in favor of the original grantee or the legal heirs.
Only updating of revenue records.
And make necessary entry in the revenue records.
As per the order of the Assistant Commissioner dated 10.
While removing the name of government. While removing the name of the previous Khatedar.
Yes.
And
the government.
the government, if it is entered in the land records. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
A reference of the AC order on bandide. Reference of AC order, ACS of reference based on the order of the AC and
Annexure D.
Annexure D.
Bantu,
Yes,
serial number 13 ಕೇವೇಟರ್ ಅವರು ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ವಿ ಬರ್ಲಿ ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ ನಾಳೆಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ 13
absent ಅಂತ
ನಾಳೆಗೆ
petitioner ಅದು ಬರೋದಿಲ್ಲ ನಾಳೆಗೆ ಬರಲ್ಲ after vacation ಅಂತ ಆರ್ಡರ್ ಮಾಡಾಯ್ತು ಅವ್ರು ಇವತ್ತು ಬಂದ್ರೆ ತಗೊಂಬಂತ ಬಂದಿಲ್ಲ ಇದುವರೆಗೂ ಕಳಿಸ್ಕೊಡಿ
ಕರೆಕ್ಟ್
ಸೀರಿಯಲ್ ನಂಬರ್ 48 ನಾನು 230ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಸರ್. ಸರ್ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮೊನ್ನೆ ನಾನು ಹೇಳಿದ್ದೆಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಪೋರ್ಷನ್ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಅದು. ನಾನು 230ಗೆ ಸಾಹೇಬ್ರು ಸಿಟ್ಟಿಂಗ್ ಬರುವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ. ಅದೇ ಸಿಂಗಲ್ ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದೆ ಸಪೋಸ್ ರೀಚ್ ಆಗದಿದ್ರೆ ಸಾಹೇಬ್ರು ಎದ್ದೇಳುವಾಗ ತಗೊಳ್ಳಲ್ಲ.
ಇಲ್ಲ ಸರ್ ಅದು ಕಳಿಸ್ಬಿಟ್ರಿ
ಸರ್ 230 ಲಿಸ್ಟ್ ಒಂದು ಇದೆ ಸೆಪರೇಟ್ ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ.
ಇಷ್ಟು ಇಷ್ಟ ಕಾಯ್ಕೊಂಡಿದೆ ಅನ್ಸುತ್ತೆ. ನಾನು ಹೇಳಿದೆ ಊಟ ಮಾಡಕ್ ಬಿಡಿದ್ರಿ, ನೀವು ಊಟ ಮಾಡಲ್ವಾ ಹಂಗೆ ನಾವು ಅಂತ ಬೈದ್ಬಿಟ್ಟೆ.
Sir? Sir, what up, sir? Sir, what up, sir?
Yes, sir.
Sir, late I know.
ಇಲ್ಲ ಬರ್ತಾರೆ 5 ನಿಮಿಷ ಇನ್ನು ಟೈಮ್ ಇದೆಯಲ್ಲ.
ಸಿದ್ಧನಗೌಡ ಸರ್. ಸರ್ ಕೇಳಿಸ್ತಲ್ಲ ಸರಿಯಾಗಿ. ನಮ್ಮ ವಿಷಯ ಸರ್ ಸಾವಿರ ಕೇಳ್ತಾದ್ರೆ ಎಷ್ಟೊತ್ತಾಗತ್ರಿ? ಹಲೋ ಸರ್, ವಾಟ್ ಆಫ್ ಸರ್? ಸರ್ ಕೋಟ್ ಆಫ್ ಸರ್?
ಹೇಳಿ ಸರ್, ಯಾರು ಮಾತಾಡ್ತಾರೆ ಸರ್?
ಸರ್ ನಮ್ಮ ಮಂಜುನಾಥ್ ಸರ್ ಮಾತಾಡೋದು.
ವೇಟ್ ಮಾಡಿ ಸರ್, ಎಲ್ಲ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್ ವಾಯ್ಸ್.
ಸರ್ ವೇಟ್ ಮಾಡಿ, ಸಾಹೇಬ್ರು ಬರೋವರೆಗೂ ನಾವು ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಚೇಂಬರ್ ಇಂದ ಫೋನ್ ಮಾಡಿದ್ರು, ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಕೇಳಿ ಅಂದ್ರೆ ಅದಕ್ಕೆ.
ಓ ಬೆಂಚ್ ಅಲ್ವಾ?
ಹ್ಞೂ ಸರ್.
ಒಂದ್ ಸೆಕೆಂಡ್ ಹೇಳ್ತೀನಿ, ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ. ಫೋನ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ಅಲ್ಲಿಂದಾನೆ, ಚೇಂಬರ್ ಇಂದಾನೆ.
ಓಕೆ ಸರ್.
ಆಯ್ತು ಸರ್. ಇದು ಆಯ್ತಾ ಸರ್? ಇದೇನು ಬಂದಿತ್ತಲ್ಲ ಇದೆ ಮಾಡ್ತಾ ಅದು ನೀವು ಅಲ್ಲೇ ಇದು ಮಾಡ್ಬೇಕು, ನಾನೇನು ಮಾಡಬೇಕು ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿ ಹುಡುಕಕ್ಕೆ ಹೇಳಿ. ನಾನು ಹೇಳಿದ್ದೀನಿ ಅವತ್ತೇ ಇನ್ನೊಂದ್ಸಲ ಹೇಳ್ತೀನಿ, ನಂಬರ್ ಕೊಡಿ. ಬಂದಿಲ್ಲ ಸರ್, ನಾನು ಕೊಟ್ಟು ಕಳಿಸಿದೆ ನಂಬರ್ ಅವರು. ಈಗ ಕೊಟ್ಟು ಕಳ್ಸಿದೀನಿ, ನಂಬರ್ ಹೋಗಿದೆ ನಿಮ್ದು, ಬೆಳಗ್ಗೆನೆ ಕೊಟ್ಟೆ. ಕಾಪಿ ಕಾಪಿ ನಾನು ಕೊಟ್ಟೆ. ಇದೆ ನಂಬರ್ ಮೂರು ಕೊಟ್ಟಿಲ್ಲ, ಒಂದೇ ಇದೆ ಅಂದ್ರೆ ಇಲ್ಲ ಅದರಲ್ಲಿ ಮೂರಿದೆ. ಅಲ್ಲ ಇಲ್ಲ, ಈಗ ಅಷ್ಟೇನ ಕರೆಕ್ಟ್. ಅನಂತ ಆಯ್ತು.
Serial number 38, entry model until further orders ಇದೆ. Reach ಆಗಬೇಕಾದ್ರೆ.
ಎಷ್ಟು ನಂಬರ್ ಇದು ಮಾತ್ರ ತಗೊಳ್ಳಿ. ಅದು ಬೇಡಮ್ಮ, ಅದು ಅವ್ರದ್ದು ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗತ್ತೆ. 4:15 ಬನ್ನಿ, 4:15 ಬನ್ನಿ ಅಂದೆ. ಎಷ್ಟು ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ. ಮರ ಮಾಡ್ತೀಯ ಮರ ಮಾಡ್ತೀಯ ಮರ ಮಾಡ್ತೀವಿ ಸ್ವಲ್ಪ ಮರ ಮಾಡ್ತೀವಿ. ನೀನು ಎಷ್ಟು ಮಾಡ್ಬೇಕು ಬರ್ಕೊ ಇಲ್ಲ RMS R ಲಾಕ್ ಅಂದ್ರೆ ಸಿಗುತ್ತಿಲ್ಲ. ಆ ಫಾರ್ಮ್ಯಾಟ್ ತಗೊಳ್ಳಿ. ಮೂರೇ ಪುರಪ್ಪ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅದು GP ಅದು ಬಂದಲ್ಲ. ಹಾ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆ ಅದು. Amendment. ಎರಡು ನಾಟ್ 3 ಮರ ಮಾಲ್ಕಿ 2 ನಾಟ್ ಪೇಡ್ ಮೂರು ಮರ ಮಾಲ್ಕಿ
ನಿನ್ನೆ ಎಲ್ಲ ನಾಟ್ ಪೇಡ್ ಅಂತಾನೆ
ಕೊಟ್ಟಿದ್ದೀನಿ
ನಾಟ್ ಪೇಡ್ ಅಂತಿಲ್ಲ ಪೇಡ್ ಅಂತಿಲ್ಲ.
ರಿಪೋರ್ಟ್ ಪ್ರಶ್ನೆ ಸ್ಕೂಟ್ನಲ್ಲಿ ಇದೆ ಹುಡುಕಿ ಕಳ್ಸಿರ್ತೀವಿ 100% ಹೋಗಿ ಹಂಗೂ ಬೇಕಾದ್ರೆ ನಮ್ಮ ಕಡೆ ಕೊಡ್ತೀನಿ ನಾನು ಹೋಗಿ ನೀವು ಫಾಲೋ ಕಲಬುರ್ಗಿ ಅಲ್ವಾ ಹಲೋ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಹಲೋ Kalburgi bench, connect the proceedings, sir. List number 2.
My lordship, serial number 1 is our matter, it's in Maramal case.
List number 2, fresh matters.
Serial number 1.
Details put
Got it informed. I will furnished.
List number 1 is Maramal case.
4, 5, 6 amendment.
Huh?
4, 5, 6.
Already?
Application is filed to.
The amendment for the appointment, the petition was filed by
Originally, the petitions were filed by GPA holders. Therefore, applications were filed to insert the name of the original grantee represented by GPA. Last occasion, Honorable Court directed to file the applications in the counter and those were filed. You may be permitted to carry out the.
We are disposed of the matter, is it?
Yes.
Already disposed.
You have to recall that order. Huh?
Wait a minute.
24.
Order on year number 1 of 2024. Namaskara.
Sir, namaste, sir.
Matters pertaining to Bangalore bench. VC through VC, serial number 1, government advocate. Pronouncement of orders.
Yes, sir. The writ petition is dismissed. It is needless to say that while calculating the emoluments of the pension payable, the amount already paid to each of the applicants has to be taken into consideration.
Yes.
Grateful.
Yes, sir.
All right, brother.
Yes, sir.
List number 2, continuation. Hearing interlocutor application, serial number 4.
On the previous date of hearing, this court has recorded the fact that although the matter was disposed of by order dated 1/4/2024, the learned counsel for the petitioner moved the matter for being spoken to. Full stop. Learned counsel had submitted that by inadvertence, the petition has been filed in the name of the power of attorney holder and not the grantee. Full stop. Leave was granted to the petitioner to file necessary application. Full stop. Consequently, this application has been filed to amend the cost title showing the name of the grantee, Sri Swami Gowda, son of Kale Gowda, as the petitioner, represented by his power of attorney holder, Sri Austin Roach. Full stop. Next para, the application is allowed. The petitioner is permitted to carry out the amendment in the cost title. Full stop. Next para, office is directed to issue a fresh certificate copy consequent to the amendment to the cost title. Yes.
So number 5, 6.
5, 6,
All are same.
5, 6, ಮತ್ತೆ 7, na?
4, 5, 6.
4, 5, 6.
4, 5, 6, ಮೂರು same order.
Yes, number 1, continuation. Serial number 32, Rajan Kumar K.
Here for petitioner.
Awaiting.
Have you received copy of the writ petition?
Yes, I have served, my lord.
Third, AGS submits that he has received copy of the writ petition. List this matter after service of notice on respond number 4.
Intimatum may be extended.
Intimatum granted earlier stands extended to next date.
Serial number 33,
This case.
Sankrapa
petitioner
GS.
order. And summons have been served to respond number 5. bro.
Have been served.
Yes. bro. I think husband of respond number 5 has come to the court.
Follow
Rukmini.
respond number 5.
R. Rukmini for respondent number 5. G. Rukmini for respondent number 5.
5.
House. Respond number 5. 33, serial number 33.
9374.
ಅದು ಕಾಸ್ಟ್ ಟೈಟಲ್ 4 and 5 ಮಿಕ್ಸ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ರುಕ್ಮಿಣಿ ಅಂತೇನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ತೋರಿಸ್ತಾ ಇದೆ 5 ಇದೆ. 5 ಅಲ್ಲಿ ಇದೆ. 4 ಶಂಕರ್ ಅಂತ ಲೈಸೆನ್ಸ್ ಸರ್ವೇಯರ್, 5 ರುಕ್ಮಿಣಿ ಅಂತ ಅದು ಸ್ಪೇಸ್ ಬಿಟ್ಟಿಲ್ಲ.
ಓ ಸ್ಪೇಸ್ ಕೊಟ್ಟಿಲ್ವಾ? ತೋರಿಸಿ ನೋಡೋಣ.
Page number 4.
ಬ್ರೇಕ್ ಕೊಟ್ಟಿಲ್ಲ. ಏನ್ ವಕಾಲತ್ ಹಾಕ್ತೀರಾ? ಅಡ್ವೊಕೇಟ್ ಗಳು ವಕಾಲತ್ ಹಾಕ್ಸ್ರೇನ್ರಿ? Are you going to appear?
ತೆಲುಗು ಕನ್ನಡ ಬರಲ್ಲ.
ಕೇಳಿ, ನೀವೇ ಕೇಳಿ.
ಅಲ್ಲ, ಅವ್ರ ಮಿಸ್ಸಸ್ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರಂತೆ.
ಅವ್ರು ಬೇಕಿಲ್ರಿ, ಅಡ್ವೊಕೇಟ್ ದೇ ಹ್ಯಾವ್ ಟು ಎಂಗೇಜ್ ಅನ್ ಅಡ್ವೊಕೇಟ್.
ಇಟ್ಕೊಳ್ತಾರೆ.
ಅಲ್ಲ, ಅದಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ ಅವ್ರು ಕೋಡಿ ತೋರಿಸಿ ಕೇಳ್ತಾರೆ, ಕೋಡಿ ತೋರಿಸಿ ಮಾಡ್ತಾರೆ. ಇವ್ರು ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಮಾಡ್ತಾರೆ, ನಮ್ದು ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಪೆಟಿಷನ್ is very simple, my lord, that even he is also agreeable for survey.
ಸರ್ವೆ ಮಾಡ್ತಾರೆ ಇವಾಗ ಅದನ್ನ. ದಟ್ ಈಸ್ ವಾಟ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
Representation has to be considered. ನಾವು ಅವ್ರು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಗಳಿಗೆ ಸರ್ವೆ ನಂಬರ್ ಮಾಡಕ್ 5ನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅಪ್ಲಿಕೇಶನ್, ನಾವು ಕೊಟ್ಟಿದೀವಿ, 2 ಜೊತೆಲಿ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ.
ಅವರು ಅಪ್ಲಿಕೇಶನ್
ಹೌದೌದು. ಈಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರೇಷನ್ಗೆ ಅವ್ರು ಶುರು ಮಾಡಿದ್ರು, ನಾವೇನ್ ಮಾಡಿದೀವಿ ನಮ್ದನ್ನು ಜೊತೆಲಿ ಮಾಡಿ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದೀವಿ. ದಾಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಷ್ಟೇ.
ಅವ್ರು ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಔರ್ ಲ್ಯಾಂಡ್. ಇವ್ರೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವ್ರ ಲ್ಯಾಂಡ್
ಅಡ್ಜಸ್ಟೆಂಟ್ ಲ್ಯಾಂಡ್, ಎರಡೂನು ಅಡ್ಜಸ್ಟೆಂಟ್ ಲ್ಯಾಂಡ್.
ಅವ್ರು ಆರ್ಡರ್ ಆಗಿದೆ, ನಮಗೂ ನಮ್ ಲ್ಯಾಂಡ್ ಸರ್ವೆ ಮಾಡಿ ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ಆಲ್ ದಿಸ್ ಇನ್ಫಾರ್ಮೇಶನ್?
Lord, prayer is, Lord, in page number 8, Lord. Issue writ of mandamus or any other writ or order directing the respondent number 2 and 3 to consider petitioner's application dated 28/2/24, which is produced at Annexure H. Fix the boundaries by conducting the survey of lands bearing survey number 97/1, 92/2 and 99/4 of Hirandahalli village along with survey number 28. Now the surveyor is conducting only 28/1. Namd application no ide, but is
it your neighboring property?
Yes, my lord, all are neighboring. And moreover, what is
Issuing notice to the neighbors,
no, my lord, they have issued.
survey will not be conducted.
Yes, my lord.
You are under a wrong impression.
Lord,
Whenever survey is to be conducted, notice has to be issued to the neighboring landowners.
please, my lord.
Without their presence, survey will not be conducted.
Now the question is, my lord, they have issued the notice, even petitioners also.
ಸರಿ ರೀ, ಅವ್ರದೇ ನೋಟಿಸ್ ಮೇಲೆ ಬಂದು ಸರ್ವೆ ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ ನೀವು ಇಲ್ಲ ನಮ್ದು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಅರ್ಥ ಏನಿದೆ?
My lord, what has happened?
You should have asked them, all right, conduct the
Now,
survey.
that is the requirement, my lord. They say application is in respect of 28/1. Therefore, they will conduct only 28/1. Issuing notice to the respondents and petitioners neighboring. But what has happened, my lord, kindly see initially what has happened, the survey has been conducted already in respect of my land.
Only thing is, ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ನಿಮ್ಮ ಅದರ್ ಸೈಡ್ ನೇಬರ್ ಇರ್ತಾರಲ್ಲ ಅವ್ರನ್ನು ಕರ್ಸ್ಬೇಕಷ್ಟೇ, ಇನ್ನೇನು ಇಲ್ಲ.
ಇನ್ನೇನಿಲ್ಲ ಅದರಲ್ಲಿ.
ಬರ್ಕೊಳ್ಳಿ. ಅವರ ಇದು ಹೆಸರು ಇದು ಬರ್ಸ್ಕೊಳ್ರಿ ಪೇಪರ್ ಅಲ್ಲಿ. ಪ್ಲೀಸ್ ಕಮ್ ದಿ ಸೈಡ್. ಅವರ ಹೆಸರು ಅಡ್ರೆಸ್ ಬರ್ಸ್ಕೊಳ್ರಿ. The petitioner is seeking a writ of mandamus directing the respondents, Tahsildar, Bangalore East Taluk, and the Additional Director of Land Records, Bangalore East Taluk, to conduct Kodi and Durast in respect of
survey number 28/1.
In respect of survey number 97/1,
97/1,
98/2,
and 98/2,
99/4.
99/4 ನಿಮ್ದೇನಾ?
Please, my lord. Please, my lord. Hirandahalli village. And the problem is, my lord, that it is in the border of two villages. 28/4, 28/1 ಬೇರೆ ವಿಲೇಜ್ ಬರುತ್ತೆ, ಈ ಸರ್ವೆ ನಂಬರ್ಗಳು ಬೇರೆ ವಿಲೇಜ್ ಬರುತ್ತೆ.
ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಆ ನಂಬರ್ ಇಲ್ವೇ? There are only two numbers.
Annexure H ಅಲ್ಲಿ
97
Annexure H, my lord. Annexure H.
ಅದೇ
ಸಬ್ಜೆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಮೇಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 28/1, ಪೇಜ್ ನಂಬರ್ 66, my lord.
situated at Hirandahalli, Bidarhalli Hubli, and survey number 99/4.
2-3 number, my lord, 97/1, 98/2.
ಅದೆರಡು ಆಯ್ತು ರೀ. 99/4 is in which village?
ಹಿರಂಡವಳ್ಳಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಸೇಮ್ ವಿಲೇಜ್
ಇಲ್ಲ, ಈ ಮೇಡಹಳ್ಳಿ ವಿಲೇಜ್ 28/1
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಇದೆ, ವಿಷಯ ಅಂತಿದೆ.
ಮೇಡಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 28/1.
ಹಿರಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 97/1, 98/2, 99/4.
97/1, 98/2, and 99/4. All situated at Irandahalli. And survey number 28/1 situated at Medahalli.
ಅದು ಅವ್ರದಲ್ಲ.
That is the respond number 5.
0.5 ಇದೆ ಅದು.
ತೆಗ್ದಾಕಿ ಅದು. Medahalli ತೆಗ್ದಾಕಿ. Along with the survey that is due to be conducted at the instance of respondent number 5, Srimati G. Rukmini, who is the owner of survey number 28/1 of Medahalli village, which is a neighboring property of the lands in question, since the properties are situated at the boundaries of the two villages. Full stop. Next para. In the representation dated 28/2/2024 at annexure H, the petitioner has requested the ADLR that in terms of an application filed by the fifth respondent, the ADLR has issued notice to the petitioner for conducting the survey. Full stop. However, the petitioner is also seeking survey of the lands along with that of the fifth respondent. Full stop. Next para. When notice was issued to the fifth respondent and the petitioner was permitted to take out hand summons to the fifth respondent, the husband of the fifth respondent, put it together. Sri G. Janardhan Reddy is present before this court. Full stop. It is stated on behalf of the fifth respondent that the fifth respondent will have no objection to permit the ADLR to conduct the survey even in respect of the lands belonging to the petitioner. Full stop. Next para. Consequently, the writ petition stands disposed of with the direction to the third respondent, ADLR, Bangalore East Taluk, to proceed to conduct the survey not only in respect of the land belonging to the fifth respondent in survey number 28/1 of Medahalli village, but also in respect of the lands belonging to the petitioner in survey numbers 97/1, 98/2, and 99/4 of Hirandahalli village, and pass necessary orders as expeditiously as possible and at any rate within a period of
3 months. 3 months.
ಅವ್ರದ್ದು ಆಗ್ಲಿಲ್ಲ ರೆಡಿ ಇದೆ ಅಂತಲ್ರಿ. 2 months from the date of receipt of a copy of this order.
That Rukmini has taken her signature is acknowledgement, we have produced it.
It's all right, please. Yes.
Number 34.
Petitioner,
YT.
last time my lords had directed them to take instructions why the body work was not, which was started, not completed.
Restriction, my lord, they say, my lord, that there's a proceedings under 108K has been initiated against the petitioner's land, my lord, because there is some violation of the grant rules.
There's a proceeding that.
have been initiated under rule 108K for cancellation.
Cancellation because.
No
proceedings are initiated, you know.
Huh?
No proceedings are initiated.
Initiated our proceedings because the ADLR after the application sought for details of the assistant commissioner office or something. Tahsildar office. Tahsildar on verification, and it was found that there is some violation in respect of grant rules. So the proceedings will be initiated under one.
Proceedings will be initiated, my lord. No
ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ 2005 ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿರೋದು. ಓಡಿ ದುರಸ್ತ ಆದ್ಮೇಲೂ ಕೂಡ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡಬಾರ್ದು ಇದೆಯಾ? ಮಾಡ್ಕೊಳ್ಳಿ. If it is permissible in law. Because the grant was made in the year 2005.
Yes, sir. That is my submission may be taken on note and it can be disposed of.
Yes, Berkeley. The previous order ಅಲ್ಲಿ 10/4/2024 ಅಲ್ಲಿ third paragraph ಅಲ್ಲಿ learned counsel for petitioner submits that since ಅಂತಿದೆ. ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೂರ್ತಿ ಹಂಗೆ ಬಂದ್ಬಿಡಿ. Next paragraph. Learned AGA was directed to secure instructions from the respondents as to why there is a delay in carrying out the Podi and Durast. Full stop. Learned AGA submits on instructions that the Tahsildar is contemplating initiation of proceedings for cancellation of the grant made in favor of the petitioner. Full stop. Next paragraph. Learned counsel for the petitioner submits that it would be impermissible for the Tahsildar or the competent authority to initiate proceedings for cancellation of the grants which were made in the year 2005. Full stop. Nevertheless, the learned counsel would further submit that conducting the Podi and Durast will not in any way affect the
ADLR
rights of the revenue authorities to initiate action, if it is so permissible in law. Full stop. Next paragraph. There is substance in the submission of the learned counsel for petitioner. Full stop. Having regard to the fact that the grant was made in the year 2005, the Tahsildar and the survey settlement authorities are required to proceed to conduct the Podi and Durast in respect of the land in question. Full stop. At the same time, if the Tahsildar or the competent authority is of the opinion that the grant should be cancelled, they may proceed only in accordance with law. Full stop. Next paragraph. The writ petition stands disposed of with a specific direction to the Tahsildar, Bangalore North Taluk, and the Assistant Director of Land Records, Bangalore North Taluk, to proceed to conduct the Podi and Durast in respect of the lands belonging to the petitioner as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Bless you.
Yeah, this order will not come in the way of if they.
Question number 35, Badrinatha, waiting.
List this matter after service of notice on respondents number 6 to 11.
36.
Petition.
Number 36, Vinayaka, yes, Pandit.
Pay for petition and avoid notice of R9.
Will is this matter of the service of notice on respond number 9?
Interim order may can be.
Interim order granted earlier stands extended till the next day.
Please.
37,
This case, I'm petition. Plus annexure B is the partition deed, minutes. In which, minutes, there is an handwritten, plus in respect to stamp and fees, that's it. In respect to others, contents and substance is in printed position, hence. Office objection, kindly. In page 26, man. Partition deed ಎಲ್ಲ printed ಇದರಲ್ಲೇ ಇದೆ. In respect to fees and all, they have written in hand. That is actually, I am not. $29 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅದೆಲ್ಲ ಪೂರ್ತಿ ಪ್ರಿಂಟೆಡ್ ಇದೆ.
Office objection is overruled. Really,
The petition, let's seeking passing of the impugned order, let's
asking for an interim order.
Let's please, let's by virtue of the dismissal of the appeal, let's by non-prosecution. Now, let's the respondent number 3 trying to dispossess.
Yes, really.
Let's the petitioner.
Please come to the synopsis.
Please. Let's father of the petitioner, let's has purchased the land bearing survey number 216/1 of Balkur village, Kundapur Taluk, Ulpi district in the year 1975. Let's. In the year 1998, let's the children's and wife of the father of the petitioner have partitioned as per annexure B. Let's. And thereafter, let's in the interregnum, the father of the respondent number 3 has filed application seeking tenancy under form number 7. Let's in the now since from the purchase of this in the 75 minutes, all the revenue records stands in the name of father and as well as the petitioner herein. Let's in page 49 minutes, in which minutes the father of the petition number 3, respondent number 3 has filed application under form number 7, stating that minutes the land in question, but minutes in which minutes he stated the owners as Krishnappa Shetty and Veerana Shetty, for not the my previous owners minutes. And thereafter, the proceedings has gone. Before the assistant commissioner, the son of that said Krishnappa Shetty came to the proceeding and stated that I have no objection to allow the application. We are not the parties to the proceedings at all. In page number 56, this is the order, grant order. In which, second paragraph.
5/8/2005 order is
56.
Page number 56.
House. ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ 5/8/2005 ವಿಚಾರಣೆಗೆ ಕೈಗೆತ್ತಿಕೊಳ್ಳಲಾಯಿತು. ದಿನಾಂಕ 5/8/2005 ದಿನಾಂಕದಂದು
ಖಾನ್ ಉಮರ್ ಸಾಹೇಬ್ ವರ್ಸಸ್ ಡಿ ಕೃಷ್ಣಪ್ಪ ಶೆಟ್ಟಿ.
ಹೌದು ಸ್ವಾಮಿ. ಅವ್ರು ನಮ್ಮ ಓನರ್ಸ್ ಅಲ್ಲ, ಆ ಲ್ಯಾಂಡ್ ಅವ್ರದಲ್ವೇ ಅಲ್ಲ. 216/1 ಇದು ನಾನ್ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು. ಮಹಾಬಲ ಶೆಟ್ಟಿ ಅಂಡ್ ಪುಟ್ಟಣ್ಣ ಶೆಟ್ಟಿ ಇವ್ರು ಅದ್ರ ಓನರ್ ಸ್ವಾಮಿ ಮೊದ್ಲಿಂದ. ನಾನು ಇವರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದೆ. ಇವ್ರು ಕೃಷ್ಣಪ್ಪ ಅಂತ ಓನರ್ಸ್ ನಂಬರ್ ಹಾಕಿ ಸರ್ವೆ ನಂಬರ್ ಬೈ ಮಿಸ್ಟೇಕ್ ಹಾಕಿದ್ರು ಏನೋ ಗೊತ್ತಿಲ್ಲ. ನಂತರ ಕೃಷ್ಣಪ್ಪ ಶೆಟ್ಟಿ ಮಗ ಬಂದು ಬಿಫೋರ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಸ್ಟೇಟ್ ದಟ್ ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಅಲೋ ದಿ
98/99.
Please.
Proceedings were initiated in the year 98/99 now.
Please. House. Application has been filed on that date. But order has been passed in 5/8/2005.
77A.
House. Nantra against which I have filed appeal before Karnataka Appellate Authority in their
216/1.
House.
Measuring 28 guntas.
ಅವನು ಅದ್ರಲ್ಲಿ ಹಾಕಿರುವಂತದ್ದು 20 ಗುಂಟೆ ಅಂತ ಹಾಕ್ತಾನೆ ಅವನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. ಆಕ್ಚುಲಿ ಇರೋದು 28 ಗುಂಟೆ. ನಾವು ಬೈ ವರ್ಚು ಆಫ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ 5/8/2005 ಇದರಲ್ಲಿ 28 ಗುಂಟೆನು ಅಲಾಟ್ ಮಾಡ್ತಾರೆ. ಆಸ್ ಪರ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಫ್ರಮ್ ದಿ ಕೃಷ್ಣಪ್ಪ ಶೆಟ್ಟಿ ಸನ್.
Yes.
we are not before the court at all. And thereafter, we have challenged this order before the Karnataka Appellate Tribunal. Thereafter, Honorable Tribunal has granted status quo order. In their 2012 millets, the petitioner met with major accident. Since 2019, he is unwell and also he lost memory. And for that millets, I have produced all the medical certificates and also photographs. At page 103, not 103.
ಏನಾಯ್ತು ಈಗ?
Thereafter,
have been passed by the tribunal?
non-prosecution dismiss ಆಯ್ತು 2017ರಲ್ಲಿ. ನನಗೇನು ಗೊತ್ತಿಲ್ಲ, when they have actually troubled in the month of April, we came to know. Thereafter, we got certificate copies and thereafter.
No, who filed the appeal before the tribunal?
Petitioner hearing.
You only filed. How can you say I was not aware then?
No, accident ಆದ ನಂತರ ನನಗೇನು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. 2012ರಿಂದ 2019ವರೆಗೂ ಬೆಡ್ ರಿಡನ್ ಅಂತ. As per that, ink page 98. ಅದ್ರಲ್ಲಿ several ನನಗೆ ಮಲ್ಟಿಪಲ್
ಅಲ್ರಿ ಅಡ್ವೊಕೇಟ್ ಅಂದ್ರೆ ಹೋಗೋದು ಟ್ರೈಬ್ಯುನಲ್ಗೆ,
ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಪೂರ್ತಿ ಸಿಗ್ಲಿಲ್ಲ.
How can you make these kind of submissions?
No, as per the records, as per the statement made by the petitioner, as per the documents, 97 may kindly be seen. Page number 97. ಮೇಜರ್ ಆಕ್ಸಿಡೆಂಟ್ ಪೂರ್ತಿ ಏನು ಗೊತ್ತಿಲ್ಲ ಅವರಿಗೆ. 2019ವರೆಗೂ ಪೂರ್ತಿ ಆಪರೇಷನ್.
ವಕೀಲರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಮತ್ತೆ?
ವಕೀಲರ ನಂತರ ಹೋಗೋದು ಬಿಟ್ರಂತೆ. ಅದರಿಂದ ಪಿಟಿಷನರ್ ಹ್ಯಾಡ್ ನಾಟ್ ಟು ಬಿ ಪೂರ್ತಿ ಇವ್ರ ಲ್ಯಾಂಡ್ ಅಲ್ವೇ ಅಲ್ಲ, ಆದ್ರೂ ಪೂರ್ತಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಯಾರ್ದೋ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇಂದ ಆರ್ಡರ್ ಆಗಿದ್ದು. ಸ್ಟೇಟಸ್ ಕೋ ಪೂರ್ತಿ ಟಿಲ್ ಡಿಸ್ಪೋಸಲ್ ಇತ್ತು ಇದರಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲಿ. 98 ಮತ್ತೆ
17
99. ನನಗೆ 2012ರಿಂದ ನನ್ ಪೂರ್ತಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬಗ್ಗೆ ಏನು ಗೊತ್ತೇ ಇರಲಿಲ್ಲ.
ಈಗ ಏನು ಆಗಿಲ್ವಲ್ಲ,
ಈಗ ಅವ್ರು ಪೂರ್ತಿ ಜಾಗದಲ್ಲಿ ಡಿಸ್ಪೋಸಸ್ ಮಾಡಕ್ಕೆ ಮತ್ತೆ ಮರಗಳು ನನ್ನ ಮಾವಿನ ಮರಗಳು ಇದೆ ಅದನ್ನೆಲ್ಲ ಕಟ್ ಮಾಡಕ್ ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದಾರೆ. ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಮಿಲಟ್ಸ್ ಐ ಆಮ್ ಬಿಫೋರ್ ಮಿಲಟ್ಸ್. 103 ಪೇಜ್ ನಂಬರ್ 103 ನಲ್ಲಿ ಪೂರ್ತಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಟ್ರೀಸ್ ಇದೆ. ಟ್ವೆಲ್ವಿಂದ ಬೆಡ್ ರಿಡನ್ ಅದನ್ನ ಬರೀ ಮಲ್ಟಿಪಲ್ ಇಲ್ಲ ಅಂದ್ರೆ 10 ಸರಿ ಆಪರೇಷನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ. ನನಗೇನು ಗೊತ್ತಿಲ್ಲ. ವೆನ್ ದೇ ಆಕ್ಚುಲಿ troubled in the month of April, I came to know. Thereafter, I got certificate copies of all those.
Can't even make out who is the appellant, who is the respondent.
Plus, sir, for number, the grantee is not alive. He is already died.
Before the appellant, tribunal, who is the appellant and who is the respondent? Where is the information?
I have not filed the appeal memo, but and in page 56, Khan Umar Sahib, who is the applicant, on the basis of his application, land has been granted. We are not party to that proceedings. Before KAT, we have filed, not being the parties to this proceedings. Krishnappa Setti, one who is the respondent before the assistant commissioner.
Was there an order of stay?
There was a status quo order.
Elide.
Think page 62 minutes. Order sheet produced the entire. Adralli. Last paragraph. From beneath 3-line top, status quo on the disputed property.
Berkeley. Learned AGA takes notice for respondents number 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve a copy of the petition along with the annexures on the learned AGA. We'll stop. Next para. Learned counsel for the petitioner submits that although the petitioner's father purchased 28 cents of land in survey number 216/1 of Balkur village, Kundapura Taluk, under registered sale deed dated 11/11/1975 from one Sri Mahabala Shetty and Puttamma Shetty and the revenue records have been mutated in the name of the petitioner's father and thereafter in the name of the legal heirs of Shri Muktesar Haji Sahib, the father of the petitioner. Nevertheless, it appears that the fifth respondent's father, third respondent's father, late Shri Khan Umar Sahib, had filed an application before the land tribunal under section 77A in form number 7A, claiming tenancy rights in respect of 28 cents of land in survey number 216/1 against one Shri V. Krishnappa Shetty. The tribunal proceeded to pass an order on 5/8/2005 conferring occupancy rights in favor of the third respondent's father on the basis of a statement said to have been made by Shri Krishnappa Shetty's son. Full stop. Learned Counsel submits that the petitioners were not aware of the said order passed by the land tribunal. Full stop. Nevertheless, when they came to know of such an order, when he came to know of such an order, the petitioner filed an appeal before the Karnataka Appellate Tribunal in appeal number 288 of 2006, and an order of status quo was directed by the tribunal on 28/9/2006. Full stop. However, the petitioner suffered from a serious accident and was totally bedridden. Full stop. The tribunal has dismissed the appeal for non-prosecution by order dated 26/4/2017. Full stop. The third respondent is now seeking to dispose the petitioner on the strength of the orders passed by the land tribunal, where the petitioner's father was not a party to the proceedings. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 5/8/2005 passed by the land tribunal in proceedings bearing number LRP 7A 5954 of 98/99 till the next date of hearing.
LRF ಅಂತ LRP ಅಂತ ಹೇಳಿದೆ ಸ್ವಾಮಿ, ಅದು LRF ಅಂತ ಇದೆ.
LRF.
Go to DPM matter, hearing interlocutor application. Serial number 50. Tarigaki.
Appear for the petition. My lord, what is
Now placed before the court are two applications, my lord, three applications. One is
ಇದು ಸ್ಟೇಟ್ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದಿರಾ?
ಇಲ್ಲ.
Not filed.
You have called for records, my lord, record is before your lordship, lordship, record is the record, original records.
My lord, three applications are before this honorable court in IA 2 of 23, IA 3 for impleading applicants as additional respondents, and IA 1 of 24 for vacating stay. My lord, IA 1 of 24 for vacating stay by R3, my lord has expressed that may not be maintainable.
3 of 2023 for impleading. ಯಾರು ಫೈಲ್ ಮಾಡೋದು?
ಅದು
including the panchayat.
That is, he is already on record.
Already on record, I've already filed wakalat. Respond number 4.
My lord, who has filed this application? 3 of 2023, it has been allowed, is it?
No, no, my lord.
ಯಾರು ಹಾಕಿರೋದು? 3 of 2023.
RP is already on record. R4.
3 of 2023. For impleading.
ಯಾವ್ದು impleading ಅದು?
Executive officer. ಮೂಡಬಿದ್ರಿ ತಾಲೂಕ್ ಪಂಚಾಯತ್.
You're already on record, man. R4.
R4 is already on record.
R4 was not on record before. By the order of this honorable court, the R4 was directed to be impleted. My lord, I have impleted R4.
On 20th of March 2024.
Yes, ma'am. Petitioner to implead Taluk Panchayat. My lord, by virtue of my lord's order dated 20th March, the fourth respondent, the Chief Executive Officer Taluk Panchayat is now on record.
Yes.
The affected party, if it all.
One ನಿಮಿಷ.
Please, ma'am.
ಬರ್ಕೊಳ್ಳಿ. IA number 3 of 2023. Was filed by the petitioner seeking to implead executive officer, Moodbidri Taluk Panchayat. However, learned counsel submits that in terms of orders passed by this court on 20th of March 2024, the chief executive officer Taluk Panchayat has been impleaded as party respondent number 4. Full stop. Therefore, IA number 3 of 2023 stands disposed of. Next.
Next is IA 2 for 23 is a application filed by the petitioner seeking direction. On that, this honorable court has already passed an order.
Then it has to be heard and disposed of.
Yes.
Really.
That was.
Your contention was that without considering your application,
that is
they could not have allotted the land or granted the land to the Taluk Panchayat.
I will be able to convince this honorable.
Yes.
I think. My lord, kindly permit me to say a few things. I am raising three contentions in this writ petition. One is the petitioner is granted with the occupancy right. After that, he has filed an application in form number 53. That that it's my submission, my lord. That is for the court to accept or reject. That application is still pending. It is not disposed of, is first submission on the application. Second submission is the petitioner has the Kumki privilege because this is an abutting land. He was granted with the occupancy right. The land on which occupancy right is granted abuts this land. Therefore, there is a Kumki privilege of the petitioner on this land. That Kumki privilege is not extinguished as it is required. Therefore, the matter requires a reconsideration because Kumki privilege can be extinguished. Kumki privilege is there for a person, even for a tenant who is granted with occupancy right, Kumki privilege is available. That is, this honorable court has held, so I will place it before. The third and important matter, now it is a statutory authority. This Taluku Panchayat, there is a local body. Taluku Panchayat wants to put up construction. My lord, the Taluku Panchayat requires a license. Without license, even the Taluku license to put up construction. Without the license, no one can proceed. Therefore, this third aspect also need to be considered by this honorable court. It is my respectful submission. My lord, as far as the first submission regarding the application is not being, this honorable court to see the order sheet order which is placed by the other side at annexure R1. Though this is this statement of objection was filed by the municipality, which is not an affected party. Nevertheless, for the purpose of record, the court may kindly see the annexure R1. Annexure R1 at page, it begins at page 6. Kindly turn to the next page. ಕರೆಯಲಾಯಿತು, ಅರ್ಜಿದಾರರು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ದಟ್ಸ್ ವೇತನ ಇವರು ಪರ್ಯಾಯ ಮಾರ್ಪಾಡಿ, ಐ ಥಿಂಕ್ ಇಟ್ಸ್ ಮಾರ್ಪಾಡಿ ಗ್ರಾಮದ 223 ಎಕರೆ 3 ಎಕರೆ 20 ಸ್ಥಳವನ್ನು ಆಕ್ರಮಣವೆಂದು ಸ್ಥಳದಲ್ಲಿ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲವೆಂದು ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಒನ್ ಈಸ್ ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ತನಿಖೆ is report is otherwise. I will draw my lord's attention. Next is important. ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡುವುದು. My lord, ವಿಲೆ means ವಿಲೆ ಇಡುವುದು is it is kept pending. That's my submission. ವಿಲೆ ವಾರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್. ವಿಲೆ ಮಾಡಿದೆ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್. ವಿಲೆ ಇಡುವುದು. Therefore, it is in the context of, my lord, may kindly come to annexure B. Annexure, one is annexure C, my lord. Kindly come to page 24. That is the photostat copy of the report. This is my lord, ಸಕ್ರಮೀಕರಣಕ್ಕೆ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಅಧಿನಿಯಮ 1964ರಂತೆ ಪರಿಶೀಲಿಸಬೇಕಾದ ವಿವರಗಳು. ದಿಸ್ ಇಸ್ ಬೈ ದಿ ಅಥಾರಿಟಿ. ಏನೆಲ್ಲ ವಿವರಗಳು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ. ಕಾಲಮ್ ನಂಬರ್ 11 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಮಾರ್ಪಾಡಿ 223/5 ಪುಂಜ 3 ಎಕರೆ 20 ಸೆನ್ಸು, ಗೇರು, ಹಾಡಿ, ಬೋಗಿ, ಹೆಬ್ಬಲಸು ವಗೈರೆ ಇತ್ಯಾದಿ. ಗದ್ದೆ, ಕೈಂಡ್ಲಿ ನೋಟ್ ದಿಸ್ ಮೈ ಲಾರ್ಡ್, ಗದ್ದೆ 40 ಸೆನ್ಸು. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮೈ ಲಾರ್ಡ್, ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಗದ್ದೆ, ಲೋಕ ಹಿಂಸು ಕೂಡ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 7 ನಲ್ಲಿ ಒಂದು ಐಟಮ್ ಹೇಳ್ತದೆ, ಆಕ್ರಮಿತ ಜಮೀನಲ್ಲಿ ಸರ್ಕಾರಿ ಮರಗಳಿವೆಯೇ ಇದ್ದಲ್ಲಿ ಅವುಗಳ ಜಾತಿ ಮತ್ತು ಸಂಖ್ಯೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 25, ಐಟಮ್ ನಂಬರ್ 17. ಐದು ಬೋಗಿ, 5 ಧೂಪದ ಮರ, 4 ಹೆಬ್ಬಲಸು, 2 ಲೋಡು ಕಟ್ಟಿಗೆ ಎಲ್ಲ ಇದೆ. ಇದೆಲ್ಲ ಗೌರ್ಮೆಂಟ್ಗೆ ಸೇರ್ಬೇಕಾದ್ದು. ಆಕ್ರಮಣ ಇದೆ ಅಂತ ಇಲ್ಲಿ ಕೆಳಗೆ ಸಿಗ್ತದೆ. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಬಾಟಮ್ ಆಫ್ ಇಟ್. ಆಕ್ರಮಣ ಸ್ಥಳವು ಕದೀಂ ವರ್ಗ ಸ್ಥಳದ, ಕದೀಂ ವರ್ಗ, ಐ ಮೇ ವರ್ಗದಾರ್ by virtue of the order of the land tribunal. My ancestor filed form number 7 and jointly it was granted to 4 brothers because mother or father was not there. All 4 of us are granted with this 5 acre and earlier by the land tribunal. After this is Akramana Stalavu, Kadim Varga Stalada, Kumki Virahita Sarakari Stalavagide. ಆಕ್ರಮಣ ಸ್ಥಳವಂತೆ ಕಾನೂನಿನಂತೆ ಸಕ್ರಮಿ ದಾಸ್ತು ಮಂಜೂರುಗೊಳಿಸಬಹುದು ಸರ್ಕಾರಿ ನಿಯಮದಂತೆ ಅಥವಾ ಸಕ್ರಮೀಕರಣ ನಿಯಮದಂತೆ ದರ್ಖಾಸ್ತು ಮಂಜೂರಿಸಬಹುದು. Original record is before this honorable court. Court may kindly look into it. Now, in the light of this,
what is the original document? Put it.
Statement of presented Nagal. Sorry, Your Worship, it's a wrong file.
ಇದಲ್ವಾ ಪೊನ್ನಂಪೇಟೆ.
I will get it, Your Worship. 5 minutes.
Huh?
I will get it.
That's.
yes. And in the light of this, my lord, in the light of what report the committee got, the report is fully to recommend that sakramikaranagolisabodu because is a agriculturist. There is agricultural land in this 3.20 acres. It is on recorded by the revenue officials that there is some cultivation and also there are other trees. It could be granted as per the regularization rules. In the light of this, if the court were to observe what the annexure R1 said on 26/12/2003, that ಸ್ಥಳದಲ್ಲಿ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲ, 2 points. ಸ್ಥಳದಲ್ಲಿ ಕೃತಾವಳಿ ಇರುವುದಿಲ್ಲವೆಂದು ತಿಳಿದು ಬರುತ್ತದೆ is against the records. What is found in records, this is totally against it. Then my respectful submission is, therefore, ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡುವುದು. My lord, also it was brought to the notice of the court that
in the first page, that is page number 6 of annexure R1.
Yes, ma'am.
ಕೆಳಗಡೆ on 12/12/2003.
Yes, ma'am.
ಸಮಿತಿಯ ಆದೇಶ.
Yes, ma'am.
ಅರ್ಜಿದಾರರ ಕುಟುಂಬದ ಹೆಸರಿನಲ್ಲಿ
ಹ್ಮ್.
6.38 ಎಕರೆ
ಹ್ಮ್.
ಸ್ಥಳವಿರುತ್ತದೆ. ಸ್ಥಳದಲ್ಲಿ
ಪರಿಣಾಮಕಾರಿಯಾದ ಅಂತ ಕಾಣ್ತದೆ, ಅದು
ಹಿತಾವಳಿ
ಇರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. That is also incorrect because the report is otherwise.
ಇದನ್ನ ನೀವು you read out the same thing.
ಹೌದು.
ಹಾ.
ಅಲ್ಲಿ 6.38 ಅಂತ ಹೇಳೋದನ್ನು the petitioner has placed before this honorable court the order of the land tribunal at annexure A. In that it is said, page 16 nalli, in page 16 of the petition. This is not for one person. ಈ ಕೆಳಕಂಡ right hand side ಮೇಲೆ just before the last sentence, ಈ ಕೆಳಕಂಡವರನ್ನು ಜಂಟಿ ಖಾತೆದಾರರನ್ನಾಗಿ ಅನುಭೋಗಿಸಿದೆ. ಶ್ರೀಮತಿ ಲೋಕ ಪೂಜಾರಿ, ಕೃಷ್ಣಪ್ಪ ಪೂಜಾರಿ, ವಾಮನ್ ಪೂಜಾರಿ, ಸುಂದರ ಪೂಜಾರಿ, ರಾಜೀವ್ ಪೂಜಾರಿ, then Mohan Pujari. Mohan Pujari is the present petitioner. It is not the, and the next page is the item of land grant. This was occupancy right was granted to all 6 of them. It is not that the Mohan Pujari alone is granted with the 6.76. He is one of the joint holders of this land, and therefore he makes an application in annexure B. And on annexure B, the report of the revenue official is there is a paddy field, there is Kritavali, and idannu kodabodu anta recommendation as per the rules. Now, therefore, I would respectfully submit that application is not disposed of. That can be gathered from the records of the revenue officials later. I will draw my attention to that. My lord, the things being this, all of a sudden, my lord, the possession would always be a legal possession can be taken through a process known to law. Now, these persons, they try to trample upon this property and take possession. That is, annexure D was issued to the 3 respondents. In this 3 respondents, the Deputy Commissioner, Tahsildar, Town Municipality, Moodavidri. That, my lord, the last sentence in annexure D. Before that, I will just read, my client, my lord, got it, my lord, page 31, ink page 31. 31. My client and his ancestors have been in possession and enjoyment of survey number 223/5, measuring 5.70 acres of Marpadi has been land as per law laid down by the Honorable High Court of Karnataka. The agricultural tenant to whom the lands were granted under the Karnataka Land Reforms Act are entitled to Kumki privileges. That the entry in column number 11 of 223/5 mention the name of the landlord, that is Raviraj, that therefore my client is entitled to enjoy the privileges and the right over the said property, which even according to the government record have been in possession and enjoyment of my client as tenant of so and so. The said property was enclosed by ancient mud wall that without the denotification, kindly note this, my lord, without the denotification of the Kumki privileges and without following the procedure in accordance with law, my client cannot be dispossessed even by the government. The government will have to follow the procedure and principles of natural justice. The person in settled possession cannot be dispossessed but by following the procedure in accordance with law. On 31/1/2023, my lord, this petition was filed immediately the next month. On 31/1/2023, in the early morning, the subordinate officials of the Tahsildar, the survey department, The chief officer and the police visited the property and attempted to destroy the mud enclosure to the above property and also to destroy the valuable tree growth, stating that it is required for the purpose of the government. The above act of government and its subordinate officials is high-handed, illegal, and calls for the legal action for the damages done for prevention. My client therefore hereby calls upon you not to interfere with my client's possession and enjoyment of the plot in survey number 223/5, measuring 5.70 acres of Marpadi village, and not to resort to forcible action. My lord, they tried to dispossess me without a due process of law. Kumki privilege was not extinguished as known. Notice was not given. Even if the first item, Form 53, that is rejected for argument's sake, the second one, that is not complied with. What they complied much later, I will draw my lord's attention to that. My lord, that's how this petition came before this honorable court.
How
and
is the Kumki rights
extinguishment?
extinguished
Yes.
in accordance with law?
Yes. A notice is to be given to the Kumkidar that the Kumki privilege land is required for government purpose, and therefore privilege is withdrawn. On that, my lord, if such a notice is given, some action is taken, then some procedure is taken. That is amenable to be challenged before the authorities or before this honorable court if no procedure is advanced with. That is the judgment of this honorable court, my lord. Right now, I will take my lord through the two judgments on this. One is, my lord, the Chandrasekhar case way back in 1976, 2 SCC 495. State of Mysore and others versus K. Chandrasekhar Adiga and another 76 2 SCC 495. Paragraph 23. My lord, paragraph, permit me to read paragraph 16 also. The rights of Kumkidars in respect of Kumki lands and the grant of such lands for occupation are matters dealt in the orders of Board Revenue Madras. A copy of these orders has been placed before us. Para 40, subpara 4 describes what is Kumki land in South Canara district. According to it, all government wasteland within 100 yards of assessed land included in a holding formed prior to firstly 1276, corresponding to 1886 AD, is Kumki land. Kumkidar is a person who is entitled to enjoy the Kumki privileges. A Kumkidar is necessarily either the registered holder, Valavargadar, or Mulagenidar of the land to which the Kumki privilege is attached. Next. 17. Subpara 4. A Kumkidar's privilege in the land are grazing his cattle, cutting and collecting leaves, timber, and other forest produce for his agricultural and domestic purpose. My lord, pausing here for a minute. This is required for the cultivation of the land of which the petitioner is entitled. On record, there is a statement that 40 cents in this Kumki land is a paddy field. Other than that, the land granted, the beneficial legislation of the Land Reforms Act, land is granted for cultivation. Therefore, this is a privilege is attached to that land. Now kindly paragraph 18, subpara 6 further makes it clear that within Kumki limits, a Kumkidar can temporarily cultivate dry crops on government wasteland. If he so cultivates land within Kumki limits, he is liable to pay not liable to pay any hakkal. Para 10 lays down that any registered holder or Valavargadar or Mulgenidar who is a Kumkidar of the land applied for should be given preference over all other applicants to the extent of those privileges. Then para 14 provides that when Kumki land is assigned on Darkas to a Kumkidar, the value of the trees except sandalwood which stand on the land will be foregone and no compensation for sandalwood need be paid to persons having Kumki privileges. That is why that column number 17, my lord, saw how many trees are there. Hebbalasu, Kiral Bogi, all that is belong to the government. Then 21, High Court has held that the provisions of the standing order are statutory in character. Counsel for the appellant disputes that finding. It is, however, not necessary to resolve the question whether these standing orders have the status of a law or mere administrative rules, because substantially similar provisions, which are admittedly statutory in character, have been made by the rules framed under Section 26 of the Madras Forest Act. My lord, then para 22, Rule 7 capital A of the rules expressly provides that the holder of land to which Kumki privileges are attached may enjoy in the Kumki land free of charge such privileges as he has hitherto enjoyed in the way of grazing cattle or cutting, converting, collecting and removing trees, timber and other forest produce, subject to the conditions laid down in that rule. One of these conditions is that trees, timber and other forest produce shall be used for agricultural or domestic purposes in the village in which Kumki land is situated or in such other villages in which a collector may permit in writing. This rule further says that it shall be open to the collector to decide either generally or in special cases what shall be considered as agricultural or domestic purpose within the meaning. Next, although styled as privileges, Kumki rights are recognized by these statutory rules and the standing orders aforesaid. They are property rights. Kindly see this, madam. They are property rights, notwithstanding the fact that their scope is restricted and their exercise is subject to these statutory rules. Therefore, these rights to be curtailed, abridged, or taken away only by law and not by an executive fiat. Though it can be curtailed, it can be taken away by, it says only by law and by an executive fiat. My lord, there is a subsequent, on this, there is a judgment of this honorable court. It said, Kumki privilege can be curtailed, but that should be a procedure and by issuing a notice. That is, my lord, in ILR 2000 Karnataka 787. And we see in this court has The my lord, para 7. That goes to the regulation. Before I proceed to consider the contentions heard by so and so, it is useful to report to section 79 of the Act, which reads as under. In any village or land in which the rights of the state government to the trees have been reserved under section 75, subject to certain privileges of the villages or of certain or persons to cut firewood or timber for domestic or other purposes, and in any land which has been set apart under section 71 for forest reserve subject to such privileges, and in all other cases in which the privileges exist in respect of any alienated land, the exercise of the said privileges shall be regulated by such rules as may be prescribed by orders to be made either generally or in particular instance by the deputy commissioner, or by such other officers as the state government may direct. In any case, the dispute as to the mode of time exercising such privileges, decision of the deputy commissioner or of such officer shall be final. Therefore, it is not that such privileges cannot be curtailed. It can be curtailed, but notice should be there. It is the question of adi altrum partum, natural justice, all that, because a person is in settled possession of the property. The privileges, Supreme Court has said it is a right to property. Therefore, now here it is a settled, he is in settled possession. Question is how it can be curtailed. Deputy Commissioner can issue notice. Next, notwithstanding subsection 2, notwithstanding anything contained in subsection 1, but subject to such general or special orders that may be issued by the state government from time to time, the privileges that are being enjoyed by custom or under any order such as privileges in respect of Kumki lands, Bane lands, and Kane lands in South Kendra district, Betta lands and Hardy lands in North Kendra district, Kane and Sopina Betta lands in Mysore area, Jamma and Bane in Coorg district, and Motashal wetlands in Hyderabad area shall continue. The privileges shall continue. Privileges can be curtailed by the deputy commissioner by issuing.
What the information is available to show that this is reserved as Kumki land?
My lord, it is my lord, in the RTC, my lord, revenue records, it is never shown as a Kumki to a particular survey number. As said in the board standing order 40, board standing order 44, a land which abuts the work land to an extent of 100 links is considered as the Kumki privileged land. That is Madras Board Standing Order, which in 1976 Supreme Court refers to. That is the Kumki. That privilege of my respectful submission in this particular case, that privilege which I had is taken away without any notice.
This is a land granted to you.
Land is granted, that is 5 acre 76 for 6 of us. That is under the Land Reforms Act, being a tenant. That next to that is this land, 3 acre 20 cents of land, which is a Kumki to the work. That question, my lord, is answered in ILR 1998 Karnataka 318 as to show if one is a tenant granted with occupation, he is not the owner.
Yes.
Original owner is somebody else.
Yes.
But a tenant who is granted with the occupancy right, is he entitled for Kumki privilege?
Allah.
Please, ma'am.
These are lands which were originally belonging to some other person.
Not this land. These are all government land.
Allah, this orders passed.
Yes, is in land first annexure A.
Annexure A.
It belonged to a person called one Mr. Ravi Verma Raja Shetty. He was the landlord of the lands in annexure A. My lord gets it at page 70.
Yes.
Survey number 71, 79, A2 and 2, 4, 6, all that. Ravi Varma Raj Shetty was the owner of those lands. When the land tribunal amendment was introduced on 1374, the Srimati Loku Pujari, she files an application for grant of land. My lord knows that under 48A, it is only occupancy right is granted for the first 15 years. So occupancy right was granted to the petitioner and others, 5 others, jointly. Then the present application came to be filed on 9/2/99, Form 53, for regularization of this land. My lord, I also understand the difference.
Yes.
That is,
See,
one is, please, please.
Because if any information is available,
yes,
in respect of the previous owner,
yes,
who was holding this land,
yes,
if that is called as work land,
yes,
was there any information available as to the Kumki rights attached to these properties?
There is some information available by the notice which was issued by the council at annexure D. Kindly see annexure D, page 31. My client and first three lines can be skipped. And as per law laid down by the Honorable High Court of Karnataka, the agricultural tenant to whom the lands were granted under the Karnataka Land Reforms Act are entitled to Kumki privileges. That the entry in column number 11 of survey number 223/5 mention the name of the landlord, Mr. Raviraj, son of Krishna Raja Shetty, that therefore my client is entitled to enjoy the privileges. It abuts 223. It says mention the name of the landlord. So we may have to see the RTC of survey number 223. My lord, to put a right question, that
so if some information is available at that point of time when the land tribunal took a decision to confer occupancy rights.
Yes.
If any information was available with the tribunal regarding the Kumki rights.
Kumki, my lord, Kumki is a privilege.
Correct. Attached to the work land.
Yes. That is
therefore,
why. Yes.
If this land, which is a work land belonging to that landlord.
Yes.
Had any information.
Yes.
As to whether this Kumki rights were attached to that work land.
Exactly. Yes, I understand. Maybe I have to get the RTC because here there is a mention, because my lord suddenly asked me, what is that? Now, this is the reply. I may have to get the RTC of this. Apart from this, there is an indication.
And if that is so,
yes, madam.
Was there a need for you to file an application?
That is.
If the work land granted to you, had already had the Kumki privileges attached to it.
Yes.
Where was the need for you to file an application?
May not. Maybe people, I don't know how to answer this straight. People are avaricious. Generally, people are avaricious. If they have the correct knowledge of law or somebody to advise them, correct advice is it's a Kumki privilege.
It is already attached to you.
It is attached
to the work land. There is no need for you.
Yes, my lord, I need to admit it. But here avariciousness takes over. Maybe no correct legal advice, my lord. Even as lawyers, we would say, early privilege ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಫಾರ್ಮ್ 53 ಹಾಕ್ಬೇಕು ಅಂತ ಹಾಕ್ಬಾರ್ದು ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲಲ್ಲ. No, ಅದು ಇರ್ಬೋದು. But here is a case where he filed 53 and proceedings, I placed it before the court. That has happened. Now about the RTC.
Application was filed
yes,
in
9299.
Under which, what provision?
Form 53.
53
of the Karnataka land revenue rules. Under rule 108 CC form 53.
Why you have to 108?
108 CC, it reads, procedure under section 94 capital B. For the purpose of section 94, to the Tahsildar of the concerned taluk shall, on receipt of an application or by.
No, this is the procedure, then we'll have to see section 94.
94B. Grant of land in certain cases. Notwithstanding anything contained in this act, if the deputy commissioner or other officer authorized by the state government in this behalf is satisfied after holding such inquiry as he deems fit, that a person has prior to the 14th day of April 1990 unauthorizedly occupied any land, including land referred to in subsection 2 of section 79. Kindly see this, Miller, because subsection 2 of section 79 refers to Kumki privileges, including that from which he is liable to be evicted under section 94, and being eligible to grant of such land under section 94 capital A has failed to apply for such grant under subsection 4 of the said section within the period specified therein, and provided that nothing in this clause shall apply to a person who has become eligible to grant of land by virtue of the Karnataka Land Revenue Amendment Act 1997, has continued to be in actual possession of such land on the date of the commencement of the Karnataka Land Revenue Act, he may, within 16 years from the date of commencement of the Karnataka Land Revenue Amendment Act and subject to such rules as may be prescribed, make recommendation to the committee or the additional committee as the case may be constituted under section 94A, and such committee may on receipt of the recommendation grant the land to such person. Provided that if an application made under section 94 capital A by any other person for grant of the same land is pending consideration under that section, the committee or the additional committee as the case may be shall consider the claim of such other person before granting the land under this section. Provided further that where prior approval of the central government under section 2 of forest conservation is required, that may not be required. Here, as we read, my lord, court may also must have observed, this is the Tahsildar. There also it is gone under the Tahsildar's recommendation. Village accountant, revenue officials, ಪರಿಗಣನೆ ಮಾಡಬಹುದು, ಕೊಡಬಹುದು. Then 94, this is 94B. 94.
So therefore, that becomes important now.
Yes, ma'am.
Since occupancy rights were conferred by the land tribunal.
Yes, ma'am.
There should be some information
Yes,
that was available with the land tribunal
yes,
in respect of the Kumki lands attached to the Berg land.
yes. That is referred to in the notice.
ಅದೇ ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
Notice ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. That must be available. One is that must be available, that may be available, and even otherwise, it may be made available to this honorable court because it is a fact to be considered. Whether that is that this land is with the owner and attached to that land. And from the government, no information is forthcoming before this honorable court by way of a statement of objection, placing any material.
ಕೊಡಿ ಅದು ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ನೋಡಿ.
I apologize, by mistake I got the others. By mistake I had got the other set of records. I apologize. Mark for it.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಏನಿದು?
Survey number 350. 323.
I also have the
223.
copy of foundation and the RTCs. No, 23. 22, 23.
RTC ಎರಡು ಇದೆ. MRRTC ಎರಡು ಇದೆ.
ಈ ಸ್ಥಳ ತನಿಖಾ ಟಿಪ್ಪಣಿಯಲ್ಲಿ given by the Tahsildar,
Yes.
he says, of course, this is in respect of survey number 223/5,
Yes, ma'am.
2 acres.
Yes.
He says, ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸ್ ಎಲ್ಲ ನಂಬರ್ಗಳು ಹಾಕಿ ಸರ್ವೆ ನಂಬರ್ಗಳ ಕುಮ್ಕಿ ಮಿತಿಗೆ ಬರುವುದಾಗಿದೆ. ಜಮೀನು ಯಾವುದೇ ಕುಮ್ಕಿದಾರರ ಸ್ವಾಧೀನ ಇರುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಕದೀಮ್ದಾರರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಎಲ್ಲ ಕದೀಮ್ದಾರರಿಗೆ ವಿಚಾರಣಾ ನೋಟಿಸು ನೀಡಿ ಸದರಿಯವರ ಅಹವಾಲನ್ನು ಸ್ವೀಕರಿಸಿ ನಿಯಮಾನುಸಾರ ತನಿಖೆ ನಂತರ ಕುಮ್ಕಿ ವಿರಹಿತ ಪಡಿಸಿ ಆದೇಶವಾದ ನಂತರ ನಂಬರ್ 2 ಎಕರೆ ಜಮೀನನ್ನು ಮೂಡುಬಿದಿರೆ ತಾಲೂಕು ಪಂಚಾಯತ್ ಕಟ್ಟಡ ನಿರ್ಮಾಣದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾದಿರಿಸಲು ಆದೇಶವಾಗಬಹುದು. This is the
yes. I will come to that, my lord. When it was done, how it was done, I will place it before the court by their own documents. I will come to that. That they have placed before the court with the annexure R3 and R4.
ಇದೆಯಾ?
ಇದೆ.
You have placed this?
ಇದೆ. Annexure R2 27/12/2022, R3 2/1/2023 and R4 27/2/23. So even as on that day, it is stated that Kumkidarige, I'll draw my lord's attention to that. I'll just finish this, my lord, this part of it.
Yes.
Yes. Now, therefore, Kumki privilege under section 79 of the Land Revenue Act can be curtailed by due notice by the Deputy Commissioner as envisaged under 79/1. Kumki privilege is almost equal to the right over the property is what 1976 Supreme Court has said, Chandrasekhar Adiga's case. Now, whether Kumki privilege is available to a tenant who is granted with occupancy right, there is a judgment of this honorable court in 1997.
No, I don't think that should be very difficult because
Yes, Miller.
in the facts of this case,
Yes,
since occupancy rights have been conferred
yes,
in respect of a work land,
yes.
so if the Kumki rights were already attached to the work land,
Yes, yes.
it will naturally come to
That is the reasoning this court
Yes, yes.
followed. Otherwise, there was a dispute.
So therefore,
Yes,
we'll have to get information
yes.
as to whether the previous landowner had
the-
this privilege
Yes.
attached to his work land.
Yes, either the government can be directed to secure a RTC of that particular year, or court gives me time. I need to place it before this honorable court, because way back when the notice was issued on 1/2/2023 itself, we have said Ravi Varma Raj Shetty who was the owner, had the Kumki privilege. That material is available to this honorable court. If that material is available, then what next to be seen is whether they have given notice to this petitioner. My lord, I am facing a mighty state. Here is a person, illiterate person, who is granted with the occupancy right together with his 5 brothers. And he is fighting for this. and the entire area of 3 acre 20 cents was enclosed with the mud. They have come one day, trampled, destroyed everything, and they start the construction. Whether such a right is, whether such an action could be taken by the government because it is a government. My respectful submission, in a society where rule of law remains, this cannot be permitted. I will, if the court permits, I will place that RTC before this honorable court, because that goes to the core question.
RTCs for the year 22 and 23 are placed.
My lord, it is not of 22, 23 which is required as on the date.
As on the date when the
Tribunal order.
But Kumki right will not be reflected in any RTC. It's a wasteland of the government, belongs to the government.
There is no
My lord, now he says,
Then from where do they get this information?
my lord, Kumki rights as described by the Karnataka Forest Manual is a waste government land.
Even in the material placed before this court,
Please,
communication have been made by the Tahsildar to the Assistant Commissioner and to the Deputy Commissioner. That information is here, that they are required to find out regarding the Kumki rights.
please. Kumki right, my lord, he says, my lord, a small extent of land regarding which, my lord, occupancy right was granted. A small extent means to that proportionately there may be a Kumki right. Not that, my lord, what happened now? 3 acres and 20 cents he is claiming. But what is a Varga right given to him? A small portion. 3 acres, 20 guntas, out of which.
Totally 6 acres and odd were given.
Yes, no,
The
3 acres.
family.
Please, madam. 3 acres, 20 guntas, out of which, my lord, only 2 acres have been taken away. Not entire 3.2 acres. 1.20 acres is still with him. My lord, now he is saying he filed an application under section Form 53. My lord, that application came to be rejected. My lord, regarding the forest, my lord, rights, nature of the Kumki right, your lordship division bench already held. But if the application is pending, assuming that application is pending, but application rejected, my lord. But there are another order, Lordship may kindly say annexure R4.
Okay. The problem is that, of course, the original
My lord,
document
may I take your lordship to
bears the thumb impression.
the second order, lordship may kindly see. Second order, R4. R4, my lord, page number 13, my statement of objection. That order is reiterated. Kindly look at the second order, my lord.
My lord, I will finish and let
My lord,
the senior counsel continue, my lord. Because
second order, one minute. Second order, Himbara.
need
At
to
page
clarify
number
certain things.
13, annexure R4. Otherly, once again they reiterated, it was dismissed, it was rejected, and moreover, the land is coming within 5 kilometers of the municipal limits. But there is a division bench judgment based on the full bench judgment. What is the nature of Kumki right? Well, kindly consider this. It says there cannot be any substantive right. It is not even a property right. Well, kindly look at this. Application was pending. My lord, this is exactly on the point. This is exactly on the point. When they, my lord, even assuming that.
The learned counsel read out another judgment.
1976
my lord,
Supreme
that
Court.
is about,
Supreme Court judgment.
Yes.
that is about general aspect about privilege of Kumki. My lord, here he filed, moreover that, here lordship rightly pointed out, he filed an application for regularization. Kindly consider this aspect. Now it's no more a Kumki aspect. It is about his application being filed and whether it was rejected or not. The 94A, A and B and 101 Rule 18CC. But it was considered and rejected. He cannot rely upon that Kumki right now. His application was rejected or not. His application for regularization. Kindly appreciate this aspect. Lord, this aspect is exactly dealt with. Lord, when the application is pending for consideration, can there be, my lord, extinction of right by the authorities? My lord, kindly look at paragraph, first paragraph only, my lord. My lord, first paragraph, paragraph 2. it deals with the appellant's claim that they are in possession enjoying a certain portion of so and so, Kumki Das. They have submitted an application before the competent authority. This is about 53. Now, can you look at my lord relevant portion? At paragraph 6, 7 is relevant. Yes. My lord, all this Supreme Court judgment, everything is considered. The short question that would, paragraph 7, my lord. The short question that would arise for consideration before us is to whether response number 2, Deputy Commissioner has the power to withdraw the Kumki privileges. The said issue is dealt with by this court in case, some but case. In this said case, division bench of the court had an occasion to examine the scope and power of Deputy Commissioner under section 79(2) of the KLR Act. While interpreting the provisions of the above said section, this court was of the view that it is not possible to take a view that subsection 2 of section 70 does not confer power on the state government to extinguish Kumki right. While the said provision specifically provide that Kumki right would continue, the same provision provides that continuance of Kumki right is subject to general and special orders that may be passed by the state government from time to time. When the statute which provides for continuance of Kumki right also makes continuation of such Kumki right subject to general and special orders by the state government, such power must be understood as conferring power on the state government to extinguish and the continuance of the Kumki right. The power of the state government to pass appropriate order in section 79(2) has been delegated to the Deputy Commissioner. The Deputy Commissioner has in power order has extinguished the right, and the appellant, if any, in the respect of the land in question, the right to regulate the Kumki right has to be understood as a right to extinguish Kumki right, depending upon the facts and circumstances of the case and need of the state government to make the land available to the state government for disposal for the public purpose. Therefore, appellants on this point cannot this court for long, cannot hold this court, detain this court for long, as the issue is put to rest in the judgment cited supra and the issuance is no more res integra. The above principle laid down with the division bench of this court, judgment cited supra is taken into consideration. Then we are of the view that even if the Kumki rights are recognized as property rights, however, such rights are subject to statutory rules and their exercise subject to section 79(2) of the KLR Act. On a reading of section 79 and the principle laid down by the coordinate bench of this court in Shambat case, the rights of the appellants, if any, are not absolute. We are also of the view that the Kumki privileges are not pre-existing rights and they are to be curtailed, abridged and taken away by the competent authority in a given case having regard to the facts and circumstances of the case. Therefore, judgment in the appeals court, my lord, in Mysore and other case, Chandrasekhar, Radiga and others, this is what considered is not applicable to the present case on hand, though we have no cavil to the ratio laid down by the appeals court in the proposed judgment. The appellants seeking Kumki rights are intended to enlarge their rights of the land holding. Therefore, the said right is not absolute and the same is rightly declined by the present case on the hand having regard to the public interest at large. The state with the public noble cause has resolved providing house sites to the weaker section of the society. The public interest at large is pitted against the individual case. Public interest at large has to prevail. If the conclusion arrived by the learned single judge is examined in the background of the above facts, we are of not only agreement with the judgment of the single judge, learned single judge, the grounds surgeon in the so and so. My lord, can you look at my lord? Here is an issue of application rejected. His application for regularization is rejected. My lord, if at all now he is aware of that. Communication was made, my lord, annexure R4, maybe kindly see annexure R4. There is specific communication to him. I will read, my lord. Annexure R4. In my statement of objection, that it says him or her, Aurige Kotiadu, Mohan Kotian, annexure R4. So, my lord, having the knowledge of the order, now my lord, he says, he comes before your lordship for a mandamus, seeking reconsideration of this rejected application. My lord, all this argument by learned friend is, my lord, with great respect, is beyond the purview of this writ petition and prayer. Can you look at the prayer, my lord? No, it's not about Kumki right at all. It's about his application for regularization. My case is squarely, my lord, covered by the judgment of the division bench. It was based on the full bench judgment. Not in some, but it was a full judgment, full court judgment, full bench judgment. But kindly see, my lord. Now, my lord, still he is retaining 1.20 acres. My lord, before he could be, my lord, on 2/9/23, there was a tender. Thereafter, status quo order is passed by this honorable court. My lord, we are only respecting court order. That's why, my lord, we do not want to continue. So, last week can clarify that Construction can go on, subject to the result of the case. That would also, my lord, suffice. My lord, the construction for the taluk office,
Total extent of land that was re-granted was 6 acres.
7.6, annexure A, 6.76. That joint 6.76 million for 6 of them.
Only you have filed the application in form number 53?
50, yes, million.
Only you have filed?
Only I have filed.
The other persons
Others have not filed because 2 of my brothers are no more. Only their children are there. And I am told that one of them is not in the place. Only I have filed application. It is on my behalf. My lord, that is the factual position.
What the learned senior counsel is
No,
saying
senior,
is-
what the learned senior counsel is saying is, look here, Kumki privilege, it cannot be claimed at all. This division bench.
No. What he firstly is saying that you have only 28 cents with you. ಎಷ್ಟು ನಿಮ್ಗೆ ಬಂದಿರೋದು ಎಷ್ಟು?
ಆರ್ಡರ್ ಆಗಿದೆ
ಅಲ್ಲ ಟೋಟಲ್ ಆಗಿ 6.
ಅದು ನಿಮ್ಗೆ
ನಮಗೆ ಅಲ್ಲಿ ಸಬ್ ಡಿವೈಡ್ ಆಗಿಲ್ಲ. ಅವರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ.
ಅವರಿಗೆ ಸಪರೇಟ್
ಆಗಿದೆ
ಆಗಿದೆ ನಂಬರ್ 6 my lord.
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅವರಿಗೆ
30 cents ಅವರಿಗೆ ಕೊಟ್ಟಾಗ
that's what
3 acres of pending ಉಂಟು.
Where is that information?
No, this is the order of the tribunal. Order of the tribunal. Mohan Pujari number 6.
ಅಲ್ಲ
That is what he submitted now, my lord, saying that I was given only a portion.
No. That is what total 6 persons are granted with the 6.76. I did not make a submission that I am granted with the 30 cents and it is not on record also. That is not the submission at all.
But they are all different persons.
And my lord.
All family members only, their family members only.
Family members, brothers, sisters. And this honorable court has said each person is a.
Gafur Sahib idare, our
Number
brother
3 is Gafur Sahib.
Number 3, Gafur Sahib.
Number 3 is Gafur Sahib.
Allah, they are not, they are the members, sorry, they are members.
ಎಲ್ಲಿ?
Gafur Sahib Mohan Pujari ಏನು ಸಂಬಂಧ?
ಇಲ್ಲ.
My lord, now.
Vaman Pujari, Sundar Pujari.
ವಾಮನ ಪೂಜಾರಿ. They are all members of the same family.
Therefore, it was ಈ ಕೆಳಕಂಡವರನ್ನು ಜಂಟಿ ಖಾತೆದಾರನನ್ನಾಗಿ.
See, now there are two issues now. Please, we have to find out what is the land, Kumki lands attached to this work land.
Please.
If information is obtained, there are two issues to be decided.
Please.
Irrespective of the application filed in form number 53.
Please. Yes.
The judgment that you read out just now.
Yes.
Says the deputy commissioner has the power.
Yes. And the pendant.
To extinguish the rights, Kumki rights, provided he follows the principles of natural justice. That is another aspect of the matter. You are only saying, no, the application that he had filed was rejected.
Yes.
Way back in the year 2003 itself.
Yes. Please.
And it has the thumb impression of this person and he cannot now say, no, I was not aware of it.
Yes.
But that is one aspect of the matter. If the other aspect of the matter is taken into consideration, that to that work land, if these Kumki rights are attached, what is the extent of land? And whether the deputy commissioner has followed the provisions to extinguish that right.
But that we have already filed an affidavit before the court.
Even as per the judgment that you read out just now.
That about pending application.
Illa, pending application ಬಗ್ಗೆ ಅಲ್ಲ ಅದು. That is regarding extinguishment of the Kumki rights.
Yes.
The deputy commissioner has the power. That will not become an absolute right with the owner of the property.
Yes.
Owner of the work land, even if the Kumki rights are available for him, that privilege is available for him.
Yes, I follow you.
He cannot say it is my absolute right.
Yes.
He cannot say it cannot be extinguished.
Yes.
It can be extinguished, but the deputy commissioner has to follow the due process of law. So, ಇದೆರಡು ಬರುತ್ತೆ. ಒಂದು, if you take into consideration the application filed by him, it was rejected.
Yes.
But in this notice, he has he stated, no, it was a privilege attached to the work land. But that factual information has to be obtained now. What was the extent of land attached to the work land? If it was a privilege, what is the extent of land? And now what will happen if the Kumki rights are attached to the work land? And even in the spot inspection that I just now read out, he says notice has to be given. Whether that procedures have been followed now.
But
even in the spot inspection of the Tahsildar, he says so. Please see this.
yes, but I follow your logic.
Therefore, even after the Tahsildar bringing it to the notice of the Deputy Commissioner, if he has not followed the principles that are required to extinguish the rights, then what will happen?
But my lord, he is aware of the order, right? Since 2003.
No. There are two aspects now.
Yes, sir.
If he is defeated in respect of the application on the ground that the application is already disposed of,
yes,
it is rejected.
Yes, sir.
But even in terms of the spot inspection report of the Tahsildar, notice was required to be given to all the Kadimdars in respect of the Kumki rights. If that process has not been followed by the Deputy Commissioner, then the grant would be contrary to the provisions of law.
But he had the knowledge of rejection.
That's better. Even if we accept that yes, the application has been rejected.
My lord,
and
look at the prayer, my lord. Prayer reconsider.
Now I have secured the original records.
Please.
These are the information available. As per the spot inspection report of the Tahsildar, he clearly says
well, that is true, but 79(2) does not prescribe any such kind of hearing. 79.
It does. What is this? That is the first judgment that he read out.
That is, my lord. No.
No, even in your judgment, what you read out, it says the same thing. The Deputy Commissioner has the right.
Yes.
He has to follow the procedure. Will not delay. ಜಮೀನು ಯಾವುದೇ ಕುಮ್ಕಿದಾರರ ಸ್ವಾಧೀನವಿರುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಕದೀಮ್ದಾರರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಎಲ್ಲಾ ಕದೀಮ್ದಾರರಿಗೆ ವಿಚಾರಣಾ ನೋಟಿಸ್ ನೀಡಿ ಸದರಿಯವರ ಅಹವಾಲನ್ನು ಸ್ವೀಕರಿಸಿ ನಿಯಮಾನುಸಾರ ತನಿಖೆ ನಂತರ ಕುಮ್ಕಿ ವಿರಹಿತ ಪಡಿಸಿ ಆದೇಶವಾದ ನಂತರ ಸರ್ವೆ ನಂಬರ್ 223/5ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನನ್ನು ಮೂಡ್ಬಿದ್ರೆ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಕಟ್ಟಡ ನಿರ್ಮಾಣದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾದಿರಿಸಲು ಆದೇಶಿಸಬಹುದಾಗಿದೆ.
But ಯಾರ ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲ, that's what statement, my lord. That statement says ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲ.
ಕದೀಮ್ದಾರರು ಆಕ್ಷೇಪಣೆ
before that ಯಾರದೇ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುವುದಿಲ್ಲ.
Sir, Kadim rights, they are claiming. Yes. He himself has stated so. ಕದೀಮ್ದಾರರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಎಲ್ಲಾ ಕದೀಮ್ದಾರರಿಗೆ ವಿಚಾರಣಾ ನೋಟಿಸ್ ನೀಡಿ ಸದರಿಯವರ ಅಹವಾಲನ್ನು ಸ್ವೀಕರಿಸಿ ನಿಯಮಾನುಸಾರ ತನಿಖೆ ನಂತರ ಕುಮ್ಕಿ ವಿರಹಿತ ಪಡಿಸಿ ಆದೇಶವಾದ ನಂತರ ಆದೇಶಿಸಬಹುದು. ಅದಾದ್ಮೇಲೆ ಏನು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಇಲ್ಲಿ. ರಿಗಾರ್ಡಿಂಗ್ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್, ಹಿಯರಿಂಗ್ and extinguishment of the right, orders passed by the Deputy Commissioner.
That is there.
ಏನು ಇಲ್ಲ ಇಲ್ಲಿ.
Order ಇದೆ.
No, extinguishing the rights.
ಅದೇ ಇದೆ.
ಎಲ್ಲಿದೆ?
We have produced. Annexure R, my lord, kindly look at extinguishment, my lord, Annexure R2 on 27/12/2002. In my statement of objection. In our statement of objection, last week kindly peruse.
R2.
R2. My lord, kindly look at this, my lord. On 27/12/2022, ಮೂಡುಬಿದಿರೆ ತಾಲೂಕು ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಚೇರಿಯವರ ನಡವಳಿ. My lord, no application is pending. Yeah, there is clear observation. ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಮೂಡುಬಿದಿರೆ ತಾಲೂಕು ಮಾರ್ಪಾಡಿ 223/5 2 ಎಕರೆ ಜಮೀನನ್ನು ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಉದ್ದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸುವಂತೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಮೂಡುಬಿದಿರೆ ಇವರು ಕೋರಿದ್ದು ಸದರಿ ಜಮೀನು ಕುಂಕಿ ಹಕ್ಕನ್ನು ವಿರತಪಡಿಸುವ ಕುರಿತು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಆಯುಕ್ತರ ಉಪವಿಭಾಗ ಮಂಗಳೂರಿಗೆ ಉಲ್ಲೇಖವೊಂದರಂತೆ ತಹಸೀಲ್ದಾರ್ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಕುಂಕಿ ಜಮೀನಾಗಿದ್ದು ಗೋಮಾಳ ರಸ್ತೆ ಪರಂಬೋಕ್ ಅರಣ್ಯ ಜಮೀನು ಆಗಿರುವುದಿಲ್ಲ. ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮಾರ್ಪಾಡಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿ ಇರುವುದರಿಂದ ಇವರಿಂದ ನಿರಪೇಕ್ಷ ಪತ್ರವನ್ನು ಪಡೆಯಲಾಗಿದೆ. ಸೂಚಿತ ಜಮೀನನ್ನು ಉದ್ದೇಶಿತ ವಿಷಯ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕ ಪ್ರಚುರಪಡಿಸಲಾಗಿದೆ. ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ಪ್ರಚುರಪಡಿಸಲಾಗಿದೆ. There was a publication. There was a public notice. ಹಾಗೂ ಅಕ್ರಮರಹಿತ ಜಮೀನಾಗಿರುತ್ತದೆ, ಆಕ್ರಮಣರಹಿತ ಜಮೀನಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನ ಬಗ್ಗೆ 49C ಮತ್ತು ನಮೂನೆ 50, 53, 94 CC ಅರ್ಜಿಗಳು ತನಿಖೆಗೆ ಬಾಕಿ ಇರುವುದಿಲ್ಲ. That's why the application was long rejected.
Adaitu sir, that is regarding application. Regarding the extinguishment of the Kumki rights. Yes, you have read it now. ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಕುಂಕಿ ಜಮೀನಾಗಿದ್ದು
ತನಿಖೆಗೆ ಬಾಕಿ ಇರುವುದಿಲ್ಲ. Then my lord, ಯಾವುದೇ ಪ್ರಕರಣ
procedure followed for extinguishing the rights.
But now, my lord, my submission is that it's about his application being rejected.
Sir, that is a different aspect. This is a different aspect now. He may fail in regard to the application. Since it is already rejected in the year 2003, he cannot say, no, I was not aware. There is a thumb impression there and we can draw an inference. But what about the extinguishment of Kumki rights, even in terms of the judgment that you read out just now?
Lord, that was that argument by my friend is my lord far-fetched. In the sense, my lord, he is on a Kumki right, his application rejected. My lord, he should go to some other forum.
Sir,
he has not challenged it.
That is a different aspect.
Yes, my lord.
That is a different aspect of the matter.
Now, my lord,
even if a person who had the Kumki privileges had not filed any application, the law requires the deputy commissioner to follow due process of law to pass orders to extinguish the rights. It's a privilege attached to the work land.
True, my lord, but now, my lord, he is going beyond his prayer. What is prayer, my lord? His application.
Not only about this person.
No, my lord, others are not for your lordship.
All the persons who are the owners of the work land, they are entitled for the privilege. Notice had to be issued to them to extinguish the rights, since it's admittedly a Kumki land.
Lord, may submit. Now, my lord, he is before your lordship on application rejected by the authority.
Yes.
My lord, he should have approached KAT. My lord, he has not done that. He is aware of the order since 2002. And my lord, he is sleeping over there, he is slumbering over
Sir,
there.
I am saying you may succeed. You
Then,
may
my
succeed
lord,
on
then,
those
my lord.
lines.
Now the prayer is to reconsider.
But it may be rejected.
Whether, my lord, even that order of deputy commissioner, my lord, extinguishing right under section 79(2) was not challenged.
Where is the order?
This is the order.
There is no, he has not issued any notice to anyone.
This is the order, my lord.
Where has he issued notice to the work landowners?
Lord, this is not before, this is not challenged before your lordship. You are right or wrong, my lord, there is an order. Kindly look at, my lord.
Sir, we can't ignore.
My lord, kindly look at ಕುಂಕಿ ಹಕ್ಕನ್ನು ವಿರಹಿತ ಪಡಿಸುವುದಾಗಿ ಶಿಫಾರಸು ಮಾಡಿ ಆಯುಕ್ತರು ಲೇಖನ ಸಲ್ಲಿಸಿರ್ತಾರೆ.
So where is the procedure followed?
ಸರ್ಕಾರದ public notice was issued, public.
ಹಂಗಾಗಲ್ಲ. If that is the procedure, you please point out.
Then, my lord.
You will have judgments regarding the manner in which
Yes,
it will be extinguished.
Yes.
You please give it. You said
Yes,
the procedure is contemplated.
yes. I'll
Then
please-
kindly look at the second order, my lord, 2 and 23. That is, my lord, reserving under section 71. That is annexure R3.
Adu bidi, subsequently it is resolved to the panchayat. That will come later. The panchayat will get rights only if the order passed by the deputy commissioner is in accordance with law. If that order goes, the grant goes.
My lord, order goes provided we challenged it somewhere, but he has not challenged it.
Sir, he is filed the
But he is
petition.
arguing beyond his pleadings and prayer. He is arguing beyond his pleadings and
no.
prayer. His
He has
application.
pointed out from the legal notice itself.
Lord,
It is not something out of the material available on record.
But had he challenged the order, my lord, your lordship would have been, my lord, I quite right.
Sir, he is challenging all these orders.
No, he is not challenging. What is the
Ground
prayer, my lord?
is, he is challenging the order of grant made in favor of the panchayat on grounds.
He has
These
not
are the
He is not challenged before your lordship. Kindly look at the prayer.
Because that time it was
Kindly
not
look
to
at
the
the prayer, my lord.
acknowledgement.
It was subsequently.
It was subsequently.
Kindly look at the
And if-
prayer. Kindly
my
look
lord,
at the prayer, my lord.
Kumki
He cannot.
privilege. My lord,
Kindly look at
as
the prayer.
It was amended later.
No,
No,
it was not.
no.
As observed by this honorable
So kindly
court,
look at the
the
prayer.
extinguishment of Kumki privilege was not known to the petitioner at all. There was no
What not?
proceeding.
He has signed the
My
order.
lord, there is a.
He signed, my lord, this is a
That-
public issue.
That is,
Regarding the application,
what is
sir.
this,
No, kindly look
I am
at.
saying there are two different aspects.
I understand, my
Yes.
page number 9.
So I am saying you may succeed on that grounds, that his application is already rejected.
Yes, sir.
But what about the procedure to be followed by the deputy commissioner?
Your lordship is quite right, my lord, but my only prayer is, my lord, this is beyond the purview of what he is arguing. What the prayer is, what is the relief he sought, and what is the pleadings. Can you look at page number 9? Direct response number 2, consider the application and annexure, my lord. Annexure, what is the annexure is seeking? Annexure, that, my lord, at page number, that is annexure, page number E, annexure E, my lord.
Yes.
Annexure E is the page number. That is the application. My lord, look at the casual approach by the petitioner. He is aware of that. ನಾನು ಮಾರ್ಪರಿ ಗ್ರಾಮದ 223 3 ಎಕರೆ 20 ಜಮೀನ್ ಹಕ್ಕು ಪತ್ರ ಕೋರಿ ಮಲಾಡ್ ಈಸ್ ಕನ್ಫೈನ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ನಂಬರ್ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಉಲ್ಲೇಖಿಸಿದಲ್ಲಿ ತಿಳಿಸಿದಂತೆ ಕಡತ ವಿಲೇವಾರಿಗೆ ಬಾಕಿ ಇದೆ. ನಾನು ಪ್ರಸಕ್ತ ಸದ್ಯ ಮೌಲ ಪಾವತಿಸಲು ಬದ್ಧನಿರುತ್ತೇನೆ. ಈಸ್ ಓನ್ಲಿ ಅಬೌಟ್ ಮಲಾಡ್ ಪೇಮೆಂಟ್ ಆಫ್ ಆಲ್ ದಟ್. ಆದ್ರೆ ದಯಮಾಡಿ ಸದ್ರಿ ಕಡತ ಬಗ್ಗೆ ಮರು ತನಿಖೆ ನಡೆಸಿ. ಈಸ್ ವೆಲ್ ಅವೇರ್ ಆಫ್ ದಿ ಆರ್ಡರ್, ಮೈ ಲಾರ್ಡ್. ನೌ ದಿ ಪಬ್ಲಿಕ್ ಕಾಸ್ಟ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಮೈ ಲಾರ್ಡ್. ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ದಿಸ್, ಮೈ ಲಾರ್ಡ್. Before he filed the application, there was an auction. The building was in midway, and when the building was half constructed, this on court granted a status quo order. What I am requesting lordship is, my lord, your lordship can examine all these aspects. I am fully in agreement with your lordship. Let the building construction go on.
Please see paragraph number 15 in the grounds.
Grounds, but relief, prayer is not there. Prayer is not there.
Second prayer is that only.
Where is the prayer?
Please read paragraph number 15. Odi, ನೀವೇ ಓದಿ sir.
Entitled Kumki right over the scheduled property. Kumki right by the petitioner over the scheduled property is recognized by the revenue authorities. Recommendation of regularization of scheduled property to the petitioner. Illegal act of response cannot be resisted. This is the ground he raised, but the prayer is not there.
See the second prayer.
Grants.
Forbear the respondents from dispossessing the petitioner from the scheduled property without due process of law.
Dispossessing, before which only, my lord, we dispossessed him.
Sorry.
Before which, my lord, kindly look at when the, my lord, kindly look at the stay, vacating stay application. I have produced the auction proceedings under which, my lord, the construction of Taluk office, my lord, that was on, my lord, 9/2/23. Taluk office construction, Mudbidri is a newly constituted Taluka, my lord. Taluka construction was there. It was now stopped. Work order was given. Now he came belatedly and obtained this honorable court granted a status quo order. My lord, I am not on 1.20 acres. I am only on 2 acres. Let him continue, my lord. And moreover, it is coming within the purview of the municipal limits of 5 kilometers. No way there is a possibility of granting the land, my lord. Further, my lord, when it comes within the purview of 5 kilometers, my lord, whether it remains to be a Kumki right.
There is no such provision, deeming provision that automatically it get extinguished.
My lord,
Athara illa illa.
Iga, my lord, when is the status quo? Can you look at the order on, my lord, 29/3/23, before which tender was called for on 2/9/23. But I am not coming the way of lordship deciding the matter on merit, my lord. Let the construction go on subject result, my lord. Only about 2 acres of land, my lord, we take a position, my lord. Other aspect, my lord, even you get 2 acres, will not come in the way. Only construction is in a portion of the land.
3.20 acres are there, is it?
3.20 acres ಕೇಳಿದ್ದಾರೆ ಅವರು.
ಹಾ.
ನಮಗೆ 2 acre ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಬೇರೆ ಜಾಗ ಇದೆ. Veranda is all that was. Construction is ಇಲ್ಲಿ in the corner, my lord. So, my lord, construction ಅರ್ಧ ಆಗಿದೆ.
ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಬರೀ 2 acres ಆ?
ಹೌದು, 2 acres. Extinguishment kindly see, my lord. ಇಲ್ಲಿ status quo order ಕೊಡುವ ಮೊದಲೇ, my lord, there was a tender. You were dispossessed.
My lord.
Construction is only a portion of the land.
Note this word, my lord. He was dispossessed. Therefore, dispossession, whether it is by an authority.
Can you look at the, my lord, construction site, my lord?
No, where is that grant order?
Grant order, my lord, grant order, reserving land, my lord. Reserving land, annexure R3. Yes. Well, can you look at annexure R3, page number 11 in my statement of objection? That is, my lord, ಆದೇಶ 2 ಎಕರೆ ಜಾಗವನ್ನು ಎಕರೆ ಜಮೀನು ತಾಲೂಕು ಪಂಚಾಯತ್ ಕಟ್ಟಡಕ್ಕೆ section 71 ಪ್ರಕಾರ ಕಾಯ್ದಿಸಲಾಗಿದೆ. But assuming that, my lord, he has a right, my lord, his right is over, my lord, 1 acre of Varga land. Proportionately, my lord, 1 acre could be granted to him, assuming that your lordship, my lord. My lord, 2 acres, ಅಲ್ಲೂ ಕೂಡ ಒಂದು ಪೋರ್ಷನ್ ಅಲ್ಲಿ ನಾವು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದ್ದೇವೆ. Can you look at the site, my lord? Statement of vacating application number ಹಾಕಿದ್ದೇವೆ. ಎಲ್ಲಿದೆ? Small ಏರಿಯಾದಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ.
In 2 acres.
2 acres ಎಲ್ಲ ನಾವು ಮುಟ್ಟುದಿಲ್ಲ ಬೇಕಾದ್ರೆ. We will not. Well, can you look at this construction? This is the photograph you have produced. Vacating stay application. In the vacating stay application, I have produced, my lord, all these photographs. 2 ವರ್ಷದಿಂದ, my lord, since 1 year, since the stay order, my lord, construction is stalled. It would lead to escalation of, my lord, all prices. It's a public cost, my lord. It's in a small city, small town, my lord. At least this interim order could be modified to clarifying that it will not come in the way of construction. Because status quo order is there, before which only you are dispossessed. And I will not claim any equity over the building, my lord, if he succeeds ultimately, my lord. I understand lordship is concerned about villagers, my lord, their rights. But here is a case where 1.2 acres are still with him. And it is within 5 kilometers of Mudubidri, my lord. It is a very costly land. And it is a government land.
When was the application filed?
Application filed on 9/2/2099.
99.
Yes, Lord. And it was, I will give the dates, the events, my lord. On 9/2/99, my lord, there was an application. It was rejected on 26/12/2003. And it was reiterated once again on what 27/2/23. R4 I have filed, my lord, communicating him, your application is already rejected. Moreover, it is coming within the purview of 5 kilometers.
23.
ಅದನ್ನು ಹೇಳಿದ್ದು reiteration, ನಿಮಗೆ ಆಲ್ರೆಡಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಮತ್ತೊಂದ್ಸರಿ ಹೇಳಿದ್ದಾರೆ ಅವರಿಗೆ. ಫಸ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಒಂದು ಸಿಗ್ನೇಚರ್ ಇದೆ.
There was no communication.
No. First order ಅಲ್ಲಿ signature ಇದೆ.
23.
Your thumb impression is there.
Thumb impression ಇದೆ.
I have some
I'll
submission to make. I will not hurry.
I'll complete, my lord.
I will not hurry through things. I will place all
I'll
these
complete, my
before
lord.
the court.
Extinction took place on 27/12/2002, annexure R2. It was reserved on 2/3/23. My lord, tender was called on 9/2/23. My lord, he came to the court, my lord, thereafter. And status quo is only on 29/3/23. There is absolutely, in fact, no bar for us to proceed further, my lord. My lord, we are a government institution, my lord, so that we do not want to have any confusion. My lord, status quo order 29/3/23. My lord, tender is produced, work order is given, construction is midway. Only request is, my lord, a portion of the building, a construction is being made in a portion of 2 acres. That not full, not in full 2 acres. Even, my lord, he succeed. Government may consider this application also, my lord. We will not come in the way. 1 acre, 20 guntas are there. It's very valuable land, my lord, now. Those are the days of 99, my lord. Mudubidri was nothing. Now, my lord, he is claiming 3 acre, 20 guntas could not be and cannot be granted. Please, my lord, have a balanced view on this matter, my lord, so that both interest, individual as well as the public interest, would be subserved.
My lord,
Only request is to construction may be continued until subject to the result of the petition, my lord.
my lord, appearing for the petitioner, I would say that now that what the senior counsel is saying, that out of 3.20 acres, 2 acres will continue. 1 acre still remains for the petitioner. Let them file an affidavit to that effect. That 1 acre 20 cents available to the petitioner, it would be of petitioner. I will, though he is not there, I will find out from my client and submit it to this honorable court tomorrow itself. But this statement that
Regarding 1 acre, 20 cents?
20, what they say is,
Yes.
it
2
is
acres only has been
2
granted.
acres and 1 acre 20 cents is still available to be granted. It will be, if it is the undertaking by the state that 1 acre 20 cents will be granted to the petitioner because there is no other application. I will advise my client and come back before this honorable court tomorrow morning itself. And this statement that the work has started, that is not the reason to vacate, because rule of law need to be followed. They themselves say that he is dispossessed. Under what authority of law they have dispossessed, my lord? This is a court of law and also a court of justice. Under what authority they have dispossessed the petitioner? Maybe he is poor, he is ignorant, he is illiterate. That doesn't mean that he can be, his rights can be trampled upon. Their statement, he is dispossessed.
It is not a right, it's
Can it
only a
be-
privilege. It is only a privilege. Kindly appreciate, he is claiming a right. It's
Whatever
not-
privilege, whatever
It is not a
privilege,
right.
division bench has said
That
that,
is what he's saying, even in terms of the judgment that you read out.
yes.
The deputy commissioner no doubt has the right or the power to extinguish the rights,
Yes,
but he has to follow the due process of law.
yes, my lord, that there is no. my
It
lord.
doesn't show
I completely, my lord.
that
Yes.
the information has been secured. These are the persons who are the owners of the work land attached to this Kumki lands. Notice has been issued to them. ಏನು ಇಲ್ಲ.
ಅಲ್ಲ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ತಾವು ಮಲಾಡ್ ವಾಟ್ ಐ ಆಮ್ ಪ್ರಪೋಸಿಂಗ್ ಮಲಾಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಎಲ್ಲ ಇದು ಮಾಡಿ ಯು ಕ್ಯಾನ್ ಲಾಸ್ಟ್ ಮೇ ಕನ್ಸಿಡರ್ ಆಲ್ ದಿಸ್ ಮಲಾಡ್ ವಿಲ್ ನಾಟ್ ಕ್ಲೈಮ್ ಎನಿ ಇಕ್ವಿಟಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೋದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
Give it in writing before this honorable court by way of an affidavit that 1 acre 20 cents is still available, it will be granted. That they, just now they said 1 acre 20. Let, otherwise.
But we are already in possession of 2 acres. Status quo order is my lord, in status quo will not order will not affect us in any way.
It is their
But still, my
interpretation,
lord,
not
still,
of
my
the
lord,
court.
having regard to the fact that it's a government undertaking, my lord, we are before your lordship seeking clarification. That, my lord, there would be maybe a clarification, my lord. Construction may go on. A particular, my lord, portion of 2 acre, that too, my lord. ಆವಾಗ ಟೆಂಡರ್ ಆಗಿದೆ 2023 ಅಲ್ಲಿ ಟೆಂಡರ್ ಆಗಿದೆ. ನಮಗೆ ತಾಲೂಕು ಆಫೀಸೇ ಇಲ್ಲ ಅಲ್ಲಿ. That's the problem. I am from the same area. There is no taluk office. These are the public issues. I understand, my lord, what the lordship is.
Even when a notice
But
is
operating your
given,
lordship mind, my lord, I
Deputy
completely
Commissioner, Tahsildar,
appreciate. But thing is
everybody
this
keeps
different. He is on application. He is on application. Should you not, my lord, diligent?
No, ನೀವು ಹಂಗೆ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ. See, he is raised a ground. There is a prayer. There is a legal notice issued pointing out to this right of his. So there are two questions to be considered.
Yes, well, that I agree, but we have our contention, my lord, at this stage, my lord, regarding clarification of the interim order.
See, in that way, we can dispose of the writ petition itself.
Please.
After considering all this, there is no need for me to adjourn the matter. Permit is nothing more left. I've considered everything.
Your lordship
I can
considered,
dispose of the matter. There is no difficulty.
lordship considered
But
his
the
content.
problem is, if I am finding that the deputy commissioner has not followed the due process of law, then how should this court permit you to go on with the construction?
My lord, a public right is pitted against his claim, my lord. Public issue is before your lordship. And my lord, kindly, my lord, even that could be, my lord, lordship may ask the authorities to consider his application. That's not a problem at all. My lord, his claim for, if at all it is
I will
rejected.
come back tomorrow morning, but let that statement be on record by affidavit. Because
That
otherwise,
statement they cannot make regarding the grant. The question is,
yes,
when he has admitted it is a Kumki, it is just a privilege. It cannot be granted. All the government can permit is as far as that Kumki land exists and it loses its natural character by coming within a city or whatever.
Yes, ma'am. That's
He-
another
he-
aspect.
He just has to enjoy the privilege. He himself has read out 79(2), which says that an agriculture activity, he can use collection of firewood. It is very clear. And it says that the state government from time to time, the privileges that are being enjoyed either by custom or an order. He can just enjoy. So the question of grant does not arise.
it is
Another intervening factor, my lord, within 5 kilometers, my lord, statutory bar for any regularization. But
No, that application
That
was
is
filed
true,
in
my
year
lord.
1999.
99 was the application.
that is true, my lord. That I agree.
I have myself held in.
Several
many-
orders in that thing.
That I am aware, my
Has to be-
lord.
Application.
That I am
As of
aware.
the date of the application.
That I am aware, my lord. Lordship held that the process should be, my lord, process should be followed. That I agree, my lord. But here is, we are trying to distinguish on two aspects. Number one is, my lord, it is application under section 53 for regularization. It was rejected long back. Then look at the latches and intelligence on his part. Secondly, my lord, it is coming with the, moreover, that could be a balanced approach, my lord. Even now, it is between the government and him, my lord. Even otherwise, what will happen, my lord? This application could be considered.
If I may state, well, if all the matters have been considered by this court, at best what it could be done is that an opportunity may be provided to him
Yes, my lord.
before in a time bound manner by the,
see,
if only claim is that the due process was not followed and there is a violation of principles of natural justice by the recommendation of the Tashildar that Varga land attached Guttedars opportunity kodabeku anta, then there is a recommendation which your lordship has read. And if that opportunity has to be given, at best is that we can relegate the matter back to the deputy commissioner to reconsider the order
Within time frame.
of withdrawing the privileges. Let an opportunity be provided to him and then whatever appropriate order is passed, then he has a right. Either of them have a right.
Now that will be a postmortem because they themselves say that
What
he is
postmortem?
dispossessed. After dispossession, we hold an inquiry whether you have a
Now,
privilege or not.
Now what?
That is what the government advocate
If
is.
the matter
yes.
is relegated back to the deputy commissioner,
That,
what
how
what
can
may
that be
happen is, if then all the practical difficulties that we are facing maybe not be there because that they can hold a spot inspection and that remaining 1.2 acres may be allowed for him to be used for his privilege as far as that exists, that is to attach to his Varga lands to other people also. Because he is not, just because he has filed an application under form 53, that does not take away the right of the other grantees and the tribunal order. Those people also will be have to give. And tomorrow, if he's heard, then the other 5 people come back to the government and say that we were not heard when de-reserving the 2 acres. All this can be covered if the matter is relegated back with a specific direction that all those persons or their legal heirs, whoever are available, let notice to be given, and that what rightly the Tahsildar has also written to the Assistant Commissioner.
See, even in respect of the rejection of the application,
Yes, sir.
the report is one thing, and the grounds on which it is rejected is another thing. Totally contrary.
ಕೃತ್ಯಾವಳಿ ಇರೋದಿಲ್ಲ, ನೋ ಕಲ್ಟಿವೇಶನ್ ಅಂಡ್ ನೋ ಪೊಸಿಷನ್. ಕಲ್ಟಿವೇಶನ್ ಇಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದಾರೆ, ಪೊಸಿಷನ್ ಇಲ್ಲ ಅಂತ ಹಾಕಿದ್ರು.
ಅವರೇ ಬರ್ದಿದ್ದಾರೆ, so and so, these many trees are there.
ಅಲ್ಲ, ಟ್ರೀಸ್ ಅವ್ರು ಗ್ರೋ ಮಾಡಿದಲ್ಲ, ರೆಸ್ಟ್ ನಾಟ್ ಇಸ್ ಎ ನ್ಯಾಚುರಲಿ ಗ್ರೋನ್ ಟ್ರೀಸ್.
He said
It is
that
a
all
Kumki
this-
land, kindly appreciate. My lord, in South Kannada district, my lord,
No.
Kumki privileges.
The grounds on which an application under section 95B is to be considered, having regard to the express
94.
provision
94.
that even a person who has a privilege of Kumki rights under section 79(2), he too can make an application. ಏನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
My lord, I understand what is falling from your lordship, but the thing is
Therefore-
this, if the
Therefore,
process is.
not only question of considering the extinguishment of the Kumki rights, the application for regularization, at least in respect of 1 acre 20 gunta, should be reconsidered.
1 acre 20, yes, reconsider.
ಇವೆರಡನ್ನು ಮಾಡೋದಾದ್ರೆ
ಇಲ್ಲ, ನಾವ್ ಹೇಳಿಲ್ಲ, my lord, that's what we fairly submitted.
ಅಲ್ಲ, ನೀವ್ ಹೇಳೋದಲ್ಲ, ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, we'll consider it, my lord. We'll
ನೀವಲ್ಲ, it should come from the state government.
consideration.
You please take instructions. Huh?
Yes.
I don't know whether by tomorrow you'll be able to get instructions.
That is literally impossible, Your Lord,
Huh?
because all the officers have reported about the mustering duty. They have to collect the material tomorrow.
Well, that would be what your lordship says,
Perfect.
would be the perfect, because even otherwise, follow ಮಾಡಿ ಕೊಟ್ರೆ ಅವ್ರು ಏನು ಉಳಿದಿಲ್ಲ. 120 ಅಲ್ಲಿ ಅವರಿಗೆ ಕನ್ಸಿಡರೇಷನ್ ಮಾಡೋದಿದ್ರೆ they can.
Having considerably heard the learned counsel for the petitioner, the learned senior counsel for the contesting respondents, and the learned AGA, and on perusing the original records which were furnished by the learned AGA, this court finds that the claim of the petitioner, although regarding 3 acres and 20 cents, 3.20 acres.
Yes, that's 10 cents ಅದು.
3.20 acres.
Yes, yes, yes.
Appears to have been rejected in the year 2003. Nevertheless, a bare reading of the reasons for rejection of such application is contrary to the report submitted by the competent authority. Full stop. On the other hand, a ground has been raised by the petitioner regarding the Kumki rights enjoyed by the petitioner as the owner of the work land attached to the land in question. Full stop. It has been pointed out by the learned counsel for petitioner from the order dated 27/12/2022 at annexure R2, filed along with the statement of objections of respondent number 3, that although the deputy commissioner was aware of the fact, and in terms of the spot inspection report filed by the Tahsildar, that claims have been raised in respect of the Kumki rights, nevertheless, the deputy commissioner has not issued notice to the owners of the work land, and it is prima facie clear that the deputy commissioner has not followed the due process of law for extinguishment of the Kumki rights. Full stop. Next para. However, having regard to the fact that this court has to balance the claim of the petitioner as an individual and the claim of the contesting respondents, namely the Taluka Panchayat, to whom 2 acres of land have been granted for construction of the Taluk Panchayat office. This court is of the considered opinion that the deputy commissioner will have to reconsider the claim of the petitioner, at least to an extent of 1 acre, 1.20 acres, which remain even after the 2 acres of land are granted to the Taluk Panchayat, both in terms of the application filed by the petitioner under section 94B, 94 capital B, and the Kumki rights enjoyed by the petitioner, as he is the owner of the work land attached to the lands in question. Full stop. Next para. Learned AGA is directed to secure instructions. Full stop. Release this matter on 29th of May 2024. Full stop. A copy of this order shall be made available to the learned AGA for compliance. Full stop. Next para. If the Taluka Panchayat intends to proceed with the construction, it may do so, but it shall not claim any equity. Full stop. This matter shall be treated as parted.
My lord, 1 acre 20 cents. Let it not be touched at all, because it is.
What he is saying is, we are not even utilizing 2 acres of land.
Yes.
Construction is being done only probably in about half an acre of land.
My lord, that may be clarified, my lord. Otherwise, my rights were trampled. I was dispossessed. Now they, in the guise of this, what they are going to do, we don't know. That at least.
What can they do, sir? They can't go beyond 2 acres.
That's right.
How can they do it?
My lord, let it be, because 3 acre 20 cents.
He'll have to reconsider both your claims.
My lord,
under the application.
Yes.
Under 94B and your Kumki rights. Both they have to consider.
Yes, but 1 acre 20 cents, let them not do anything about it, my lord. Otherwise, having come before the court with the plea.
What can they do, sir?
My lord,
even in respect of 2 acres.
My lord, what they can do, they have shown in action. They have trampled on my property, which cannot be taken away without due process of law. And now come and say that equity and government, all that.
It is not his property. It's not his property.
I don't say that it is my property.
It's not his property.
And it is not your property free from privileges. You cannot use it.
ಅಲ್ಲ ಈಗ all you can do there is to utilize it only as a
Privilege.
enjoy your
That's a
Kumki
privilege.
rights.
Yes.
ಅದ್ ಬಿಟ್ರೆ ಇನ್ನೇನು ಮಾಡಕ್ ಆಗಲ್ಲ ನೀವು.
ಮಾಡ್ತಾ ಇಲ್ಲ, ನಾನು ಮಾಡ್ತಾನು ಇರ್ಲಿ.
Please do it.
Yes.
Workally.
That
ಅಲ್ಲ, my lord.
The rights of the petitioner insofar as
1 acre 20.
1.20 acres of land to enjoy the Kumki privileges shall not be stopped by the respondents
Until this.
till the next date of hearing.
Please,
Yes.
we are grateful, my lord. Very balanced this.
48, my lord. Disposed of kind of not very small correction, my lord, survey number and extent. Number 48.
ವಾಪಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ. ಯಾವುದು?
48, my lords. My lord was pleased to dispose of the matter, my lords. There is small correction, my lords, may require, my lords, with respect to survey number and extent of land. Cell number 48, my lords. I have filed an application for correction of the judgment, my lords.
179 ಆಗ್ಬೇಕಾಗಿತ್ತಾ?
ಹೌದು, 179 ಆಗ್ಬೇಕಿತ್ತು. 2.50 acre ಈಚ್ 2 ಜನ ಪಿಟಿಷನರ್ಸ್ ಇದ್ದಾರೆ. ಅದು
ನೋಡಿದಿರೇನ್ರಿ?
Annexure A and B are the application.
Serial number 48. Serial number 48.
Annexure A and B are the applications filed by the petitioner.
Have it tomorrow, your lordship.
With loss of kind permission, my lord.
I'll pass orders.
ಹೌದು.
ಏನಾದ್ರು ವ್ಯತ್ಯಾಸ ಇದ್ರೆ you please let me know.
Yes.
With your. With loss of kind permission, my lord.
Order on IA number 1 of 2024. This application has been filed by the petitioners seeking certain typographical correction of certain typographical errors that have occurred in the orders passed by this court. Full stop. Learned Counsel submits that the survey number is 179/4.
179.
Only 179.
ಹೌದು, 179.
179.
ಬಾರ್ 1 ಅಂತ ಇದೆ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. ಇಟ್ ಈಸ್ ಲಾರ್ಜರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ 179 ನೋಟ್ಸ್. ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಫೈಲ್ಡ್ 179/1.
And it is mentioned as survey number 196/4. Full stop.
2.5
The Learned Counsel would also submit that the petitioners had filed applications in form number 57 seeking regularization of unauthorized occupation of 2.50 acres each.
Annexure A and B.
Full stop. Next para. Accepting the submission made by the Learned Counsel for petitioners, comma, the orders passed by this court shall be accordingly corrected.
Please. Apply. 47.
With your loss of kind permission, serial number
Stop.
45, my lord. Serial number 40.
A certified copy shall be issued to the petitioner
Please.
after necessary correction.
Please.
My lord, serial number 45, my lord. I may be permitted. My lord, in serial number 45. In serial number 45, may be permitted to move the vacation court, my lord. Serial number 45, my lord.
ಅದು ರಿವರ್ಸ್ ಆಗ್ಬೇಕಾ? ಬಟ್ ಅದು ಮುಂಚೆನೂ ಬಂದಿದೆಯಲ್ಲ, ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ ಅಲ್ಲಿ? Wrongly mentioned as Chikkaganjuru village instead of Kambampalli village. ಅದೇ ಸೇಮ್. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ? ಹಾ, ಸೇಮ್ ಅದೇ ತರ. ಆ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅದೇ ತರ ಬರುತ್ತೆ. Learned Counsel for the petitioners submits that this court has rightly. Recorded the submission of the learned counsel for petitioner that the name of the village was wrongly mentioned as Chikkagunjuru instead of Kambampalli village in the first paragraph. Full stop. However, in paragraph number 6, the villages are reversed. Full stop. Next para. In paragraph number 6, after the words, if it is found that the petitioner is in actual possession of the granted land in Chikkagunjuru village instead of Kambampalli village, close note commas, shall be corrected as anta matte adana repeat ಮಾಡಿ Kambampalli village instead of Chikkagunjuru village. ಮಿಕ್ಕಿದ್ದು ಅದೇ ತರ ಸೇಮ್ ಆರ್ಡರ್.
Serial number.
In respect of the land which is the graveyard, stating that it has been auctioned by.
ಯಾವ್ದು sir?
Serial number 46. Interim orders have been granted. They are misusing the interim orders and they are preventing the people even to bury the dead bodies. And they are putting up a fence around the property and filing complaints also.
No, please
I
wait.
have filed the application.
ಅದಾಗಲ್ಲ ಅದ. That cannot be considered.
What is happening is this.
No.
Serial number
It's the right of a private person.
No, I am submitting.
No. You are making submissions on behalf of the general public. That person is claiming certain rights over the land. We'll have to consider. Yes. Let us see. Yes. ನಿಮ್ದು ಯಾವ್ದು?
Serial number 45, my lord, 45. Serial number 45. In that case, I may be permitted to move the vacation court.
Lord, I appear for the petitioner in that matter, my lord.
Notice has been issued, isn't it? Notice has been issued.
I require to.
I sought for, no, my lord, I sought for vacating stay. I may.
Vacating stay.
ಹೌದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇನೆ.
ಏನ ಅಂತ
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಇಷ್ಟೇ ಆಗಿದೆ. ಒಂದೇ ನಿಮಿಷ ಅಲ್ಲ, ಒಂದೇ ಸೆಕೆಂಡ್ ನಲ್ಲಿ, ಅದು 1 ಸೆಕೆಂಡ್ ನಲ್ಲೇ ಇವರು ಆರ್ಡರ್ ಗ್ರಾಂಟ್ ಆಗಿದ್ ಅಲ್ಲ, 1 ಸೆಕೆಂಡ್ ಇದು ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿದ್ದ ಆರ್ಡರ್ ಜಾಗ ಬೇರೆ, ಅದು ಬಿಟ್ಟು ನನ್ ಜಾಗದಲ್ಲಿ ಮನೆ ಕಟ್ತಾ ಇದಾರೆ. ಫೋಟೋಗ್ರಾಫ್ ಅದ್ ನೋಡಿ, ಇಂಟೀರಿಯರ್ ಮಾಡ್ರಾದ್ಮೇಲೆ ಮನೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದಾರೆ. 1 ತಿಂಗಳಲ್ಲಿ ಮನೆ ಮುಗಿಸೇ ಬಿಡ್ತಾರೆ. ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದ್ದೀನಿ, ದಯವಿಟ್ಟು ಕ್ಲಾರಿಫೈ ಮಾಡಿ. ಅವ್ರ ಗ್ರಾಂಟ್ ಆಗಿದ್ ಲ್ಯಾಂಡ್ ಅವ್ರಿಗೆ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೇನೆ. ನನ್ ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಬರಬಾರ್ದು ಅಷ್ಟೇ.
ಜಾಗ ಎಷ್ಟು?
5 cents. 5 cents.
You are putting up construction.
Construction, my lord. Petitioner is putting up the construction. They actually, in this manner.
He is my colleague, my lord. He is arguing on my behalf also. If Arvind Bhatta, he is telling on my behalf.
You please tell us.
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3ಗೆ ಅಷ್ಟೇ ಆ 5 ಗುಂಟೆ ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ ನಾನು. ಯಾವ್ದು ಕೊಟ್ಟು ಅವ್ರು ತಗೊಳ್ಳಿ, ಅದು ಟ್ರಿಬ್ಯುನಲ್ ಯಾವ್ದು ಕೊಟ್ಟಿದೆ ಅದು ಅವ್ರದ್ದು, ನಂದಲ್ಲ. ಈಗ ಅವ್ರದ್ದು ಅದನ್ನ ಬಿಟ್ಟು ನನ್ನ ಹತ್ರ ಬರ್ತಾ ಇದ್ದಾರೆ.
Formal statement of objections to the application, my lord. There is no urgency as such.
So therefore, you also don't go on in a brisk manner to put up the construction. That is not the reason why interim orders are passed by the court.
Let him be granted the permission to move the vacation bench, my lord. In the meanwhile, I'll file my objections to his application, my lord, seeking vacating.
Perfect. Idರಲ್ಲಿ serial number 45. Respond number 3 is permitted to move the vacation bench, seeking vacation of the interim orders passed by this court. Yes.
See number 38 and 39, my lord, were dismissed because
Order may kindly be extended.
Interim order granted earlier stands extended till the next date of hearing.
38 and 39 were dismissed because I didn't take steps against R3. Now I filed the application to take steps, so this is R3, my lord. I also filed recalling upon.
ಬರ್ಲಿ ಆ vacation ಆದ್ಮೇಲೆ no urgency now.
So 40% except now the survey sketch, my lords. Except the survey sketch, the survey is completed only on that short point, my lord.
ಯಾವುದು?
Number 40.
2014 matter. ಇವಾಗ ಏನ್ ಮಾಡಕ್ ಬರುತ್ತೆ? Let it come up after.
It is not pertaining to case.
ಡೇಟ್ ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ, after vacation ಅಷ್ಟೇ.
ಯಾಕೆ ಹೇಳಿ? ಯಾವ್ದು ಹಾಕಲ್ಲ ನಾವು.
28 ಭಾನುವಾರ. After vacation ಅಂడి.
ಏನು ಬರೆಯಲ್ವಲ್ಲ ನಾವು. ಏನು ಬರೆಯಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋದಿಲ್ಲ ಬರೀ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಪಾರ್ಟ್ ಡೇಟ್ ಆಗಿದೆ
ಆಗೋಣ, ಏನಾದ್ರು ವಿಚಾರ ಇದ್ರೆ ಆಗ್ಬೇಕು. ಇವಾಗ
ಸೀರಿಯಲ್ ನಂಬರ್ ಪಾರ್ಟ್
ಸಿಸ್ಟಮ್ ಗೊತ್ತಾಯ್ತಾ?
Date ಇಲ್ಲ ಸರ್, ಅದು after vacation.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಇಲ್ಲ, after vacation sir.
ಥ್ಯಾಂಕ್ ಯು.
ಪೋಸ್ಟ್ ಮಾಡಿದೆ.
ನಾರಾಗಿದ್ರೆ ಸಾವಿರದ ಆಗ್ಬಿಡೋದು. ನಾಳೆಗೆ ಆಗತ್ತಲ್ವಾ? ಅದೊಂದು ಎಷ್ಟು ಒಂದು 10 ಆದ್ರೆ ಸಾಕು ನಮ್ಗೆ. 2,000. ನಾಳೆ 6 ಗಂಟೆ ಆಗುತ್ತೆ ಇಲ್ಲಿ ಹೆಂಗೆ 5:30 ನಾಳೆ ಲಾಸ್ಟ್ ಡೇ. ಹೆಂಗ್ 9 ಗಂಟೆಗೆ ಅಂದ್ರೆ ಆರ್ಡ್ರು ಫೈಲ್ ಆಗ್ಬೇಕು. ಎಂಟ್ರಿ ಮಾಡುವ ಕೆಲವು ಹ್ಯಾಂಡಲ್ ಕಳ್ತಾರೆ. ಇದನ್ನು
ನಾನು ಬರ್ಬೇಕು.
ಈಗ ಯಾವ್ದು ಇಲ್ಲ ಆಗಿರೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿರೋದು ಯಾವ್ದು ರೆಕಾರ್ಡೇ ಆಗಿಲ್ಲ. ಮ್ಯಾಟ್ರ್ ಅದೇ ಕಂಟಿನ್ಯೂನಾ?
ಏನಪ್ಪ ಯಾಕೆ ಪಾಸ್ವರ್ಡ್ ಅಂತಾರೆ ಮತ್ತೆ? ಏನೋ ಒಳ್ಳೆ ಅನ್ಸುತ್ತೆ, ಹಿಂಗೂ ಅನ್ಸುತ್ತೆ. ಅಕಸ್ಮಾತ್